Hypocrisy.
Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota. We're going to get to this quickly because it's already started. I apologize. My internet is being something today. Yes, I know it's muted. Give me a second.
Prevents further harm. It prevents the
I don't know this. I didn't catch this chap's name, but I believe he is a police expert, police tactics and training expert.
For first responders to render aid to them.
And Mr. Branca should be joining us in a bit, having issues with StreamYard, frankly. Probably on my end.
Are you aware of any Fort Worth training?
You there, Mr. Branca?
Tell an officer not to announce.
Yes, sorry.
Yes.
Can you hear me?
Where is that specifically?
Kind of.
I don't know it specifically, but it is common practice. It is common.
We're being way drowned out. Hold on.
That caution is to be used when approaching.
They rebalanced their audio.
But where specifically in any training? Did you review all the training documents for Officer Dean?
Okay.
For Officer Dean?
Let me see if I can hear you now.
To some extent, yes.
So specifically, where is the instruction to Officer Dean not to announce himself at an open structure call?
It would be in the scene approach training.
Did you review that?
Not the lesson plan, no.
Do you know specifically from what you reviewed that Officer Dean was told specifically not to announce his presence at an open structure call?
In those specific terms, dealing with that specific call, no.
Okay. No further questions.
That's a good answer.
Pretty correct. Any objections to this witness testifying, Mr. Smith?
1 second.
Okay.
So this is just
Well,
a
that
Dalbert on this guy.
Is it? No jury yet?
Jury here?
Okay, yeah, no, that was Dalbert. Well, I hope the defense does better with this witness than they just did right there. That was not a good answer for the defense.
Let's see. I didn't think it was that bad of an answer. The question was he ordered to not announce? And he said, in this specific call, no. But he had testified, I think he had testified earlier that that was the common practice.
Okay, well, yeah, all right.
I guess we'll see when they actually call him. I'm hoping this internet issue kind of clears up for me because, yeah, it's doing you dirty. It's got your video really choppy.
I think it might be on my end.
I have no idea, but the way my internet's been acting today, I would suggest it's probably on mine. Very annoying. Just an announcement, guys, and I'll talk about this later. Yesterday, we had a push for Captain Coy cracking the something. What? Oh my God, my brain is broken. He's a young guy, had a YouTube channel, terminal illness. Yeah, here we go. Cracking the box. He has a terminal illness. He's on palliative care. And he did break his 100,000 subscriber goal that he wanted to get to before he passed away. And so that's awesome. Oh, wait. So I'm hearing that we both look smooth to you guys out in the chat. That's all that matters. I can deal with a choppy Branca. As long as you guys out in the world of YouTube and Rumble hear us just fine and see us just fine, that's the key. So
I suspect the problem was on my end. I had a file upload going up. It may have bogged everything down on my end.
Could be. We'll see. Because it's still choppy for me, even though it says smooth for them in Robody. But like I said, my download's been really weird this morning. I was trying to download some of my old broadcasts from StreamYard to free up space, and it said 10 days required. So it could be StreamYard's connection with me on the download end that's just causing issues, because I'm not having issues with YouTube. That seems fine. And it seems to only be on this connection with you, because my speed test says 900 meg down. So, and if it's smooth going out, that means it's probably just to me for whatever reason. Very, very breaded. Here we go. All right, so they're bringing in the jury. They did a Daubert hearing on this police expert. A Daubert hearing, again, if you don't know, is where they have just a set of qualification questions to make sure the expert is indeed an expert sufficient for the court. And so they'll ask them questions about their training, their expertise, their CV outside of the presence of the jury to see if they should even bother wasting the jury's time with the person at all. In this case, they have determined that it's just fine.
Everyone may be seated. We're waiting on one juror.
Can I once and for all denounce the ADL? Look, any league that's out there advocating for some sort of particular group's rights, all suspicious. Very, very suspect.
Good morning.
Good morning, Judge.
We have a swing to the courthouse this morning. We are ready to proceed. Ladies and gentlemen, this witness has been previously sworn to testify truthfully. Mr. Brissett.
Thank you, Your Honor.
See, now I'm getting issues.
The defense would call Dr. Jay Coombs to the stand.
Go ahead.
We're getting blasted by a winter storm out here, so.
Good morning.
How are you currently employed or otherwise occupied?
I'm an assistant professor of
God damn it.
practice with Sam Houston State University.
For those
Well, that has to be your end, right?
Yeah. See, I'm getting these weird
Houston State is. Where is that located?
It's down in Huntsville, Texas.
And how long have you worked with Sam Houston State?
I've been on full-time faculty.
It was originally the Sam
since
Houston
my retirement
Institute of
in,
Technology.
December of 2018, and then I was an adjunct faculty member there prior to that.
Where did you retire from full-time?
The Harris County Sheriff's Office in Houston, Texas.
How long were you at Harris County?
36 years.
Were you a certified Texas peace officer during that 36 years?
I was.
And do you still have a certified Texas peace officer license?
I do.
And there's different levels the jury's heard about. Aaron and Carol had a basic. What level do you hold?
I have a Master Peace Officer certificate as well, a license, as well as an instructor's license.
36 years before you retired, you had to go to an academy, correct?
Yes, I did.
And where did you go to an academy to begin with?
The Harris County Sheriff's Academy, and they're in Houston.
You've had a chance to listen to some of the testimony here this week and review the materials in this case. 36 years ago, they still teach the basics that they do today in the police academies?
The basics, yes.
In addition to going to a police academy, what other type of training have you had that prepared you to come to court today?
I've had a number, literally thousands of hours of in-service training throughout my time as with the Harris County.
So this guy's
Sheriff's
going to be
Office.
critical because he's got to fix what the defense failed to fix on redirect yesterday.
In Redstone Arsenal,
When the
Alabama,
defendant
where I was
testified.
certified as a bomb technician.
Yeah, he's got to basically come in and say the guy didn't do bad police work.
Attended the
Right.
FBI National Academy in Quantico, Virginia, which is a leadership and management school for police administrators throughout the
Because their
United
clients are
States.
at real risk of getting convicted to 99 years in prison for doing bad police work.
When it comes to be called doctor, what type of formal education do you have as well?
Well, I completed my doctoral studies in 2004 there at Sam Houston. Prior to that, I completed a master's degree in 98 and then my bachelor's degree in 1980. Yes, 1980.
So while I was troubleshooting
Doctorate
internet,
in criminal
I didn't grab a breakfast snack and I didn't grab any liquid to drink. So I'll be right back in just a second.
What I teach in our Master of Science program, which is geared toward mid-career practitioners. So we're talking sergeants, lieutenants, captains in law enforcement agencies throughout Texas. In our online program throughout the United States, we've even got some students with the Chinese National Police.
That's
we
good.
Basically bring them up to speed on several aspects in criminal justice. I teach management and administration, administration and leadership, as well as ethics, and then the human resources.
Why ethics to mid-range police officers?
Ethics is critical to policing in the United States. Not so much if you're in a totalitarian dictatorship, but here we need to understand not so much what to do at times, but what's the right thing to do. And that's very important for police leadership.
In addition to the training you've talked about, did you also go to a program called the Force Science Institute?
I did. The Force Science.
I'm a graduate of Force Science Institute.
In February of 2018. And it talks a lot about human dynamics, the speed at which people can perceive things, react to things, and other subjects.
What year did I graduate Force Science?
In your time at Harris County, in addition to being
The year before him,
Right.
2000. Oh, wait a minute. No, 2 years after, 2 years ago,
I
2020.
did. I joined the agency in September of 1982. I made sergeant in August of 1985, lieutenant October of 88, and then captain in May of 97.
Is part of your duties, the Harris County Sheriff's Department set up a little bit different than some of the departments here in the Metroplex. Would you agree with that?
Yes.
Is that based on the geographical areas of the county of Harris, that there's a large part of unincorporated as compared to, say, Tarrant or Dallas?
It's not only a large part of the county is unincorporated, but it's also very heavily densely populated as well.
We've heard about districts here, central, east. Was the sheriff's department there assigned district numbers?
Yes.
In the last district that you were in charge of, how big a population space were you responsible for?
I was responsible for over 800,000 people and 174 deputies.
In your role as a commander of that sector, do I have that right, commander, or what was the title for that?
District commander.
Did you have to review use of force reports?
I did.
What is a use of force report?
This is something that's relatively new in policing, probably about the last 15 years or so. It's a general rule in American policing now that anytime an officer uses force, for whatever reason, they generate a separate report detailing the force that was used, the resistance that required that use of force, where the force was applied, what category of force was used. And that way we can keep detailed records to what is basically working and what's not working.
When you look at a use of force report, those can happen from simple laying hands on an individual
Yes,
all the way up to the discharge and use of deadly force. Would you agree with that?
yes.
And is your role, you were responsible for reviewing those for your sector and making decisions whether to send them up the chain of command or finish them at your level? Is that safe to say?
All except for officer-involved shootings. Now there I would review, but an officer-involved shooting, the decisions are made at a much higher level.
How's our boy doing here?
whether it's a simple use of
You broke up
force
there.
with hands or an officer-involved shooting. it's
They're just going over qualifications.
concept and
He was a
effect
district
Sure.
commander someplace. I missed it. Responsible for a district of 800,000 people.
You've had a chance to
Familiar with use of force reports.
material when Mr. Lane retained you to be part of the defense team. Is that safe to say?
Yes, it is.
You've had a chance to look at State's Exhibit 1 and then the work that Mr. Fredericks did on the video, breaking it down frame by frame and showing you what you could discard from the image and what you could pay special attention to, correct?
Yes,
Are you prepared to walk the members of the jury through how you would grade and walk through this use of force situation here today?
I am.
In addition, there's been a lot of talk, and you've been here this week. Expert row is right here on the front row behind us. A lot of discussion about general orders.
Yes,
You're aware that Fort Worth has general orders.
yes.
Is it safe to say every department in the country has general orders?
I would hope so.
Department of Justice for their agents has an overarching set of general orders for their agents as well.
Yes.
You looked at academy materials. In addition to academy materials from Fort Worth, you know, if you do, that TCOL, the certification body for you and other peace officers, the sheriffs that are here in the room, have basics that you have to teach to, a minimum level. Is that safe to say? As part of their criteria to be a peace officer, you got to know this.
Yes.
If we could break this down, let's start from the time they receive a call. Why is it important to get the most information possible on the screen to the officers when they go to the scene?
Well, the more fully briefed an officer is when he or she is en route to a scene, the better they're able to make decisions about how to handle that scene.
You've seen the call text that's been admitted, the typed words, and then you've listened to the audio for the dispatch and seen the NBC printouts, correct?
Yes,
You understand that the play call for this from dispatch was a signal 56, correct?
yes.
And your understanding, what is a signal 56 at Fort Worth Police Department?
Signal 56 is an open structure.
As the expert, you've had a chance to review all the general orders. What's it tell you to do if you're Carol and Aaron at the time they get a signal 56 dispatch?
A signal 56, according to Fort Worth PD policies, to be handled as an alarm call.
Is there a particular
Okay.
audible alarms and silent alarms?
Yes,
They're both different in the playbook, correct?
yes.
Which type of alarm are they supposed to treat this as?
Audible.
Okay? If they treat it as a silent, you need to look at the book.
Excuse me. Yeah, it's silent. My apologies.
Okay,
Oh my God. You had one job.
Yes,
and it has a steps. They don't say you have to go in order, but there's a checklist that you have to accomplish, correct?
yes,
The deputies under your command during your 3 decades at the Harris County Sheriff's
This
Office.
guy does look like
you
Tom
expect
Skerritt.
that your deputies would know each step for every one of the things in a general orders book that's 3 inches thick?
Well, I would expect they would have a good working knowledge of it, as I had a good working knowledge of it.
And are topics like that covered during these roll calls that you would have with deputies each day if there was a point of emphasis
That's
from,
uncanny.
command that we needed to address some issues? Hey, we've been sloppy on the radio. Here's the procedure for making radio calls. That type of stuff can be cleaned up in a group setting.
Yes,
So you've read the general orders for Fort Worth. Do they require Aaron and Carol that night to have a general understanding of all the orders?
yes, they do.
General understanding, and they have to be able to function and adapt the orders to the scene that they're faced with. Is that safe to say?
Yes.
Why is that important when you're looking at stuff?
Well, in policing, we're dealing with human beings. That's where the term police comes from, polis, meaning people. you can't write a policy and a procedure that applies to all people and all police officers in all situations. They call them general orders, and they are, but it's understood that sometimes an officer on a scene literally has to call an audible or handle something a way that might not be entirely in keeping with policy. And after that call, that officer is made to answer for why that deviation was taken, and they have to justify their actions.
Based on the call text that you've seen, and it's been admitted into evidence, is parking on Mississippi appropriate for these two officers?
Yes.
What are your thoughts on how they ultimately walked up to the house in
This
question?
guy's going to take him through the entire
Well-
scene again and explain why it was all just fine. Like that's his whole purpose.
Number one.
That's his job. He better. That's what they're paying him for.
Other than there is an open door. Why? Is it
By the way, the
because
defendant should have done this himself.
the door open, or
Right.
had
The
something
defendant should have maybe
occurred?
like taken notes.
So, we discussed family disturbances, how you approach those family disturbances. When you're coming up on a scene, what police officers are trained to do generally is one, not walk right up to the front door. You don't go up the path. You would walk across the yards, and before you get to the house where the call is, whether it's an open door call, whether it's a family disturbance, something like this, you stop and you listen. You try to listen to see what's going on because you're trying to gain information. Again, so you can know better what to do. You also know better what is or is not perhaps going on in that structure. So you listen, you look, and then you come up and approach the residents.
What observations do you have of, once they got up to the front door, the process, let's break it down into some chunks.
Okay.
From the front door to say where the lawnmower is. You
Okay.
Take the members of the jury through your observations there.
Sure.
He's a law enforcement policy expert, folks.
They approach the front door, they look inside, and again, this is proper. They're trying to gain information. And from the testimony I've heard and from the things that I've read, the photographs I've seen, the interior of that house was a mess. Now, the question becomes, why is it a mess? Is it the maid's day off? Or is it being burgled? Has something gone on in there? It could be many things.
Maid's
right there.
day
It's not
off.
necessarily one thing or the other.
In an 800 square
They
foot
need some
house.
information. At that
Yeah.
point, so
Not
what
sure
does
that's a
Fort Worth
maid
policy
type of
tell them to
neighborhood,
do?
buddy.
It tells them to
And they might live
go-
there.
They will go around to the structure to check for forced entry. So they're there at the door, they're looking, they don't see anybody in the living room area that they can see through the door.
Although my maid's doing pretty well for
Cross
herself.
that threshold, and they turn the corner and they're going up the what we call the B side of the house. Think of it this way. If the front of the house facing the street, that's the A side, then it's B, C, and D. So now they're on the B side and they're approaching that second door.
You listened to some questions yesterday about how Aaron and Carol cleared the door on the A side and then the door on the AB side as it makes the turn, B side.
Yes.
What observations do you make as a supervisor or as a police officer in general, how and if they cleared those doors?
Again, it depends on the situation. If they just had an armed robbery suspect run in there, you're going to cross those thresholds much differently in a much more tactical manner. They didn't know what they had. They're looking in, they don't see anybody, so they go ahead and cross the threshold. So the way in which they did it, given the nature of the call, given the information that they picked up at that point, was perfectly fine.
When you get to the Bravo side door, the B side door,
Yes.
what observations, at this point, it appears that Dean's camera is energized at that point. Is that safe to say? It's turned on between the A side and the B side movement right there, and it comes fully alive as they get to the corner, audio live?
I think it comes on when they're at the front entrance, and then shortly thereafter, the audio comes on with the two beeps as they're moving.
What observations do you make of how they handle crossing the B door?
Again, they're looking, they're listening, they're talking with each other. They still don't see anything, although they're seeing more. Now they're seeing cabinets open, they're seeing drawers open. This is concerning. Again, it could be just the fact that whoever lives there doesn't really close their cabinets. But it's also a sign of a burglary. But the problem of it is that they don't really know. There's nothing definitive right now to tell them what they've actually got. They look in the area, they don't see a threat, so they cross that threshold.
And you've had a chance to go out to the scene, so you've not only seen the stuff in a cold scenario where you've seen crime scene photos, you've also had a chance to be on the street and look at the residents, correct?
Yes.
Once you clear the Bravo window, the B window, B door,
Mhm.
are there any windows past the lawnmower till we get to the backyard?
I don't believe so, no.
You were here yesterday and there was questions about how to clear the two cars, correct?
Yes.
What are your observations about how these two rookies cleared those cars?
Again, they were talking and they cleared the cars. There are officers that won't. They'll forget them, and that's not good police work. They took the extra time to clear those vehicles to make sure either A, there was not a suspect, or there was not a victim inside those vehicles. They did just a fine job.
They didn't just do a good job; they did a great job.
I wouldn't say it was bad police work. In fact, I'd say it was quite good.
Light to energize and look inside those cars?
Given what they had, because at this point in time, they really still don't know what they had. It could be something, it could be nothing. So they're still in this fact finding. So no, they need the light to illuminate the inside of the car. And they use the light to do that. And that, again, in given what they had on that scene that night, it's perfectly fine.
Why couldn't they prepare their client to say this?
Officers either young
I don't
or
know.
old and experience level to start calling
Hire
out
this
the
guy to
place
prepare their client to say this.
premises for an open structure at that stage, at that point.
They could or they couldn't. Some officers would, other officers may not. It's the officer's call on the scene.
Is it like TV where you get an instant response back from dispatch in your experience on instant license plate returns?
Yeah.
We're talking a couple minutes?
Well, it could be, but also too, just the time to get on the radio. It could be a busy night. You have to wait, key up. Well, then somebody might be keying at the same time. You have to wait. Well, while you're waiting there to run that tag, you're also wasting time.
It's all a trade-off. You're doing one thing, not another thing. You can't do everything.
Visualize the scene in person and then look at the photos. The time that Aaron takes as he goes on the B side of the structure, down the right-hand side of the vehicles to the detached garage. What are your thoughts on how observing that human door and then the roll-up door were done by Dean at that point?
What I'm seeing here is both officers are being very methodical. This isn't a rush in, a run to get to the backyard or wherever. This also isn't something that they're taking in a cavalier manner. In other words, this call's no big deal. We're wasting our time here. They're taking it step by step. They're proceeding slowly and methodically. As Dean made the corner at the car, He's checking the garage door for forced entry. He's also checking the walk-in door for forced entry. Again, given what they had, was this a detailed, down on his hands and knees inspection of the door? No, but that wasn't really necessary at that time. A quick look, a quick sweep to see if there's any obvious signs of forced entry on both of those doors.
Part of your preparation for this case, you and Mr. Fredericks had a discussion, several discussions regarding his observations, both visually and the audio visual. The audio you recognized and discerned and prepared an exhibit that was admitted yesterday, correct?
Yes,
And are you able to, having looked at the timeline, may I approach her?
Yes.
My apologies, Lisa, with the sirens going off, this was the last thing I was thinking of this morning. Dr. Koontz, I'm going to show you what's been admitted as Defendants 44. You had a chance to sit down with Mr. Fredericks and go over that on his deck at our office on Sunday afternoon and hash all this out, much like the jury got to see stuff here yesterday, correct?
I have.
And when you're looking at Defendants 44,
Hey, just a shout out to my chat,
when you're looking at
who
44,
I love very much.
there is
If any of you has an in with a Dodge dealer who can get their hands on a Hellcat anywhere in this country, let me know.
07 and
You're
744
looking to buy a Hellcat?
Yep.
milliseconds through the time where we have the deep breath,
Come on, internet. Don't fail me now.
correct?
Seems like a good car for snowy weather.
Would you expect two officers
It's
that
the
are
point is to leave the snowy weather with it.
running a signal 56 play to be talking back and forth?
Yes, any call.
Why?
You're coordinating. their
Prefer a
activities.
Challenger
Each
Hellcat
officer
and
is
a
telling
new
the other
one,
what
not used.
they've seen. They could be warning the other officer. But again, this is, right now, we're trying to gain information. And by talking with each other, they're coordinating their activities and they're giving each other information.
When they get to the backyard, you understand the general orders for the silent alarm, somebody has to check the backyard. Fort Worth general orders, somebody's got to check the structure.
The structure.
And the structure in this case has 4 sides.
Yes,
So the C side, the Charlie side, and the Delta side are inside the fence line of this structure, this habitation area, correct?
yes,
So somebody's got to clear C and D.
that's correct.
And these 2 officers, on your understanding, they were ordered there by the city of Fort Worth.
That's correct.
Their crossover move that Officer Dean talked about yesterday, do you have any concerns or anything with how they entered the gate, entered the backyard to cross over, given that they had to go in there?
No, that was the way that it's taught.
What do you mean by that?
Well, think of it this way. You have 2 officers at both sides of the door, gate, whatever. If they come in and go like this, well, they're having to stop their motion one way, turn, and then go the other way. It's very inefficient. It also slows them down. What you don't want to do, you want to spend as little time as possible there in that doorway. As we heard yesterday, it's called a fatal funnel. So you want to speed your way through there. And by crossing, it gets you through there very efficiently and very quickly.
Carol Dark says that she's gun belt to gun belt with Aaron in this situation. We can only see what Aaron's camera is capturing facing forward.
Yes.
Safe to say? If Carol Dark says she's gun belt to gun belt with Aaron, where do you place her in that scene at that time, after they've crossed over?
I would place her immediately to his left rear.
In the backyard, there's some sequences of time that you're here to talk about, correct?
Yes.
As part of this sequence of time, as part of your training to earn your PhD in teaching this field, do you look at how the human brain, specifically police officers, perceive events during critical incidents?
Yes.
How police officers perceive stuff in critical incidents is a lot like how humans may perceive stuff in high stress environments. Is that safe to say? It's not unique to just police.
No, because they're human actors.
Has this been studied not just recently, but for, I guess since time began, but since we started recording stuff, there's been some specific studies on reaction times and how officers in a high stress environment perceive stuff, correct?
Yes.
Are there also studies in the United States military that have been developed that would help
From
us
Top Gun.
thought processes for how people react?
Yes.
Is there a
Flew with your old man.
Best.
Best pilot I've ever seen.
I got the look. We're okay. What's an OODA loop?
An OODA loop was invented by Colonel John Boyd. Colonel Boyd was a fighter pilot during the 50s and before, but he would fly from base to base, and at the O Club, he would make his fellow fighter pilots a bet. And he would say, I can start off up in the air in a position of disadvantage, and within 40 seconds, I can be in a position of advantage over you. And he'd make him $100 bet. He never lost that bet, according to what I've read. And he developed what he called the OODA loop. That was his methodology of doing that. And the first step is called observe. First, you literally have to see. You have to observe something, whatever that may or may not be. The second step is you have to orientate yourself. What is that? And you react on your training, your experience, a number of things to figure out what that is. Then you have to decide the D in OODA loop. What are you going to do with this that you've now determined what it is? And then last, the A, you have to act on it. So those are the 4 steps of the OODA loop.
Did you prepare a poster board for us to help explain that to the jury?
I did.
May I approach now?
Yes, sir.
Dr. Koontz, I'm showing what's been marked for identification purposes as Defendant's Exhibit 48. Do you recognize 48?
I do.
And did you prepare this for us?
I did.
Would this aid you in your testimony before the jury to explain the OODA loop and how time is perceived by an individual when they have to make a decision under high stress?
The OODA loop.
We'd offer Defendant's 48 for all purposes, Judge.
No objection for demonstrative purposes, Your Honor. Other than that, it'd be a repetition of testimony. It's not evidence.
That's overruled. Defense 48 submitted.
Yeah, that's all nonsense.
May it be published as well, Your Honor?
Yes.
Ah!
Dr. Koontz, if we could start
My internet is reacting heavy to this weather. It's really weird. It's selectively fast.
Yes. Dr. Koontz, we got 14 in the box, so let's break it 7 and 7. Let's start down here.
Do you want me to try to feed it from my end?
And
I don't
take
think-
us through, and then we'll go down there where the other side can see.
I don't think that's going to work.
Can
Come on.
you, on the exhibit, can you take us through the decision process?
It'll clear
you're
up.
talking about here?
Sure. First, we begin with an observation. And that includes both outside information, in other words, this is something new that's just coming in. When you came in this morning, you saw me on the witness stand. You've not seen me there before. It can also be an observation from a changing circumstance. You're looking at something, you're first observing it, but then all of a sudden something changes. So those are your observations. All of us have some amount of experience, some amount of intuition, that feeling we get sometimes about something. That's feeding into these observations too, is kind of coloring it, it's kind of shading it. Then also too, we're getting feedback. Based on what happens over here, this is feeding back and it's basically modifying these observations.
Okay, we'll show that part down here. Same, so it's easier. Want to go through the same part again?
Okay, do we need to go through the same part again?
I want to make sure everybody can see, because if they have vision like me, they couldn't.
Okay, but basically, here are the observations. And they're
Holy
being fed
shit.
From outside information. Observations are also being fed as your observations change. You're getting new information in about that same thing. Information's coming in based on your intuition, your life experience. And also you're getting feedback from these other steps.
And how do you take that then to the next part for the decision?
Well, then you go to orientate. Well, you've got this observation, but what exactly is it? Okay. Well, it's going to depend a lot on your cultural traditions, what your thinking is about it, also any new information. What do we have now on our belts? We've got our phones. We have a question about something, first thing comes out to Google, and we find out new information.
Let's move that down here so
Okay.
everybody can see. So same area, so you're
Oh, come on.
orientating. What are we showing?
Stop killing me, internet.
Basically, what you're doing is
Story of my
taking an
morning.
observation in the abstract, and you're making sense out of it. What does it mean?
I don't know why they're going through OODA loop. I don't see how that applies unless they're going to get back to reaction time somehow.
Of this process, correct?
Yes,
And how does that boil down?
basically, based on your observation, what you're making out of it, well, now you've got to make some sort of decision, what you're going to do next.
And is the decision the same as acting?
No, not at all.
How so?
Well, every year along about this time, I make the decision to watch my diet in the new year and lose some weight. I don't act on it, unfortunately. So decisions and actions are two different things. We can make a decision that doesn't necessarily result in an action.
Dr. Koontz, when Aaron enters the backyard, he has a duty to his partner, Officer Darch. Does he not at that point?
Both officers have a duty to each other, yes.
What's Officer Darch's duty to Aaron?
To safeguard him, to protect him as best you can.
And would that be Aaron's duty to Officer Darch?
Yes, it is.
So they're not supposed to split up.
Has cover over the backyard, on the seaside, going back past the garage down the right, and the rest of the backyard that's visible at that point, correct?
Yes.
Aaron's cover is a little bit different because there's a window as soon as they cross in. Can you explain how you expect and what you observe here in that area?
The physical layout of the area,
Physical layout of the area.
once you go through the gate, to the immediate left, it's a fence line. And this fence line continues right to the edge of the window. So there's no room on the left side of the window as you're looking at it. To the right side of the window, probably 18 inches or so, give or take, is an air conditioning unit on that side of the window.
We don't have the exact measurements, but you've got to, based on the crime scene photos and dimensions of what we do know about window trims and stuff, we can make a rough estimate as to where stuff is.
Yes,
It's safe to say the AC unit out there is not 1 feet 9 inches wide.
I wouldn't think so, no.
Okay. This OODA loop, does Aaron go through more than one OODA loop, in your opinion, at the window?
Yes.
Can you break that down for the jury and give the jury the first OODA loop?
Okay, the first OODA loop is the approach to the window. Just like when they approach the property, check the A side, check the B side, check the garage, went through the gate. They're gaining information. They're making observations. They're orientating to those observations. They're making decisions, and then they're acting. They're moving forward. They're going through this the entire time that they're making the approach. When he's coming up to the window, all of a sudden he sees a figure, and it startles him. You can see that here in
I would
Mr.
object to
Frederick's,
saying it startled him.
audio analysis right here where it says the deep breath. When he takes this deep breath,
Can't
you
know what
can
his state
see
of mind is.
his thumb goes off the momentary switch on the flashlight, and he straightens his body up. At this time, it looks as though he's moving slightly backward and he's drawing his weapon. So this is one OODA loop. He's made an observation. It's a figure in a window. What's that figure doing? It's bent over at the waist and it's reaching for something. He's wondering what that is. He doesn't know. So he makes a decision. It could be a burglar. I need to arm myself. What would a reasonable police
burger?
officer do in the same or similar circumstances? A reasonable officer at that point in time is going to draw their weapon if they haven't drawn their weapon already. Then he steps forward to keep engaged and to keep watching what that individual is doing, to keep sight of that individual. That's the first OODA loop.
In that OODA loop, and looking at Mr. Frederick's visualization of the audio, you have the deep breath, and if you overlay that back on the video, you have a frame that's completely black out there. Is that the time frame we're talking about of the deep breath?
Yes,
You heard from Aaron's testimony yesterday.
The frame's completely black. I'm surprised the cop didn't shoot it.
At the academy in training.
That was a race
line of
joke.
duty training with his holster with a light on it. They're taught to turn the light on with their off hand.
yes.
And to you, the off hand's the hand that's not holding the firearm. Is that safe to say?
It's called the support hand, yes.
He wasn't able, you were able to visualize and make some observations. Was he able to turn the light on the frame rail with his offhand?
No,
What's that tell you about how the light got on then?
he actuated it with his trigger finger.
Does that give you a position of where his finger had to be at that time?
Yes.
Why is that important to you when you're looking at an officer-involved shooting such as this, as the sequencing of where an officer is prior to discharging the weapon?
Well, officers are taught to what's called index, and it literally means your index finger.
Is that push arm?
Yes.
That's not what it means. You can index anything. It means placing something in a particular position,
Thank you.
on a particular spot.
A modern firearm.
Don't point that
basically
thing at the
only way it's
jury.
gonna fire
Don't do it.
Is if you pull the trigger.
Oh my God. Bad trigger discipline.
If you keep your finger out of that trigger guard, you're not going to.
It'd be funny if a spray of water came out.
So what we've been teaching.
Azteco
probably
One
for the
says this is a
last 15
gross
to 20
misapplication
years
/
is to do
misunderstanding
what's
of the
called
OODA loop.
index.
I would agree.
Holding the weapon, you keep your index finger here. You do not put it inside the trigger guard. You certainly don't put it on the trigger. You keep it here.
With a Glock 17, look at the Glock 17,
Yes,
Glock 17 or any Glock, because they have the same trigger mechanism, do they not?
Yes,
The safety for what it is on a Glock is built into the trigger itself.
yes, it is.
The mock-up, the orange example we have here in front of us, I think is of a Beretta 92. That safety is actually up on the side by an exterior hammer.
Yes,
Glocks don't have a hammer that's visible on the outside,
they don't have a hammer, no.
and they don't have a safety on the outside like that mock-up of that Beretta there.
No.
So the training, this wasn't an accidental round or reckless. This, if the finger's here for the light, to turn the light on, we know at some point Aaron's finger is not in the area where the trigger is. Is that correct?
That's correct.
After that first OODA loop sequence, in the backyard, is there a second sequence that you observed?
There's a pause. You'll have to explain what an OODA loop is to me.
Can you explain that to the members of the jury?
The second OODA loop begins, and remember the feedback loops I showed you on Defense 48. As you're running through the OODA loop, each one of those steps has a feedback to observation. As he makes the act, as he executes the act to step forward and look further at what he saw, he's confronted by what he sees as a figure and a pistol pointed directly at him. That's the second OODA loop.
If OODA loops are applied to policing from the time that Aaron and Carol get to the front porch all the way through, as they're walking down the side of the B side of the structure, there are a lot of different options as part of their OODA loop as they're processing and constantly evaluating what's going on. Is that safe to say?
Yes, it is.
The first OODA loop in the backyard, there's still multiple decisions that are going on in the OODA loop process. I see data, I'm evaluating it, I gotta do something.
Yes.
The second OODA
What up,
loop,
Jeff?
once a weapon.
Sorry,
Aaron already has
decided to reject dinner all over the Italian leather sofa.
decision in that second OODA loop.
Yes.
Can you
We had words.
members of the jury?
Police officers are trained that when a firearm is pointed at you, shoot that individual. You are in extreme danger. You are in danger of being shot and killed. So really, as far as the training, as far as your options as a human being, it's down to one decision only.
Have there been studies as part of your education that you reviewed and understand that illustrate this?
Yes,
And is there a study known as the Blair study?
yes, there is.
Can you explain to the members of the jury what the Blair study was about?
Blair and his colleagues at the Texas State University had a question. What do you do if a suspect is standing, Your Honor, may I stand for just a minute? What does a police officer do if a suspect is standing with a weapon down his side like this? Do you shoot him? Do you not shoot him? What do you do? What is the reasonable thing to do? So what they did is they conducted an experiment where they had a Confederate stand just like that.
A Confederate.
And they brought in actual police officers. And both the Confederate and the officer had these very fancy research blocks. They've got all sorts of computer stuff wired up to them. So they can literally time when your finger touches the trigger, when the trigger's depressed. It's amazing what they do, and it feeds right into a computer. So what they told the officers is, okay, you're going to go in here and you're going to confront the suspect. The suspect is going to have a weapon down at their side. You're going to tell them, drop the gun. And they're either going to comply and drop the gun, or they're going to bring the gun up to you. If they start to bring the gun up, you shoot them. Got that? Got it. What they found was that the suspect, standing like this, can bring this weapon from here up to here in 0.38 seconds. less than half a second. The officers were told to stand like this in a ready-to-shoot position. Okay? And if he drops the weapon, well, fine. But if he brings it up to you, all the officer has to do is fire. The officer took 0.39 seconds on average to fire his weapon. What they found was, and I want to say it was approximately 61% of the time, the suspect was able to bring the weapon up and fire it before the officer standing there ready to fire could fire his or her weapon. Their finding was that, again, if an officer is placed in a situation where even a suspect has a weapon pointed down like this, that officer is in extreme danger, because the best they can hope for is probably to fire at the same time. Well, that's not a good thing. And in the worst case scenario, in the greater percentage, the suspect actually beat the officer to firing the weapon.
That study came out and was published subject to peer review back around 2011, as I recall.
That's correct.
Aaron was at the academy after 2011, based on your understanding, yes?
Yes.
Would an example that both Aaron and Officer Darts have talked about, where the target is bladed toward them and then it pivots to shoot, would that help simulate that in a different world of reaction time to get the officer's muscle memory to get to a point where they're able to discharge their weapon in a rapid fashion when they perceive a threat?
Yes, that's the entire purpose.
You were part of our activities on Sunday afternoon where we kept both Mr. Fredericks and Aaron separate.
Yes.
Leading into yesterday when Aaron took the stand before Mr. Fredericks, Aaron had never seen what you and Mr. Fredericks had been working on with the stuff, and you hadn't shared it with Aaron by any way, had you?
No.
Clearly, that much is obvious.
There was discussion as you sat here yesterday when Aaron was on the stand about Aaron seeing the barrel of the gun and it was rather large.
Yes.
You've been through critical incident shootings yourself as a police officer, have you not?
Yes.
You researched this area and worked in this area extensively. Is that safe to say?
Yes.
What happens with an officer when they're faced with a weapon where you hear, I don't see their hands, all I see is the barrel? What are we looking at?
Well, there are three things that can happen, and happen in a very high percentage of officer-involved shootings. If you remember, Grant Fredericks told us that human vision is about 180 degrees, a little more than 180 degrees. He said you could waggle your fingers like this. That 180 degrees decreases to about 2 to 3 degrees. It's like you're looking down a toilet paper tube, and it's called tunnel vision. I experienced this myself on the last critical incident I was involved in. I gave testimony.
The last one?
That it was a struggle between myself and a person trying to disarm me. And they kept asking me about the third guy trying to reach in and grab the gun. And I kept saying, there's no third guy there. Yes, there was, back and forth. Come to find out, there was a third guy there. But I was so fixated on retaining control of my weapon, I didn't even see this guy.
Yeah, we talked about this yesterday when I talked about the simulator system we used.
Shot was fired. That's tunnel vision. Second is auditory exclusion. Many times in the post-shooting investigations, officers will say the shots sounded muffled, or someone could be shouting at them right next to you. They don't even hear them. And last is time dilation. Time dilation, the officer can either perceive events as happening faster than they actually are or slower than they actually are. And again, these three perceptory phenomenon are common in most high-stress situations.
That's how I get when I get to the
Unfortunately,
fried
Officer
chicken
Al-Shiri
section
is
of a
very
buffet.
high-stress situation.
Actually, being faced with a deadly weapon is more high stress than just being a peace officer in general. Is that safe to say?
Absolutely.
The three things you talked about, is that part of what we would generalize as the lizard brain of our body? The reactions that take place?
Yes, under stress, you revert to your training.
What is the lizard brain in the studies in the vernacular?
Well, you're losing your ability for logical, reasoned thought. You're going into survival mode.
And you understand as part of Aaron's training at the academy, they have a whole week on officer survival.
Yes,
And additional training where they try to put the officers, and when you went to the academy, let's just say it's a while ago, right?
wow.
They didn't have survival cities built back when you went to the academy after you left the Marine Corps to simulate what we're seeing now in today's society, urban conflicts, domestic violence. That scenario setup really wasn't there in that capacity as it is now, both in the military and in police departments. Would you agree with that?
I would.
And maybe we took that from the military as they've been overseas for 20 plus years of building whole cities here to replicate what they see overseas. Departments, officers that have come back to serve as peace officers have brought that type of training in realistic venues for police officers. Is that safe to say?
Object are leading and compound question.
You understand there was a city in Fort Worth in the.
This one's
academy
just all wrong, Your Honor.
training. Is that safe to say?
Yes,
And you understand as part of the training in your review that he got to,
Oh, that's the new leading workaround. You understand? Is that safe to say?
loaded gun.
What, if anything, would you understand is safe to say?
I'm sorry, say this again.
Can
Would you
say,
agree or disagree?
Dr. Coons, what you experienced in your critical incidents or what Aaron experienced in training in an academy is realistic as you can get it? Can you simulate being shot?
You can certainly simulate it, but it's not going to be the real thing. You're not going to experience usually the level that you would.
Because at the end of the day, when the training person blows the whistle, the exercise stops.
That's correct.
OODA loops continue with both Aaron and Officer Darch after Aaron's weapon is discharged. Would you agree with that?
Yes.
Can you take us through your observations in an OODA loop form of Aaron and what you observed is post-incident, post-shot fire till the time to get to the A side door?
Okay. Both officers, again, are under high stress. They're reverting to their training. What's their training? You hear Officer Darch immediately get on the radio. I believe she says shots fired, shots fired, shots fired. Officer Dean gets on the radio, advises there's been shots fired, and second behind that, he needs MedStar. He understands that he has probably shot somebody, and if that's the case, they're going to need medical help. And he's summoning them, again, second only after advising dispatch of what's just happened. They understand that something's going on in here. We don't know what, but we've got to get in there and we've got to make some sense out of this, figure out what we've got here. They're retracing their steps, and as they turn to do so, again, Officer Dean is asking Officer Darch for her TACMED bag. He's thinking of what he may need once he gets inside there. They retrace their steps, they go around, and they go to the A side door.
You heard questions yesterday about sharing information about a weapon
Yes,
and what Aaron did not convey to Carol as they're going around. If you train together, is it safe to assume that if one officer's discharged their weapon, they did it for a reason?
yes.
You would expect that for two people that went to the academy together and trained together, or just partners in general?
Well, partners in general. If an officer fires a shot, something bad has happened.
the auditory exclusion and the adrenaline dump that happens with a critical incident, is Aaron over that as soon as he clears the fence to go back down the driveway?
Not at all.
How long can something, the effects of that last at a scene?
At least several minutes.
Once Aaron gets to the front door, the A side door, and goes in, there was questions yesterday about whether they did a slow clear, a fast clear, or taking place going through.
Yes.
You've observed the stakes one. What are your observations as to how these two rookies went through and cleared to get into the medical aid?
There's clearing a room and there's clearing a room. And it depends on the circumstances. When I was with the Criminal Warrants Division and we would serve a felony warrant on a house, we would clear that house. We would do it slowly. We would do it methodically. We would physically enter a room, cross the door, get out of the fatal funnels, go along the walls. We would open every closet door. We would go through all the clothes at the bottom of the closet. We would look under the bed. While we had other deputies stationed outside covering up the hall and down the hall, we would go through the entire house, room to room to room, doing that. When we got done clearing that house, the attic, now in Houston, we don't have basements. I don't know about y'all up here. So we don't have to worry about a basement in Houston. Then we would go to outer buildings. But make a long story short, and it would take us 20, 30, 40 minutes. But when we said that residence was clear, it was clear. And that's appropriate for that type of a circumstance. This circumstance here is different. Officer Dean and Officer Darch are figuring someone has been shot. So there's a need to get there and get medical aid to that individual. On the other hand, they still don't know what's actually going on in that house. There could be dangers in that house. So what they're doing is what Officer Dean described incorrectly as a fast clear. What they're not doing is just running from the front door straight to the back bedroom, where somebody might step out of a room and shoot them in the back. They are making observations as they're moving quickly. They're looking into each room, making sure there's not someone right there. They're proceeding forward. So what they're doing is they're balancing their priorities on the given situation with the understanding there's somebody down there that might need medical help. So that's a different type of clear. That's a fast clear, and it's appropriate for that type of circumstance.
Would you agree with me that every decision an officer makes is a calculated risk to it for their own safety?
Yes, just putting on the uniform.
Officer Dean arrives inside the room and you hear a deep breath after he locates and he verbalizes some stuff in there. Can you take us through what your observations are in the room with Officer Dean once he gets inside the room of incident?
Well, Officer Dean locates, he approaches Ms. Jefferson. He locates the weapon. You can hear Officer Darch approaching Zion, talking with him, telling
Approaching
him he's
Zion?
not going to be arrested.
In the
and removing
Matrix?
him from the room.
That's the kid.
Yeah.
Officer Dean takes custody of the weapon and
We're
relocates the weapon.
free now.
Is there going to be a big cool rave in the basement?
Oh, you're pretty hot.
Oh, sorry.
Let me turn you down.
Turn myself down here too.
Effects of what has taken place as an officer comes back out of the tunnel vision when they start to get their hearing back, that you may see effects on their body or hear it verbalized in body-worn cameras from incidents.
Yes.
Anything that you observed in watching and listening to the
Oh, is this more socially acceptable?
in that room that's inconsistent?
Still pretty loud.
Here, I got you. I'll turn you down on this end.
To exhibit.
No.
You mentioned earlier about time can either expand or compress. What did you mean by that? There was questions yesterday yesterday by the state about the time to render aid. Do you have an opinion in that area about how time can compress or stand still for officers that have just discharged their weapon and been in a high stress event?
Well, even though he was under an extreme amount of stress, one of the first actions in the immediate aftermath of this event was Officer Dean considering medical help for Miss Jefferson. He verbalized it on the radio after notifying dispatch, and then in asking for Officer Darch's TACMED bag. So concern for her welfare, concern for getting her medical treatment is on his mind.
The issue of time, for the time to do something in the room after the weapon has been moved. He's trained to move the weapon.
Yes.
Can time stand still for folks where they may think it may be a minute on the clock, as Mr. Smith mentioned yesterday, but it may be in somebody's mind shorter or longer?
Yes.
If I could, Dr. Cummings, I want to go back outside to the start of the second OODA loop. You're familiar with Fort Worth General Orders at this point, are you not?
Yes.
You're familiar not only with the playbook as it talks about Signal 56, audible alarms, and then the silent alarm that they were running, but also their use of force standards, correct?
Yes.
In Texas, under TCOL and under the training that Fort Worth utilizes, is mere presence alone sufficient to identify somebody as a peace officer?
Mere presence alone,
Police officer in uniform as Aaron was that night.
yes. In uniform, yes.
So the misnomer in the media that they have to identify themselves, that's not what the orders say, is that correct?
No.
And that's not just Fort Worth's orders, that might be Denver, Colorado's orders,
What?
Department of Justice's orders. If there are times where officers are faced with deadly force as soon as they walk up on something, is that correct?
That's correct.
Azteca one says someone needs to describe the victim's OODA loop. These don't happen in isolation.
Give them the tools to function when they're out on.
I mean,
call like they're ordered
The
to.
problem is that the victim's
Yes, it is.
actions don't matter except to the extent that they influence the defendant's decisions, because the victim isn't charged with a crime here.
Drop it.
No.
That's correct, but I think they're suggesting the OODA loop concept only really applies if you're dealing with two actors and they're
Officers
each have their own decision loops and one's inside the other's decision loop.
Verbalize?
verbalize
Yeah.
what they visualize.
Well, they're verbalizing what they want.
What do you mean by that?
In other words, as Officer Dean's testified, he was taught at the academy, the hands are where the attack is going to come from. Watch the hands. He couldn't see, when he's seeing this subject that we now know to be Ms. Jefferson, bent over reaching for something, he's wanting to see her hands, to see what she's actually doing. His stress level.
Got a
is
woman bent
going
over in
through the
front of him and
ceiling,
he's interested in her hands.
and
Gay.
he's verbalizing that. You know, show me your hands. Let me see what's in your hands.
The hips don't lie.
That's what he wanted to see.
In your review of critical incidents across the country, those commands are usually very salty language. Would you agree?
It can be very salty language, yes.
This was rather tame compared to what you've experienced on some of those. Would you agree?
Yes, it was.
No cuss words.
Not that I recall, no. He's an engineer.
There's a lot of questions.
He's an engineer, so no cuss words. I know different engineers.
Yes. Yes.
Your understanding of how you apply use of force standards in making a grading system, you have to take their experience level into play, correct?
Yes.
You have to look at an officer based on what they knew at the time, based on their experience, did they act reasonably?
Yes.
In looking at the totality of the circumstances, though this is a very tragic situation, do you have an opinion as to whether or not Officer Dean acted reasonably given the information that he had before him?
I do.
Object on invading the province of the jury.
Overrule.
Let me ask that again. Based on, in calculating reasonableness for this,
Yes,
you have to take the two rookies as they are. Darch isn't on trial, so you have to take Dean as a rookie. Do you consider him a rookie at that point?
absolutely. He only had a year on the street.
You have to take the rookie officer as he is, given what he's given from the call taker to dispatch to start with, correct?
Yes,
And you have to add up all the other data points as you go along till you get to the decision in the second who to look to fire, is that correct?
yes,
And is that where the decision stops? It's you judged what you knew at the time.
that's correct.
Do you have an opinion as to whether or not Officer Dean's actions that night on October the 12th, 2019 were reasonable based on your understanding of the use of force standards and the ability to defend himself against a deadly weapon?
Officer D actions that night. And yes, this is a terrible event. There's nothing good about this. But his actions as a police officer were reasonable in what he was doing.
Thank you. I'll pass the witness.
Let's take a morning break before we do cross-examination. We'll start up at 10.
Okay.
Okay, see you then.
Do you want those?
Now he gets yelled at by the prosecutor for an hour.
Oh my God. So I don't know, assessment. Some of these experts have the ability to make me just exceedingly uninterested in their testimony. And I think that's a problem that experts need to recognize, because if I'm uninterested, the jury's probably uninterested too. But can you explain to me an OODA loop?
So this is, they mentioned John Boyd. He was a fighter pilot, American fighter pilot, a trainer of other fighter pilots. And he came up, I don't know if he invented it, but he applied this concept of an OODA loop. Effectively, it's a way of describing arriving at actions faster than the opponent fighter pilot. So you're observing, you're orienting your plane, you're making decisions, and then you're executing those decisions in a loop, because once you make an action, then things have changed. You have to observe, orient, decide, act again, over and over and over again. That's why they call it a loop. And the point is to do that loop faster than the enemy is doing it.
Sure.
So you're more effective. But it really only applies in that context, that it's not just you doing a loop in isolation, you're doing the loop faster. That's the point.
Gotcha.
Faster than someone else. So it doesn't really apply here. This is more a reaction time kind of scenario where you see the gun, the muzzle's pointed at you, and you don't have the luxury of waiting. You have to make a decision right then, because if you wait, you're dead.
Right. It's not like there was a tactical interplay between these two, right? Because that's the concept. You've got, if I'm understanding correctly, you've got two parties who are each interested in a desired outcome, and that is victory over the other person. In a shootout, that would be death. But in this case, it's not a shootout. There's not like a plan going on for either person. So yeah, OODA loops don't matter here at all in that context. Why the hell is he talking about them? Hearing again.
I guess he read the book.
Oh, your book?
No. John Boyd's biography talks about the OODA loop at length.
Oh, I thought you were saying he read Law of Self-Defense on the OODA loop chapter.
What, does
It's good.
Andrew have a book?
Who's going out?
Hey, get your copy of Law of Self-Defense Principles for free. Go to Amazon, read the reviews, 1,200 reviews, 5-star rated, but don't buy the book at Amazon. They'll charge you $25 plus shipping and handling. We'll give you the book for free. We only ask you to cover the shipping and handling at lawofselfdefense.com/free book.
Very good. Very good. How you doing, Jeff?
Doing pretty good.
My internet seems to be clearing up because you guys are not choppy and roboty anymore, which is really nice. I really prefer to be able to actually hear you rather than miming the 7 syllables I got out of your sentence and trying to piece it together in my head before responding. Jesus. I know it's like I'm really was heartened to hear that going out, like the stream out to the audience was clear and fluid, because to me, I mean, I could barely understand anything that you guys were saying. So I apologize for my lack of like interaction there. I was just sitting here seething by myself. I do find it funny that this witness looks like Tom Skerritt from Top Gun, and then of course brings up a fighter pilot as the main course of questioning. Thanks. Now, I thought he was talking about a loop-de-loop at first. I was like, this is weird. Like, I don't know, because he said OODA loop, but I didn't have any concept of what that was.
Well, with all the we have the OODA loop today. Yesterday, what was the funnel of the tunnel?
Yeah,
funnel,
fatal
the
funnels.
The fatal funnels. Yeah, they have fatal funnels and OODA loops. It kind of reminds me of the Snoop Dogg's released a new cereal brand, Snoop Loops. That's kind of all I've been thinking about. No, it's a serious thing. It started like Snoop Loops. He and Master P. So
Attaboy. Hey, these Snoop loops are fire, you know.
Well, this expert said what he needed to say in direct.
Yeah,
not in a very dynamic, interesting fashion, but they got what they needed from him for use in closing. We'll have to see if he holds up on cross.
yeah,
That's
that's
interesting that Nick was saying was the guy he's an expert and he was obviously fascinated by what he had to say, but it wasn't being projected beyond the front of his desk.
yeah. He's not capturing them. And I
We've
don't know
seen better police use of force experts, right? What was the trial with a police use of force expert?
Kim Potter
Just came from surgery, right?
Yeah.
Just had a open heart surgery or something. 12 hours early, drove his car 1,000 miles to. They should have gotten that guy.
He's in Dallas, I think. He was like there. He's
The guy
like,
that literally invented everything the police ever did, plus rescues babies from South Africa. or
Right.
something.
That guy.
Have you heard of SWAT teams? I made those. Like,
He walks up to the witness stand, takes his cape off.
hands babies that he rescued on the way to women in the audience. He's like, here, hold this for me. I'll grab them when I get back, and then I'll
You get a saved baby. You get a saved baby. Everybody gets a saved baby.
They're
leave
not
here
just
and
from
find them
Madonna
good
anymore.
homes. And if they don't have good homes, I'll build them a home myself. Jesus, who is this guy? Oh, and I work for free.
Yeah. Oh yeah, that was good.
Oh, yeah, why don't they have that guy? And that guy was fascinating to listen to. Like, he was very interesting to listen to, just fine on the stand. And it's that's what they need. I don't know what it is, because this guy seems like he knows. Well, I mean, aside from talking too much about OODA loops, but just generally, he seems like he knows his stuff. He's a professor. It's like, okay, you should be able to make this interesting and engaging for people. And maybe I'll do that. I'll do a course on training expert witnesses. Like, I don't know your subjects at all, but I know that you're boring.
Right.
We'll just take an acting class or a drama class or tune into a Toastmasters once in a while. Just learn something about speaking.
Yeah. Learn anything about speaking, or just be enjoyable. Like, when guys are super boring talking about the thing that they do all the time and they're boring, I'm like, what do you do for entertainment? Like, how do you not know how to engage anything? Do you just sit around and read material about the stuff you're interested in? And maybe that's what they do, but I don't know. Like, at least Bronca takes the guns out and shoots them.
That's true. Well, a lot of people don't have much of a personality.
Yeah, I've met some.
And most of them are professors. Professors are genuinely some of the most boring people there are. These drone on every day about the same subject. And I wonder if experts get caught. The experts that testify a lot, if they can just get caught up in that. All right, this is the 8,000th time I've told this story without realizing it's the first time the jury's heard it.
Well, there was that one chick ballistics expert. She was in 2 trials. She was in Edgecombe and Rittenhouse, right? And she's really pretty, and she gets on the stand. She sounded like a robot from Wisconsin. God, it was unbearable. Her like accent and affectation to her speech was very teacher-like and organized, but she also had the thick accent.
Chick, right? She would take the question and then turn her head like a robot.
Yeah,
To look at the jury.
it was like a robotic cheese.
I remember her now.
And it was like, why? How are you bad at this? Like, And we'd speculated that maybe she had early on had testimony where she was kind of engaging, but maybe she like got into it and slipped up and ruined the case or something. I don't know. Like she had a trauma. God, why are you like this? Let me tell you about 1997. No, she didn't look that old, but no, it's just weird when they like, this is your subject. This is what you do. This is what you talk about all the time. Yeah. You should be able to add something to make it engaging, but no, I think he covered what he needed to cover. First, he covered that their weird parking job was appropriate. They parked away from the house and that really sets the stage. And I feel like the defendant should have set that stage earlier. He's like, well, we parked over there. I knew it wasn't the right house, but we parked over there because she parked over there and I wanted to. No, you parked over there because the whole point was you're trying to approach this house without being noticed.
Mm-hmm.
So you don't park 2 squad cars right in front of the house for some burglar to like walk by a window, be like, what the hell is that? Like that seems pretty obvious to me. Park a half block away, make it look like you're at some other house for some other thing, walk up in darkness and just a little bit of effort to conceal your approach. We're not in Splinter Cell here, right? Like you don't have to knock out a guard or anything, but just approach the house from a non-obvious perspective. And he didn't do that yesterday. And this guy's like, no, it seemed fine. They parked over there, and then that sets the tone for the rest of the encounter, as opposed to apologizing for every action you made. That all sort of comport with this idea that you don't want the people inside the house to know where you are. And so then he's on the defensive the entire time. He's like, well, I guess if I shined my flashlight for 4 seconds into a car, everybody in the house obviously would know I was there. So you're right. That was bad police work. No, that's insane. That's insane. Only someone who's looking out the window at the car is going to notice a light going on.
Also, the rule is you don't unnecessarily disclose your position. Sometimes you have to.
Right.
I mean, if you can't clear the car with your eyes closed in the dark, you have to be able to see.
Yeah. And well, don't you agree that walking across the yard could have exposed you to someone and said, well, but I had to get across the yard. Like I have to do that.
But it's like the ammo thing. Nothing would have been the right choice, right? If he hadn't used his flashlight, they would have said, but wouldn't a responsible officer use their light so they could see what they were supposed to be looking at? Oh yeah, I guess you're right.
Right. Yeah. Well, how could
no decision would be the right decision.
How could you possibly have seen inside the car? Wasn't it dark out? Well, I mean, yeah.
Didn't they teach you at the academy to use the flashlight when it was dark?
And that was the summary of the prosecutor's line of questioning yesterday was be loud, belligerent, be offended at every action, and then get the officer to empathize with the offense, be self-critical with perfect 20/20 hindsight, and then play into that. It was a smart technique to use. It's not really legally effective, but practically effective. I mean, you got the officer to sit there and say every decision he made was bad just because there was a bad result. But his
What final
decisions,
grade did he give himself?
B+. But
Good for
but he
him.
didn't sound like the cop or the prosecutor was right. You want to rethink that grade? Man, bad decision, bad decision, bad decision, bad decision. B+. This doesn't make sense, does it? And the jury's hearing that. That's a good tactical sort of engaging rhetorical device that he used.
Right.
And he set this cop up perfectly for it. And then he bowled him down at the end. Legally, none of that matters. Practically for the jury, it might.
Well, we know what the
matter.
state's closing is going to be, right? This guy told us himself 40 times that he engaged in bad police work, and this poor victim is dead as a result. Somebody has to be held accountable.
Well, it started with this. B+ police work. Boom. Picture of dead woman. That's a B+ police work in Dallas? I don't think so. I don't think so at all. Let's talk about that B+. He self-graded a B+ that he said. Pretty good. Just barely below perfect. And look at this. Boom. Not good police work. Boom. Have a chart with all of the times. What would you say about this thing? Not good police work. B+. B+.
Right.
B plus.
Or have them all on index cards and then throw them all up in the air at the end.
Is this the kind of police work we expect? Is this above average police work to you? Is this just
Grade on the
below the
curve.
best?
Right.
Yeah, I mean, just that's a narrative waiting to be just home run on close. I hope he does it. I hope because he's got that thick Texas drawl too. He's like, B plus. That's a B plus right there. Let's talk about a B plus. I would love that.
It's a
Oh
B
my
plus.
God.
I doubt it.
Oh my God. What does an F look like? Uvalde.
Oh God.
That's what an F looks like.
The whole class gets an F.
Jeez. Yeah, in Uvalde, they're just glad they grade on a curve.
Yeah. C plus for everybody. Young Putin takes the stand. Did the last half of his cross-examination go any better? Apparently not.
No, it didn't get better at all.
No.
Actually, at the very, very end, he finally got a little bit defensive and started saying he did the right thing. He did the only choice he could make at the time.
Right.
Of course,
The last couple minutes, but
yeah. Then the prosecutor goes, "Oh, the only choice? The only choice." And then he went back through all of the choices that he had admitted were bad. Do you have a choice here? Did you have a choice there? Did you have a choice before that fatal funnel? Yeah. Yeah.
Just learn to say, in accordance with my training, I did this.
Cross-examination.
Yes, thank you, Your Honor. Dr. Coons, do you have a copy of the general orders up there?
Dr. Coons.
327.01 dealing with the silent
Language.
No, sir.
I love Texas,
alarm? Do you
man.
remember those general orders?
Not every one verbatim, no.
Do you remember the
Dumbass.
part B of those general orders?
If you can refresh my memory.
If you tell me what it is, I remember it.
That all main exits should be guarded so as to prevent the escape of any offender?
Can I see the document, please?
Yes, that vote's witness.
Yes, sir.
You're reading
B.
B.
Yes, sir.
But the nonsensical part of this is this victim didn't die because they didn't cover the doors. That did not
Right.
contribute to her death.
Yeah.
It's irrelevant to her
Part of
death.
the general orders under silent alarm, isn't that correct?
It is.
That all main exits should be guarded so as to prevent the escape of any offender.
Should be.
Is that correct?
That's correct.
And that makes sense as part of the general order for a silent alarm, which refers back to open structure, because the police wouldn't want anyone to escape while they are investigating.
I guess
that open structure. Is
the
that correct?
narrative he's going to go with is
Not necessarily.
if they had had
The
enough
notice
police
says should,
officers
not
to
shall.
properly approach the house and cover
What I'm
it,
asking is, why
this
is
wouldn't
that
have
over there?
happened.
Well, again, it's a general order. Gives general instruction to their officers on how to approach that type of call. And that's why it says should and not shall.
But why is it theirs? To prevent people that are in that structure from fleeing, correct?
It is there to give general guidance to their officers.
But what is the general order? What message is it giving to the officer that's studying it, reading it, and acting out on it?
It's giving them information on how they should handle the call.
And that information is to guard the exits so that people cannot flee from the structure. Isn't that correct?
That's one thing for the officers to consider. Yes.
But isn't that the general message of the second part of the general order dealing with silent alarms?
That's the message, and that's why it says should and not shall.
So that way the officers can just have an out to act however they want. Is that it?
Oh, absolutely not.
Oh, so far, this is good.
Choose should, shall, whatever. I mean, it doesn't matter as long as they get the general gist of it. You're going to grade those papers and give these officers a passing grade. Isn't that correct?
Well, this isn't a test in the abstract. This is real life.
Oh, good
Oh.
answer.
It's real life. And somebody lost their life. Isn't that correct?
It's correct.
And somebody lost their life because of the decisions this defendant made in the early morning hours of October 12, 2019.
No, so it's not correct.
The decisions made by the defendant and the decisions made by Ms. Jefferson.
get to that here in a minute.
Oh, he's earning his money now.
I'm gonna get back to this.
Yeah, the prosecutor better rethink his strategy of trying to rattle him by sounding exasperated because it's not working.
Old Dallas from Aliens ain't taking none of that shit.
When you discuss the OODA loop and someone is observing, and someone is orienting, and then someone makes a decision, it doesn't just automatically happen that they act on it immediately. Is that correct?
Yes, sir, that's correct.
I mean, there's some
Covering your
time
mic didn't help, buddy.
that takes- some time that passes, isn't that correct?
Yes,
Between the decision to act and to act. Generally, how long does that last, especially when you're dealing with officer-involved shootings?
it depends.
Have you testified before that that decision usually lasts anywhere from a second, a third to a second and a half?
It can, yes.
So, may I approach the witness, Your Honor?
Yes, sir.
Just so that,
Oh, geez.
You remember testifying?
I think he's
in August
actually leaning
2018
into the
in Dallas
microphone.
County?
I did.
It's a different case,
Yep.
different facts.
It's almost as if a
And in that
general rule
testimony-
can't be applied to every
Sworn
situation.
testimony, right? Just want to tell the truth. Isn't it true that you said that according to the OODA loop and the research that you have, whenever the officer is orienting, then makes the decision, and it's anywhere from a second, a third to a second and a half for that officer to stop
It depends.
or act?
It depends on the situation, situational. Now, if you're talking about this event is entirely different than this event here.
Yep.
So you're saying that the event itself can rewrite the neurological aspects of the human brain and the human nervous system that delay reaction times when a person intakes information and then decides to act. Are you saying
Everybody who drives a car makes decisions faster than a second and a half.
the act that the person's going through doesn't change the hard wiring of the person's brain, does it?
It doesn't change the hardwiring of the brain. What it does, what changes is the person's ability to react to it. In other words, a simple stimulus will elicit a faster response. Now, more complex the decision is,
Just remember
the
that,
longer
ladies.
it's going to take. Now, this area of research started out probably in the late 40s and 50s with the traffic crashes. Basically, how long did it take people to take their foot off the throttle and put it onto the brake? What they found is that if the driver knew it was coming, it took them a lot less time to take the foot off the throttle, put it on the brake. If it was a surprise to the driver, it took them longer.
Okay, so now let's get back to officer-involved shootings. I mean, you testified previously that in your OODA loop, that an officer in an officer-involved shooting, from the minute they take in the information, from the instance that they take in the information and decide to act, that action to follow through with it can take anywhere from a second, a third, and a second and a half. Isn't that true?
Well, again, it's not my OODA loop, it's Colonel Boyd's OODA loop. I'm utilizing it. And again,
He gave testimony earlier about the 0.3 second response time from the study that was done. So not everything takes a second and a half.
that timing is going to vary based on the incident.
Are you a neurological scientist?
Oh, no.
So let's get back to this. You testified previously. Isn't it true that you've testified previously that the instant that the decision is made in the brain, for that action to be followed through, it takes a second, a third, and a second and a half? Isn't that true that you testified previously to that information?
In that particular case, given the circumstances of that case, based on the research that I have reviewed, in that case, yes, it took that time.
It took a second, a third, and a second and a half for that officer.
I would object on relevance here.
And then get that message to his hand. Is that right?
And it's the 8th time he's asked the question.
In that event, yes.
So someone is shooting, pulling the trigger over and over again, and
That didn't
decide
happen
to
here.
stop and you
Yeah,
talk about
Object to
ping pong, all
relevance.
those
There's
other
one
stuff, it
shot
takes a
fired, Your
second,
Honor.
a third,
Why do we care what
second and a
happens
half.
with
According to
multiple
your own
shots?
Testimony in 2018, for that message to get to the hand and for the hand to then do what the brain is telling it. Isn't that correct?
I can draw my pistol from the holster and fire a shot in less than a second.
Are you saying that Officer Dean's brain and nervous system and
Title of your
muscle
sex tape.
reactions react any differently than the person you testified for in 2018?
Well, I'm sure there are probably some minor differences because people, depending on their age, a number of other factors, their reaction times differ. My reaction times at 68 are going to be a lot slower than Dale's is here. So that can vary, if that answers your questions.
Well, again, you didn't do any studies on this other guy you testified for, did you?
How do you mean studies?
Well, you didn't do any neurological studies to test his reaction time, did you?
I'm not qualified to do neurological studies.
But yet you testified under oath, again, a second, a third, and a second and a half for the human brain to make that decision.
I mean, we know he shot in less time than that. So
Science that I've reviewed and researched.
Yeah.
And placing that science onto that event as it happened at that time, yes.
asked and answered.
So,
Irrelevant.
I got to give credit to the prosecutor, though. He's making this more interesting.
The defense attorney was asking questions that Officer Dean, the defendant, was still doing his investigation. Is that correct?
Yes.
Did you hear Officer Dean testify that he'd made up his mind that this was a burglary in progress whenever he first saw looked into those open doors of the residence on East Allen Avenue?
Well, he testified to a few different opinions on that.
Did you hear him say yesterday morning that he looked into those open doors on East Allen Avenue?
He said it looked like a burglary in progress.
Burglary in progress.
I also heard him say that it could have been a burglary in progress.
Did you hear him say yesterday morning / afternoon when he testified under oath that when he looked in those doors, he thought that it was a burglary in progress?
My recollection is
Among other responses, yes,
But he did say, you didn't hear him say that?
I believe so.
Okay. All right, so that would mean that the investigation's over, isn't that correct?
No, it wouldn't, because as I testified, he testified that there were several other responses there too. It could have been other things. He testified that he didn't know what he had at that time.
I'm not talking about what you believe is reasonable after looking at everything after it happened. I'm talking about what the defendant testified to under oath yesterday. I mean, are you calling the defendant a liar?
What I'm saying is, he testified.
he was clearly continuing the
Calling
investigation.
the defendant a liar?
No,
Yep.
not at all.
Okay, so if the jury remembered what he said about when he made up his mind, that would be what they need to remember. Is that correct?
Well, they would need to remember all his testimony, all the testimony that occurs here.
There
Good
you go.
answer.
He made up his mind. Isn't
Don't cherry pick,
they ignore
fucker.
what he said?
Oh, I didn't say that.
Okay, so that's important too, right?
And he also said other things.
Okay. So, again, you testified, I mean, him parking down the street, whatever.
The prosecutor's getting a little bit-
Yeah,
Fine.
Prosecutor sounds rattled.
Is it
Trying to rattle this guy,
guy.
it's not working. That's fucking unsettling.
To walk straight across diagonally and intersection.
Well, he did say the last time
Well,
I was involved in a
again,
shooting. He's
Conceal
been in more than one.
probably is not the good term here. It's to be less conspicuous. Because again, this isn't a SEAL operation. This is an Army Rangers here. They're trying to keep a lower profile in approaching this scene where they don't know quite what's going on.
Would you agree with me that walking straight diagonally across that intersection is the most non-conspicuous way across that?
No,
Can you pull that picture up for just a minute? That aerial?
Oh,
Sure.
oh, good. Nail
I
him
don't
on
know,
his
too.
own visual.
2 cop cars screaming down the street with lights on would probably be less conspicuous. Was that the answer he
Notice-
wants?
The house is set back from the mosque. When they crossed that intersection, they couldn't be seen by somebody in that house. The mosque blocks the house.
I understand that you're giving them the excuse for that now, but at the scene,
Oh, He's getting
what
wrecked.
the officers reasonably knew at the time, that wasn't the best way to cross that intersection, was it?
Your Honor, may I approach that?
Can use this laser pointer.
Oh,
Just shine it right in the prosecutor's eyes.
He wants to put a finger on the diagram to show.
Yeah.
thank you, Your Honor.
It's hilarious. Prosecutors digging holes, man.
Yep.
We're talking at night. If I remember correctly, they were, parked here or here?
The south side of the street, which would be the
So-
lower part of the intersection.
right here.
close to the bottom of the street.
Well, again, they're going to have to get there somehow. Now, as you can see, if you're drawing a line here,
Uh,
a lot of that is excluded from view of the house. So basically, when they're here, they're not going to be able to see the house. If they can't see the house can't see them.
Done.
They're going to have to get across there.
Nailed
The-
it.
The marked unit is already here.
Chaotic
So
Cross, he says, literally
it's a-
cock blocked by a
basically
law.
just a non-starter. Did they walk this way? Did they walk this way, then this way? Did they walk this way and across here? Basically, they got across the intersection and that was just fine.
I mean, you've been talking about, silent alarms have been talking about all week, open structure. Have you testified before that walking down the middle of the street for an officer is not the best idea? If that officer.
Oh, I don't think they walk down the middle of the street though.
His presence.
If the officer is attempting to conceal his presence, walking down the middle of the street is the best thing,
Is not the best thing.
is not the best thing. I would say so.
Okay, so concede that part.
Couldn't-
Well, walking down the middle of the street in view of the party you're worried about.
The officers.
Walking down the middle of the street isn't crossing a street.
You're aware that.
That's walking down the middle of a street, not walking through an intersection.
That's what I heard.
Would have been reasonable to expect an officer to notice 4 grown adults sitting across the street from a house that they're going to approach?
No.
No.
It depends on a number of things. It depends on lighting conditions. It depends on how much moonlight there is. It depends on what's going on there. Their attention is probably on this structure. Now, by the way, which house are
There you
we
go.
talking about?
The closest one?
This one right here. So they're coming
Look at
up from this
camera.
direction.
Come on, pan
If
over
there are
faster.
people here, is it possible that they saw them? Yes. But there are a number of factors which may make them more able or less able to observe those individuals.
Like the fucking stand of trees in the way, that might help.
Trained to be as observant as possible.
Yes.
Wouldn't you want any police officer you train
So they're supposed to see everything, like have 360-degree perfect vision.
to notice any other?
At
There's
night.
a line of trees running right there.
What
The
I
house is
want
still
them to do
set
is have a
farther
good-
back. Ah.
360 view.
In that 360.
If
view,
they
wouldn't
notice
you
the
want
people,
them
this
to
prosecutor would be
know
like,
other
well, you
people
took your eyes
standing
off the
around?
potential burglary
I
building?
would certainly
Yeah.
want them to make that effort, yes.
Okay. So now we get up to the front door of the home on East Allen, Yolanda's house. And you're perfectly fine with them standing in front of that front door.
They didn't stand in front of the front door.
You're perfectly fine with their presence for however short it was in front of that front door.
This is, I explained to the jury, the way in which they scanned the interior, given the nature of that call, they had to cross that threshold to get to the other side, to go around to the B side. The way they did it, again, giving what they had, was just fine.
And when you agree with me, have you?
Dismantled.
investigated burglary calls, is that correct?
Yes,
I mean, and, you know, in the olden days, TVs used to be one of the heaviest items of furniture in the house, isn't that correct?
absolutely.
But TVs aren't that way anymore, are they?
Depends on the
That's on
TV. Yeah.
You see the flat TV, Tatiana Jefferson's home.
I didn't see it in her home.
Man, I hung a 75-inch TV on my wall and I wanted to
I haven't
fucking
been inside
die.
the restroom.
Have you seen the crime scene photos?
Yes,
Did you see the crime scene photos?
I did.
And it was still right there on the stand where it would have been if someone was watching TV on the couch, isn't that correct?
Yes.
And wouldn't you expect an officer to notice that if they think there's a burglary going on, that the electronics have not been taken?
Well, they may not have been taken yet. They might be looking for other smaller objects. Grab the TV at the last thing.
Yes.
Well, think about it for just a minute. That's the largest, bulkiest item. When they start toting that out of the house, the neighbors are going to take notice, and that's when the cops might get called. That's probably gonna be the
Look
last
for
thing
loose
they'll take
cash.
out.
Look for
You're exactly
jewelry.
right. Do you think that's why Officer
guns.
Dean testified he caught the people that were doing the bad things?
You don't pick the TV up first and then search the rest of the
So, yeah,
house,
he testified that he
carrying the TV around.
really hadn't made many decisions on that.
No, he testified he made a lot of decisions. So is that what you're saying, that the TV still sitting there contributed to the defendant thinking that the burglars are still inside the house?
What I'm saying is it's really not a factor of whether they're there then or not. It just might be the fact that they hadn't got to the TV yet,
Because they're still in the house digging up other stuff, right?
possibly.
And I mean, and that's kind
Or
of
they got chased off.
what the defendant was saying yesterday, that these burglars could still be in the house. He's already making up his mind that the bad guys are in the house, correct?
No,
They could be.
Are you saying that's not what he said yesterday?
that's one of many things he said,
Okay, so he said that yesterday, correct?
among many other things, yes.
He said that yesterday, correct?
Among many other things, yes.
Another OODA loop? We're in time loop here now. Ooh,
Okay.
he's smirking at the prosecutor.
So we get to the second door, and you're fine with the way they fast clear that second door, correct?
Well, they didn't, that's not a fast clear. What you're doing is you're moving across the fatal funnel, and they did it just fine. They looked inside, they didn't see a threat, because again, at this point in time, they still don't know what they have. It could be something, it could be nothing. So the way in which they did it, given those circumstances, is just fine.
Nope, I mean, but who's guarding the front door at this point?
No one.
No one's guarding the front door.
No one's guarding the front
Right.
door.
Okay, so then they moved past a window right there on the side of the house. Do you realize that?
I don't believe there is a window on the side of the house.
On the side of the house?
I don't believe unless you want to show me.
Nice.
He means before the gate. The prosecutor means the window that was fired through. Because I don't believe there's a window between the door and the gate.
It just looks bad. The prosecutor's having to take so much time to find the picture that he is sure is there.
Yeah, where's the window?
That's not the picture.
Where's the
he
window?
That was witness, Sean? Oh, right there, Stakes Exhibit 52.
Oh, right, that one.
Okay.
What's that over the kettle grill?
Yep, that's a window.
So you were mistaken when you said there weren't any windows on the side of the house. Is that correct?
That's correct.
All right.
Oh,
So-
but they didn't go by
Okay.
that window. They went around the cars.
Yes.
Did they attempt to look in that window?
I don't know. Did you
I
ask
don't believe
him?
that they did.
So that window's, are you fine? I mean, you said they had to check the windows in the back. Are you fine with skipping that window in Stakes Exhibit 52?
They literally might not have seen it.
Okay, so they didn't see the people outside. They didn't see the window right there in Stakes Exhibit 52. What's that a reflection of in Stakes Exhibit 52? That in the window.
In my experience, I guess that was the flash of the camera, but it could be anything.
he's,
So
he's trying to say it's the flashlight.
Do you remember it in the body cam?
So
That was the witness, Sean?
am I wrong in thinking that that window's completely obscured by blinds?
One.
That's what it looks like to me.
Second mark.
Plus, there's objects right at the base of the window. You
That
can't
same
get
defendant's body
right up
cam
against it.
right at that window, that same one.
And as you said, they went around the car.
With that, if it's right in the middle of Stakes Exhibit 1, and I can pull this up on the big screen, maybe we should do that.
Okay, so they checked this window.
So you saw the body cam come around the corner of Stakes Exhibit 1, and what was right in front of the body cam when the defendant came around the corner?
looks as though there's a window and it looks like there's a blind covering the window.
Yeah.
Yeah, exactly.
But are you gonna say that maybe they missed that window, they didn't see that window? That's
What?
Still your answer?
Given those light conditions, I would say they should have seen that window.
Okay. So
But
if they saw that
it's
window, then you would expect them to
covered
give
by
that same attention to that window that the defendant gave to the window in the backyard. Isn't that correct?
no.
Should have.
But they didn't. did
But
they?
why?
Well, if it's fully covered by a blind,
And that?
Fully covered with blinds.
what I'm saying is they need to give the amount of attention to each one of these that requires. If this one is covered by a blind, you can check for entry, but tool marks, things of this nature, by looking at it. You can get up a little closer, but you can look at it. You don't have to get right up on it.
They didn't check that window, did they?
I don't know about that. Because remember what Mr. Frederick said. The camera's pointed one way, but the officer can be looking one way or the other way.
Did they check that window? Did the defendant check that window with the same
Answer.
intensity they
Nope.
checked the window in the backyard?
From
No.
this, we can't tell.
But
I'm saying
no,
did
of
the window
course
watch
not.
them?
It's
No.
fucking covered. Why would
From
they?
what you've got right there, what I'm saying is, we don't know how long the officers took looking at the window.
What do you mean you don't know? It's right there. It's on video.
Not
Well,
his
The
eyes.
video's not correct.
I'm not saying that.
Should they have checked that window? Yes or no?
I'm not saying they didn't check the window.
Okay.
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 They might have checked the window, but you don't know for sure.
It's possible that they did. It's possible they didn't.
I wasn't there.
Why didn't you ask the
Don't
cop
know
when you had him on the
by
stand?
watching the video whether they did or didn't.
Well, let's watch the video
Okay.
again.
I mean, presumably he sees the window covered by blinds.
You went robot voice.
Oh,
you
sorry.
stop?
I said presumably he sees the window covered by blinds.
If you'll
Like-
notice, when he walked by the window, the camera moved slightly to the left. That could very well indicate that he looked at the window. He was within what appeared to be a couple of feet of it. As Mr. Mr. Fredericks testified, it could be look closer than it actually is, be nearer than it actually is.
Actually,
So-
are they farther away?
No, it's closer.
Objects are closer than they appear?
Yes.
Yeah, okay.
So it's
That's why I said
entirely,
They were farther away. Yeah.
it's entirely possible that that camera movement that we just saw was Officer Dean looking at the window, seeing it was covered with a blind, so he's not going to gain much by going over there and trying to look into it. But he can look at tool marks, things of this nature, and they moved on. They had an entire structure to cover.
You're saying he probably checked that window for tool marks?
From what I see from that video, it's entirely possible.
And if one of your trainees did this down at Harris County, you would have gave them a passing grade for checking that window for tool marks? If you
Well-
saw this video.
Again, I'm not grading my folks.
Why
This
does he
is
have
real
to-
life.
Why does he
This
have
is
to
real life good police
test
work
for
that you've seen.
tool marks on the
So
window?
far, this has been good police work, yes.
There you go.
Can you tell me exactly, I mean, you reviewed the defendant's training manuals, haven't you?
How do you mean training manuals?
What he was taught in the police academy, is that correct?
The course descriptions, yes.
And what all have you reviewed for this case?
A number of things. Certainly the video, the investigative reports, investigative photos, pretty much everything again that I received.
Is there anything specific in what you reviewed that where Fort Worth PD instructs the officers not to not to verbally announce their presence on open structure calls.
Is it in writing? No.
Is there anything?
But of course, the state could have called an instructor from the academy if that was incorrect, if that was not the
Yeah.
policy.
Any handbook, any general order, any instructions that were Fort Worth PD tells its officers not to verbally identify themselves at an open structure call.
I would say that there is.
Where is it?
It's in the general approach to crime scenes.
Where'd you find that?
It's scattered throughout Fort Worth PD policy. They're basically stating, and you can check several of them, that when you're approaching a possible crime scene, use caution.
Use caution,
Yes.
but it doesn't say not to announce yourself.
Well, when you're announcing yourself, you're not using caution.
Again, is it anywhere in writing where you answered this question earlier. Is it anywhere in writing specifically that states that Fort Worth officers should not or shall not verbally identify themselves when on an open structure call?
On an open structure call, in that verbiage, no. However, it is strongly intimated through several other parts of the Fort Worth PD general orders to be cautious in approaching crime scenes.
But there's
To be
nothing,
careful. Excuse me, I'm not done with my answer.
Oh, yeah.
I'll decide that,
Thank you.
Mr. Smith.
there's nothing in writing that says don't verbally identify yourself at an open structure call, is there?
But it's strongly suggested in other parts of the manual.
There's nothing in writing that says.
No, it's in writing in the
Don't
manual.
Verbally identify yourself on an open instruction call. Correct. Is that right?
In those words for that particular call, no.
It's the exact same answer he gave in the Daubert hearing.
So after you say that they have sufficiently investigated this window, where did the officers go next?
They check the vehicles.
And you said they did a great job checking those vehicles.
Given those circumstances, yes, it was adequate.
So what about whenever he turned his flashlight on? Isn't that isn't that telling everybody where he is? He turned his flashlight on?
No.
It could be.
Just say
Just a
no.
minute ago, you were saying, you told me you weren't done, that, hey, they gotta use caution.
Mhm.
Don't let anybody know you're there, but this time, whenever he shines his flashlight, that's perfectly okay.
No, you're misconstruing my words. I said they needed to use caution. In caution, you're making decisions based on what you're seeing, based on the overall circumstances. They needed to look inside those cars. They briefly illuminated the cars to check inside them for a victim or for a suspect. It's a balancing of risk.
So you're saying that it wouldn't have been reasonable for those officers to knock on that front door when they first got to East Allen Avenue?
No.
You're saying it would have been reasonable to open that screen door and check and see if there were crime marks for the inside of the screen door?
No.
Are you saying it would have been reasonable to open the screen door and ask if anybody's home inside?
Not at that point, no.
Are you saying it would not have been reasonable to knock on that side door?
No.
Are you saying it would not have been reasonable to call back to dispatch and ask about the cars that were in the driveway, since the call text gave details about this one?
Well, it's a great point. They could have done that. The problem of it is that takes time. It takes time to get on the radio because you have other units using that same frequency, so you have to wait. Then the dispatcher has to run those tags, takes a few minutes.
This guy would have
Then the
gone.
dispatcher, while she's handling other calls, has to relay that information back to the officers, so it's taking time.
These officers getting paid by the investigation or something? Why is time?
Oh, gee.
They want to do a good
Oh my
job.
God, are you
They
kidding?
want to do a good thorough job. They want to make through this, and they want to get through this, and they want to find out what's going on. So again, it's a balance. There's a lot of things you can do. What is the importance
This guy would have had a field day if they got on their radio and started
calling.
calling people in. Wasn't that announcing?
Already checked to make sure that there isn't a victim, there isn't a suspect inside those vehicles. Now you move on with the Fort Worth policy of checking the exterior of the structure.
The same Fort Worth policy that says, we've already gone over, the same one that also says, all main exit ways should be guarded so as to prevent the escape of any offender.
Should.
Good answer.
Should.
Should. Not must.
All main exit ways should be.
Not shall.
So that's not that important to you.
Oh, I didn't say that.
I mean, when they went over these cars, is the front door wide open? Is it under guard?
Not to my knowledge, no.
Is the side door under guard?
They're in that vicinity.
Okay. But it would have been reasonable if they decided to call dispatch to ask about the cars.
In my experience, I'd say it's a lower priority.
Okay. Would it have been reasonable to call dispatch to ask to get more information from the caller?
For what purpose?
To find out more information. Are these in fact the cars? Do
Why?
you know, the caller had said, do you know, the owner is usually home at this time. Do you know if the owner is actually home at this time? Would that have been good information to have?
Isn't that on dispatch?
At that point in time, they're already on the scene, so it would have been better that they had turned their attention to actually checking that structure, as Fort Worth policy states.
Was the house gonna get up and run away?
No, but somebody inside it could have.
What door were they gonna run out of?
Don't have to run out of the door.
So, you're saying you're still building their investigation, but you're also saying they have to work quickly because the bad guy can still be in the house. Is that right?
What I'm saying is they don't know quite what they have, and they're trying to run it to ground. They're trying to gain information.
That's my point. So wouldn't it have been a good idea to contact the person that called the police in the first place to get some more information?
That individual called the police and said there was an open door and said the cars are there, those are their cars, but they never leave their door open like it is now. And I'm paraphrasing here. So they already had that information. Now they're on the scene. Now it's up to them to do the checking.
And also the caller had stated, and they had information that the owner is usually home at that time. Isn't that correct?
I believe so, yes.
That doesn't mean it's not a burglary.
Getting all that information is fine, but talking to the neighbor that called the police, we don't have time. These officers didn't have time to do that. Is that your testimony, Jay?
No, it's not.
So it would have been reasonable for them to have dispatch reach out to that caller?
Well, you use the term reasonable, and that's not the proper term here. The thing about it is how best to go about answering this call.
What's the
Checking
priority?
out. What I'm saying is.
There's
if you
100
don't
reasonable
qualify
things.
All their options, calling
Right.
the reporting back at that point in time with the officers on the scene would have been a lower priority. Now, let's take an example of let's say a robbery in progress. Somebody calls in and says, I'm watching, this guy's got a gun on this cashier. You keep that individual on the line, and then you keep relaying to the responding units what that individual is seeing. We didn't have that here.
So, because this isn't just an important enough call, right?
I didn't say that,
I mean, you're kind of going back and forth.
no.
Nope.
No.
So you want them, how about this?
You get lost there,
Would the defendant
prosecutor?
be fired if he had knocked on that front door?
Probably not, no.
Would the defendant gotten in trouble?
This is what happens when a bully finds out he can't intimidate
Yes.
someone.
How?
If he relayed that to his sergeant or his other officers, they probably would have looked at him and said, Rookie,
hell were you
what
doing?"
did you do? Don't do that. You make sure that you find out what's going on there before you announce that the police are there. Because
You're really going to testify that a Fort Worth officer would have gotten in trouble by knocking on a citizen's front door?
in this case, in a same or similar circumstance to this case, given the nature of this call, his peers and his sergeant would have taken him to task, yes.
Do you know that he's announced himself on other open structure calls?
It's entirely possible, given the nature of that particular call.
So what you're saying is this is just all in a vacuum about what happened on East Allen Avenue on the Grove.
No, I'm not saying that.
No, it's the opposite of a vacuum.
And then if there are other changes out there, they don't apply because of this particular call on that night.
Not saying that at all.
Okay.
That was a
So-
shitty summary of what's happened so far, sir.
Now, they've checked the garage, they checked the cars in the driveway. What about the stuff that's lined up over there? Did you hear the testimony that Officer Darch and Officer Dean believed that stuff was being stacked up to take away?
Well, I didn't hear the testimony of Officer Darch,
Hey, Jeff,
but
Alvin
I did hear
Caribbean
the
Cask.
testimony of Officer Dean, and it is possible. Burglars do that. They'll go through someplace, they'll take the valuables, take whatever they're there for, and they'll stack them in one spot. That way, when they're done with the burglary, they bring up the vehicle. It's a lot quicker to load all the stuff into the car and get away.
You ever heard of confirmation bias?
Yes,
What is that?
confirmation bias is when you have a
you?
pre-existing thought and you find some fact or something that supports that. You're
Was somebody
basically-
charged with the crime of
rather than
confirmation bias here?
Analysis of what you actually have.
Let's get it on,
you're
Nick.
Wanting to confirm what you already think something is.
Nice.
So you've already
Literally
said
what
that
this
you
prosecutor is
thought
doing is
that
confirmation bias.
Just after looking in those two front doors, he thought it was a burglary in progress. That's-
I've had this for 2 years. I'm just opening it just for you.
That's one of the things he
Ooh.
said could be, yes.
Wow.
And then, so now he sees this, he and Darch both say they see this lawn furniture in the driveway, and that also contributes to their thinking that this is a burglary in progress. Did you hear that testimony as well?
Was it lawn
Like that
furniture or
glug,
was it-
glug, glug,
was it
glug.
Weed whacker or more?
I'm sorry, lawn
Here,
equipment.
sir.
Cheers.
Didn't you hear that testimony as well?
I did.
So in that little confirmation bias there, he's made his decision that this is a burglary in progress, and then now he's seeing this lawn equipment, and he's thinking, well, the bad guys are stacking stuff up.
What it is he's getting more information. The problem of it is the information he's getting, it could be one thing, it could be another thing.
But if he told you that's what he thought, we should listen to what he said. Isn't that correct?
Well, again, he testified a little all over the board on that.
But he said that he thought that stuff was stacked up by the bad guys committing the burglary in progress. You heard that, didn't you?
He said it could have been, yes.
And isn't that exactly what confirmation bias is? He looked through those front doors, thought the burglary was in progress, and now he's seeing this lawn equipment, and now it's, okay, I've confirmed it, yes, it is.
Not everything is confirmation bias. If more information is consistent with a hypothesis, that's just more information consistent with the hypothesis.
Et cetera. He's testified to that.
But he said that though yesterday, isn't that correct?
Among other testimony to other things.
But he said that yesterday, isn't that correct?
Among other testimony to other things, yes.
Yes or no? He said that yesterday, didn't he?
He did, among
Okay.
other
Thank
things.
you, sir. Now,
I really don't want you to say that other things. Like he just
You're
forecasts what he doesn't want the
that
jury to hear.
lawn
It's dumb.
equipment is being stacked up to take. Would you agree with me that people don't keep lawnmowers in their homes?
You've never been to Channelview. I haven't seen it myself.
You haven't seen it. So you would agree with me that people don't normally keep lawnmowers in their homes.
Normally, no.
People don't normally keep weed whackers in their homes.
Not normally, no.
Where do people normally keep a lawnmower?
This is speculative.
Garage, side of the house,
Where do people normally keep a weed eater?
garage, side of the house, shed.
Okay, so if you're thinking.
Unless the neighbors steal it all the time, so they keep it in their house.
Should your next logical step be check out the garage?
If at that point in time, that is your final determination, that you have enough information to go, this is a burglary in progress. Then, as the order states, you call backup units, you call for a canine, you lock the place down. but he hadn't reached that conclusion because it could have been that, or it could have been somebody that just doesn't really take good care of their equipment.
I want you to go back to that. What do the general orders say about a burglary in progress? What should the officers do?
Call for backup, call for canine.
The minute they think a burglary in progress is happening?
The minute they come to that conclusion, he hadn't come to that conclusion yet.
If he testified he came to that conclusion, should the jury believe that testimony?
They should take into account all of his testimony, not just one factoid.
If he believed there's a burglary in progress, the minute he made that decision, what did the general order say he should do?
He hadn't made that decision.
If he made the decision that this was a burglary in progress, what do the Fort Worth Police Department general orders say he should do?
Okay, are you giving me a hypothet?
Sure,
What?
hypothetical.
Okay.
Okay.
Hypothetically, if Officer Dean would have come to the conclusion that I have a burglary in progress here, and it's highly likely there's a burglar still in there, then it's Fort Worth policy that they lock the scene down, they call for backup, they call for a canine.
Can I approach the witness again, Your Honor?
Yes, sir.
I mean, the counter argument, of course, is the very fact that he didn't call for backup yet tells you he hadn't yet concluded for certain it was a burglary.
Recognize that.
Right.
I do.
And it says, if the officers have any reason to believe that a burglar may be still inside the building, they shall keep the exits and under surveillance. And
But they
call
had
for-
reason to believe that from the phone call.
So it's, if the officer has any reason to believe that the bad guy's still inside, that's what they should do. Isn't that correct?
So every open structure call, it's supposed to be a backup call.
And that's a shall keep those exits under surveillance, correct?
If you reach that conclusion. But look at the sentence just above it.
If officers find signs of forced entry or have any reason to believe.
Mhm.
Did you hear him say that he thought that the screen yesterday on that side door had signs of a forced entry?
It could have been forced entry.
So if he believed that was forced entry, then what he should have done, he shall keep all exits under surveillance. Isn't that correct?
If that's his final conclusion. That wasn't his final conclusion.
Did you hear him yesterday that he thought that there were signs of forced entry on that screen door on what you've already called the B side of the building?
That was one of his many responses, yes.
And then you, again, would agree with me that the general orders say that you shall, if you believe that you shall keep all exits under surveillance.
If that's your final determination on scene, yes.
Okay. Let's get back to the garage then. How did they inspect the garage?
Just fine.
Just a walk over looking at it, just a quick walk by, you're okay with that?
Yes. Under those circumstances on this scene, yes.
Not a good idea to check and see if the garage door opens up real quick to see if it's easy to get into, maybe for the
No.
burglars to get the stuff that's stacked up on the driveway?
Not necessarily, no.
You want him to
Not
open a
necessarily,
garage
maybe
with
see
his
if that
back to
door
the
fits
fucking
in a
house?
little bit.
Well, they can do that with a visual.
Not to see maybe if, and do you think they got close enough to tell if that door's been jimmied?
You walk right past it.
Was it broad daylight then?
It was not.
Okay.
He has a
Do you
camera
think
light.
that, would might have been a good idea, just maybe even to shove on that door to see if the door even worked anymore.
When you're shoving on the door, you're making noise.
So that would have been bad to make noise.
Well, what I'm saying is, it's a consideration.
Zoltar asked
What
why
would shoving
why is the
this way on
defense allowing
garage
any of
door
this?
accomplish?
because his prosecutor's
Oh,
burying his
I'm
case.
there. Maybe I would have shoved on this way of the garage door and it just came wide open and I see that the garage is a bunch of stuff missing and I maybe confirmed.
How would you know there's stuff missing? You're not familiar with the garage?
It is being stolen.
It
Is
was,
that not good police work?
it was a roll-up door.
Talking about the door that's right next to the roll-up door.
I thought we were talking about the roll-up door because you were
I'm sorry,
talking
I
about
moved
that.
on. That's my fault for not being clear then.
Ah.
I'm
Mhm.
What about that decider?
How would you grade yourself on that
Can
line
you
of
repeat your question
questioning?
there?
Maybe just shove on it and see if it just comes open. That been a good idea?
That's what you'd say to the stripper when she's.
They're checking for signs of forced entry.
Can't you just shove on it, see if it comes open?
And to me, that's a little bit more important than seeing whether or not they bothered to lock or latch the door.
Have you ever seen someone kick in a door and then push it like it's still closed?
Yes,
And it looks closed if you're just walking by it, isn't that correct?
no, usually there's deformation to the lock, the knob. There could be deformation to the strike plate.
Could be.
Yes, in my experience, there is.
And did you ever just kind of shove on that door to see if it just came open? Or did you just look at all that and decide it being kicked open?
Again, it depends on the call. I mean, are you talking about my experience?
Sure, yeah, your experience.
Yeah, I really can't recall. The situation, honestly, where that's happened to me.
Okay. We'll move on from the garage then.
Yeah.
At that area that's in front of the gate and how it's configured with the house on one side and the garage on the other?
Yes,
You heard me talk about that yesterday, isn't that correct?
I did.
Once they're both at that gate, is there anyone covering those two front doors?
Nope,
No one's covering the two main exits that they've seen?
No.
No one knows if people are coming in and out of that house at that point?
not at that point, no.
And no one knows if anyone's coming to that house that may be armed, is that correct?
That's what now?
That's armed,
What about
armed
the,
with weapons.
I didn't hear the first part. I don't hear well, I'm sorry.
That's okay. No one knows. They didn't know if somebody could have been coming out of that house with a weapon in hand, isn't that correct?
Not if they were exiting the front, no.
Is that a good place for officers to be in that particular situation?
Given the circumstances of this call, everything, the totality surrounding this call, yes, that was a good call.
Good police work, if they're back there with their six totally uncovered, with a house possibly full of bad guys, with no one on the front door. That's your testimony.
Well, but that's not what we've seen here. One, they've already checked the living room area. That's not full of bad guys. Also, you say their six wasn't covered. Yes, it was. They're covering both their sixes.
Are you telling me somebody couldn't just sneak around that corner if they were both up there at that gate?
Well, their heads can be on a swivel, and you're constantly looking around you.
Can't you disagree with me? It would have been a good idea to put eyes on those front two doors.
In this case, given two officers, they had a choice to make. I believe that they made the right choice. They stayed
Thank
together.
you. Fucking finally.
They had another choice, didn't they?
What was that?
Call for backup?
Not on that type of call, no.
Thank you.
You want to look at the general orders again?
Sure.
Is there anything, are you gonna say there's something in the general orders under silent alarm that they're not allowed to call for backup?
Oh, I didn't say that.
I love that answer that he keeps delivering
Yeah.
it the exact same. Oh, I didn't say that. It's
part
like
we
Reagan's, there you go
discussed.
again.
Everyone's witness again?
Yes, sir.
Perfect.
Section D,
This guy is
Yes.
worth every penny.
If you find signs of forced entry or of reason to believe,
Mhm.
then they shall keep all exits under surveillance and call for assistance. Isn't
Yes.
that correct?
That's correct.
there's nothing in the general orders about saying you are not allowed to ask for assistance or backup on an open structure.
No, not at all.
Okay. So you're saying that they had to get in that backyard and check that window, is that correct? Or check what's in that backyard for the structure?
Well, they had to check what's in the backyard so they could continue checking the structure for forced entry.
They had an ultimate right to get in that backyard? Are you telling that jury that?
When you say they had a right, what do you mean?
I mean that can Fort Worth PD go wherever they want on a citizen?
No.
Based on their whim?
Based on anything, you tell me.
Based on
Well, if
anything,
they have a
yes.
warrant, absolutely. If
But
they
if they
have,
don't have a warrant,
if they have exigent circumstances, yes, they can.
okay. What are exigent circumstances?
Objection
Well,
calls
no.
for a legal conclusion.
And if I stray too far here, please tell me. Fourth Amendment requires that,
You're going to let this
officers
expert give
involved in
this
warrant
police
for
expert give a
warrant
class
search.
on
There are
exigent
7
circumstances to the jury in
exemptions
favor
officers
of
are taught to the
police?
warrant requirement.
Why would you fucking
One
ask
of them
this? This is
what's called
stupid.
Exigent circumstances. In other words, if I answer a call of a man screaming in his apartment,
This
get
might be the
there,
biggest
the door's
tactical
locked, but I
mistake
can
the
hear you.
prosecutors made so far.
Says, help me, help me, help me. I don't need to go get a warrant in order to forcibly enter your apartment because I'm there not as an evidentiary search, but to help you out, to get you medical aid.
Oh, I can't wait to talk about this on a break.
What's the phrase reasonable expectation of privacy mean to you?
As a layperson, not being a lawyer, it basically means that we have a reasonable expectation. We do not expect the government to inject itself into our affairs.
Without good reason.
Probable cause.
So, do people have a reasonable expectation of privacy inside their homes?
Are they charging this cop with trespass?
It's in backyard.
Yes.
So you're saying there was exigent circumstances at that
It's
time?
reasonable expectation. It's not absolute expectation.
They were answering a call for service. There was a neighbor that was very worried about them, and they were checking. They weren't doing an evidentiary search. They were there to check the circumstances behind that open door.
This guy's going to leave the courthouse in his
Exigent
F-14.
circumstances.
But you agree there's no exigent circumstances here when they're opening that gate?
No, there were. The call.
No, I don't agree that.
What's the exigency? What is it?
The call of the neighbor.
Yeah.
The call of the neighbor that we are not following up with, isn't that correct?
What?
We are following up. That's why the officers are there.
You said you would not expect these officers to have to reach out to that neighbor again, but now we're blaming the neighbor for the.
No, why would the
exigency of
officers
the
reach back to a
circumstances
neighbor
these
after a
officers
dispatch
in the
order?
backyard? Is that correct?
Well, number one, I'm not blaming the neighbor for anything. We've received a call for service from the neighbor. We've got what we need from him. Now we've got the officers on the scene answering that call for service.
If that gate was locked, would you expect those officers to just jump over it?
No.
What would you have expected them to do?
See if they could find a different vantage point. Maybe go around by the mosque or around by there's an alley behind there to see if they can look.
But not hop the fence, right?
I would not have done that, no.
Again, it's
Relevance?
reasonableness.
So because these people didn't lock their gate, it was okay for Fort Worth police to be in their backyard?
Yes. it was.
Yes.
So would
That's
you
literally
tell-
part
so
of
would
the
you say
analysis.
for Everybody in Fort Worth to start locking their gates? So
Yes.
Fort Worth police can't get in their backyards?
Well, I tell people in Fort Worth and pretty much anywhere else to lock your gates. That way, the bad guys, it gives them a little more trouble getting in. So it's a good idea to lock your gate, not to keep the cops out, to keep the bad guys and gals out.
Bad gals.
Prosecutor,
See
Yes.
that? Bad gals.
If you had a locked gate, you would have
this
expected.
prosecutor is flushing all the work he did yesterday right down the shitter.
Yeah.
Locked the perfectly okay with it going back there.
Yes.
If only the police officer, the defendant, had given these answers.
By the way, if
You
you're
okay with people having firearms in their home?
if all your
Provided
blinds
they're
are
not
up
a
and your doors are
convicted
open, a
felon,
cop
yes,
looking in your house is
absolutely.
much more reasonable than if they're closed.
Live down in Huntsville, I mean, this is Texas, right?
This is Texas, but I don't live in Huntsville.
Well, where you, I'm sorry, but you have to tell the city if you want to. You work down in Huntsville.
I do.
Yeah.
He's from Houston, I think. Didn't he say that?
I mean, isn't it perfectly reasonable whenever you hear something in your backyard and you're a citizen,
Relevance. What's reasonable for the victim here is not relevant.
gun, take it with you?
Court reporter's not amused.
overnight?
I'm going to check it out, and I'm going to have a firearm with me. Yes.
Especially if you see a bunch of people back there with flashlights?
Yes.
Because you wouldn't expect, because we have that reasonable expectation of privacy in our backyard, isn't that correct?
Well, the reasonable expectation of privacy is from the government, not necessarily bad guys.
That's what I'm saying. You wouldn't expect the government to be back there, would you?
Not necessarily.
You wouldn't expect the government to be back there, would you?
Certainly could be. I've been back there.
I've been back there.
It is perfectly reasonable for you to hear noises in your back, for a person to hear noises in the backyard.
This is objectionable on relevance grounds.
See somebody back there with flashlights and to go check out the backyard window with the firearm in their hand.
Yes.
So you heard Officer Dean testify yesterday. He didn't really know where Officer Darch was whenever they entered that, whenever he was looking at that window, correct?
He didn't know her specific location. That's correct.
He didn't know if she was right behind him or a little bit further back, did he?
That's correct.
Okay. Did you heard Mr. Fredericks testify yesterday, didn't you?
I did.
Did you hear him testify about how long it took Officer Dean, the defendant, to begin his commands, the beginning of his commands to shooting the firearm on State's Exhibit 1 or Defense Exhibit 40?
I did.
And what did he say?
I'd like to, before I answer that, I'd like to refresh my memory with the audio of the spectral analysis.
Sure. That is Defendant's Exhibit 44. I'll bring it to you.
Thank you.
I'm sorry, Your Honor. I should ask for a broke.
You're fine.
Yeah, he's mad.
Yeah,
he's
he's
flustered.
Okay, Officer Dean, the body cam video, the audio states that at 15.893, and as we heard yesterday, he starts to enunciate the P in put your hands up.
And how long between first verbalizing that P and the shot being fired?
He's got to do math. They said there'd be no math.
JW65 says Hellcat. You can find several in SoCal. They're 90 to 100K. My local dealer in 91320 is 4 of them. Yeah, I'm looking for a 2023 is the main thing because I'm a snob who likes the newest, best, shiniest bell. But I might consider a 2022. I've seen several links to those, but
Just over half a second.
that's for later.
0.6 of a second?
No, just over half a
It's
second.
over half. So if we were to use your other sworn testimony that says that it takes
He's back to this.
a second, a third, and a second and a half for the person to make a decision and then to act on it,
Mhm.
the defendant had already decided to fire before he verbalized those commands. Isn't that correct?
No.
That would be incorrect.
If we were to use your prior testimony, that it takes a second and a third to a second and a half to make the decision and then act on it for that to happen. And that would mean that he had made that decision a second and a third to a second and a half before he pulled the trigger. Isn't that correct? If we're using your sworn testimony from the other case, which you say doesn't apply, isn't that correct?
Well, again, that's for the fact circumstances in that case. This is a different fact circumstance.
Wouldn't you agree with me that if we take your sworn testimony from that other case, that it takes a second and a third to a second and a half for the brain to make the decision and the finger to pull the trigger, that's a lot longer than the over half a second that you just calculated. Isn't that correct?
That's correct, but that's for that scenario. This is a different scenario.
That was for that officer who was pulling the trigger. Is that correct?
In that fact circumstance,
Not for this officer pulling the trigger.
in this fact circumstance, that's correct.
So the laws of physics have changed.
No, not at all. The facts surrounding the event have changed. It's as I discussed in the Blair study. It took the officers with the weapon out pointed at the research Confederate. It
Right.
took the officer approximately I want to say it was 0.36 seconds, 0.39 seconds to fire when they first saw the suspect coming up with a weapon.
You were testifying about this other officer and why he kept shooting. And you said that officer kept shooting because it took a second, a third, to a second and a half. for
In those
making the-
circumstances. Again, asked and answered.
In that case, yes.
And then here we have Officer Dean, so a second and third to a second and a half before he pulls the trigger would be before the defendant made any verbal commands. Isn't that correct?
No,
When did the
Told him.
you said it was less than half, it was just over half a second before he pulled the trigger that he started the verbal commands. Isn't
A
that
little
correct?
more than half a second.
So, a second and a third, we'll go with the minimum, is more than just over a half a second. Isn't that right?
well, a second and a third is more than a half a second. That is correct.
Second and third is more than half of a second.
Give it up, prosecutor.
You know, that moment, Ron?
Yes.
Yeah,
Poor reporter
take a moment.
hates her life.
I was gonna say, I don't like your testimony.
How long were you a detective, Dr. Coombs?
I was never a detective.
How long were you an investigator?
I was never an investigator.
How long were you an officer?
Are you talking, how long was I a deputy
Deputy.
with the Harris County Sheriff's Office?
Yes, sir.
I held the deputy rank for 3 years.
3 years. And what after that?
I was a sergeant for slightly less than 3 years.
Did you ever investigate any crimes down there in Harris County?
Yeah,
Yes.
tons of them.
Did you ever testify for the prosecutors down there in Harris County to try and convict any of these criminals that you investigated?
No, I testified as to the facts as I believe them to be.
Oh, nice
So I'm saying
answer.
You tested, the state called you, Harris County DA's office, right?
Yes,
And then you talked about your investigation.
Trying to go towards
Is
bias
that
towards
right?
cops with this guy.
I answered the questions I was asked, yes.
And all those times, did you ever, I mean, it's important, isn't it, whenever, as an officer and investigator, to collect a lot of facts, isn't that correct?
Yes,
Isn't it also important that we also look at what a defendant or suspect does right after committing an offense, isn't that correct?
it can be.
I mean, hiding a gun, if a guy commits a murder and then immediately hides the gun, that would be important evidence, isn't that correct?
It's another fact in the case, yes.
If the person runs off right after they shoot somebody, that could be important information, isn't that correct?
Could be, yes.
Did you ever go testify for any of those defendants about any of these studies that would give them an excuse for their behavior after their crimes?
Well, one, I'm not sure a crime has been committed here. So I don't understand the question.
That's fine, Your Honor. If I notice.
Read the rep.
Ooh.
Object to the last statement of the counsel as a sidebar.
Let's move on.
That was not the way he thought it would go.
No question.
May Dr. Coons be excused subject.
Oh, no redirect even.
Yeah.
That prosecutor got fucking destroyed by this guy.
Yep.
Talking trash and truths over on Rumble says 3K watching here, less than 400 plusies. Come on, guys, support the channel. Pound that plusie.
Okay, hang on.
If you're on Rumble, please hit that plus button. Let's kick it up the chain. By the way, tonight will be one of those Rumble exclusive shows. So if you're on YouTube, you can start watching the show on YouTube. However, it will convert over to Rumble after about an hour.
Okay,
The defense
Defense
rest.
rest?
we went to get your lunch. It's not here yet, but I'm gonna let y'all kind of relax a little bit, okay? So, see you in a little bit.
Good place to rest. I mean, that guy just closed out the whole case.
Wow.
Yeah, that was strong. Strong ending. Now let's see how they do on close. The opening for the state was very emotional and very little substance, very little law, very little evidence, very perfunctory, really. And the opening for the defense was very soundly based on law and evidence, so much more substantive. So we'll have to see what happens on the closing. I expect the closing to be emotive and dependent mostly on the defendant's unfortunate cross.
Yeah. Yeah, that's going to be the biggest, because that's where all of the damage was done. This guy came in. Here's what you never want. You never want to bring in a witness to repair the damage that your client did to themselves. This guy did a pretty good job of it. And that's going to be the tempering agent in closing arguments if they focus heavily on the defendant's screw ups, frankly. I mean, and they should. They absolutely should. And he's going to have to say, you know, they didn't even ask him how much he was paid or anything like that, but they paid this expert to come in and tell you
They
everything
forgot.
you needed to hear.
They were supposed to ask that at the end, and they forgot. He was so flustered, he forgot. That's what happened.
So it's like, it's they brought this guy in to come in because their client admitted to doing bad police work the entire time. Here, bad police work. Now, of course, this guy is going to say he did good police work because that's his job. But do we care about what someone else says about police work, or do we care about what the person who shot someone and killed them thinks about their own work? If he thinks this about his own work, then his shoddy police work led to this person's death unreasonably. He acted in a way that was not justifiable, and is not justifiable by the own actions that he created that generated this unsafe environment. And he acted contrary to the safety of a citizen, and he killed them. And we punish people for killing people, even if it's a police officer in the conduct of his duties. You know, you start going down those lines, and again, it's going to be tempered by this, but I think, you know, you hit the guy on his own testimony. That's what you hang him on.
Well, that's all you
the
have.
risk, of course.
Yeah.
They don't have
that's
a
all
good
you
set
have.
of law. They don't have facts
And-
that apply to law here.
And the defense should counter that by saying, look, even if you think he didn't clear the fatal funnel in the ideal way, that's not why this victim died. Even if you think he should have checked the garage, that's not why this victim died. None of that. He used his flashlight. That's not why this victim died. None of that. This victim died because this officer saw her point a gun at him, and he defended himself.
Exactly. And that's what the defense, have to focus on. They have to focus on the moment. It's like, look, all of that stuff, you've got one guy, you know, who's filled with regret and emotion because he's a police officer. He's there to protect people. And what he ended up having to do was defend himself, and that ended up with someone dead. And no officer on earth wants to go through this. You can see how it tore him up on his testimony. I mean, you could see the emotion. It was broadcast all over his face. He broke down while talking about it. It's hard for him to deal with. But all of those regrets, all of that second guessing, that's all hindsight. And in the moment is what you're called to answer the question on here, jury. And what you've got is someone who's testified that when he looked in the window of a house, what he saw was a gun pointing right back at him while he was in the lawful commission of his duties, answering a call in the way that he was ordered to answer.
Yeah. I noticed they didn't charge the officer with trespass, right?
Right.
He was allowed to be there.
It's like,
And apparently 50% of the chat can't wrap their minds around that.
I know.
They're still on the trespassing thing.
does he regret the decisions that led up to this? Of course he does. But those decisions can't be unmade. What happens at the moment of the shooting is what the jury is called to answer, and the facts around this case are clear. This officer responded to a deadly threat with deadly force. That is exactly what he's trained to do. That is exactly what we would expect a regular citizen to do. And frankly, it's exactly what we would expect the deceased in this case to do if she were in a similar situation. And it's really unfortunate that this worked out in this way, but that doesn't make a man guilty, deserving to go to jail forever, you know.
And maybe throw the policy under the bus, right? Maybe say, listen, this is a result of this policy, and maybe you don't like the policy, and maybe it seems to lead to this bad outcome, and we get it. We're sympathetic with that, but this officer did not make the policy.
Exactly.
I mean, it's I think ultimately going to be an unimpressive and unsuccessful argument, but the prosecution is going to have to hammer the points that you've said hard. But you've also got to look at the kid testified previously. Well, you forget the fact that he testified previously that they pointed the gun at him. He didn't point the gun, and there wasn't time to respond to the instructions she was being given before he pulled the trigger. I mean, you've got to hammer those, but I just don't.
I mean,
know
the
if it can be
the state
effective,
doesn't
though.
really have a coherent theory here, right? I mean, first are arguing, well, the gun wasn't really raised. Now the kid's saying the gun wasn't raised, or was it raised? Or was he trespassing? Is he not allowed to go into the backyard, or is he allowed to go into the backyard? Should he have checked the garage or not checked the garage, or cleared the cars or not cleared the cars? Or should he have taken more time to look around, like check the garage, or should he have worked faster? They went past the door too quickly, but then they didn't take enough time to look at the garage.
Here's what
It's
I want to point
incoherent.
out. Okay, first of all, to the people accusing me of bootlicking in the chat, sure, that's fine. These are confusing cases because you have a former cop who's charged by the state. So which do you prefer? Do you prefer to bootlick the former cop, or do you prefer to bootlick the state? I'm not sure. But that being said, all of that aside, here's what should have happened. When the lady saw the intruder outside the window of her home and had a gun in her hand, she should have shot him. She should have shot the cop. She should have shot him. I would have shot him. I think Andrew would have shot him.
I would have shot him.
Well, you can't.
Well, not here. I could back home. I mean, Utah, you're encouraged to shoot them.
It's not about this. This isn't a case about like the proper policing. Like, this guy followed policies that I disagree with. I don't like exigent circumstances. I like the warrant requirement. I don't want interventionist police. I've talked about this over and over. When police were invented in the United States in their capacities here, they didn't have the ability to be interventionists. Information moved too slowly. They were servers of warrants and arresters of people under those warrants. They were investigative after the fact. They were the cleanup crew. I kind of like that. I believe that people and communities were empowered to police the activity within those communities. I would prefer to see something move back towards that. But this
Well,
isn't
just
the
look at the
law
Ahmaud
for this
Arbery
guy.
case. Look at the Ahmaud Arbery case, right? When the McMichaels and Roddy Bryant engaged in self-help rather than call the police, they ended up with life sentences. So
Right.
people are not incentivized to intervene themselves into these ambiguous situations. They're incentivized to call the police and have the police take care of it.
Right. And personally, like I would prefer the opposite of that. But for this defendant acted in a way that is legally justifiable. Whether that legal justification is something we prefer or don't prefer is a different question. I hate every encounter that ends up with a citizen dead by police. I hate all of them. I don't want encounters with police officers. I want them reduced dramatically. I think there are tons of ways that we can do it by eliminating stupid laws. One of my go-to cases is Eric Garner up in New York selling loose cigarettes outside of a convenience store, ends up dead because of a bullshit law that meant New York City couldn't collect taxes on cigarettes that were already sold in New York City. So they already collected taxes, but they wanted to double tax. So that ends up with a guy dead by police. I hate it. That cop walked. I think it's one of the worst things. It is one of the most obvious, like, cop versus citizen problems that didn't turn out with the citizen actually acted like a complete piece of shit, like Mike Brown, for example. Mike Brown down in Ferguson is punching a cop through the window, grabbing his gun, has powder burns on his hand because his hand was so close to the gun, walks away, turns around, charges the cop discharges. Darren Wilson's entire life is ruined because this guy was violent asshole who also was stealing shit, like armed robbing a convenience store just before that.
Well,
right?
Yeah, strong arm robbery.
Or strong arm robbery, yeah.
Right.
But Eric Garner's a completely different case. And that's a case that's, in my opinion, much better suited towards the arguments. And of course, one of the biggest
I
ones.
think the Garner case is very parallel to this one. I don't think that cop was responsible for the policy. I mean, this not selling loosies, that's the city policy. He's just, he's the cop. So he's ordered to enforce the city policy. That's what we expect our cops to do. That's why we hire them. I looked at that case very closely. What ultimately killed that poor guy Gardner was really his physiology.
Him being fat. Yeah, him being a big fat ass is what killed him. And that's what I was going to get to. The cop, I don't think, wanted to kill Eric Garner in any way, but it doesn't matter because what I'm talking about is just reducing the number of like pointless interactions between civilian and police, because every law, every ordinance ends with a bullet at the end of the day.
Right.
Because someone either resists, is perceived to resist, some passerby gets involved in a scuffle, anything can happen. And I think reducing those is ultimately good. And of course, the worst one that I've seen ever was Daniel Shaver, who's the guy in the La Quinta hallway. And he's got like 6 cops yelling conflicting orders at him. He tries to comply and he gets iced right there in the hallway. It's really horrible. There's no race issue involved in that one. It's just a fucking tragedy and bad policing leading to the death of a citizen over what could have been handled in a completely different way. But policy dictated how things worked. That police officer should be in prison, and so should his supervisor who was there, in my opinion. But you know, these are the things we're up with. But bootlicking and general policy aside, you have to look at each case as they come before you. And this guy, we don't want what happened, but did he do anything unlawful? And it really looks like a completely justified use of force, as unfortunate as that is.
Nuremberg, just following orders. I mean, I've seen that in chat more than once. You know, it's
What an idiotic argument. So,
Yeah, no,
of course,
I was
what Nuremberg is referring to is following orders that are clearly immoral. Searching an apparent burglary site for evidence of forcible entry is not clearly immoral.
slightly different than genocide.
Lackluster said Daniel Shaver's wife just got paid $8 million, which nice, I guess. The interesting part of that is, of course, George Floyd's non-wife and family, who largely seem to hate him, got $28 million. So kind of sucks to be in that camp.
Yeah. What about the guy with the knife? The guy who got shot right around the Kim Potter trial period. Remember, he was getting into the car at gunpoint.
Oh, the guy,
I'm blanking on his name.
not Freddie Gray. That was Baltimore. The guy up in Wisconsin who sparked the Rittenhouse stuff, right?
He got shot in the back by the cop.
Was it?
Maybe
we might be thinking of different ones.
His girlfriend had called the cops on him. The girlfriend had called the cops on him because he wasn't returning her car or something. And then the cop showed up. Jacob Blake. That's the guy.
Yeah.
I think he got 27 million.
He got a shitload of money. He lived. I think he might be paralyzed. I know he was in a wheelchair at least for a while. Yeah, he got like 7 bullets in him. Yeah. Plus 25 million on GoFundMe. And people can be sold a lot of stories. Jacob Blake was a piece of shit who was kidnapping children in a stolen car, fought with cops with a knife in his hand.
With a knife in his hand. Right. A big ass knife.
Those cops had all the restraint in the world until he's literally about to steal a car in front of them with children in the back that he is kidnapping. They finally shoot him. They don't even manage to kill him. It's like, oh God, I feel bad for this guy.
They literally shot to wound.
Here, have millions of dollars. Oh my God. So here we go. Eric Allen says this is hilarious in regards to the last witness. Gates of Above. Hey, Nick, so why was it bad for the prosecution to ask that police policy expert about the Fourth Amendment? Okay, so the Fourth Amendment is this academic argument that happens between lawyers in written motions with a shitload of research, lots of citations. The Fourth Amendment practical arguments that happen in the field where a police officer is adding justification to their continued investigation are practical arguments. They're not solid legal arguments. Now, they're usually pretty good and they get a good grasp of what the Fourth Amendment is, but let's just say there's some flex on it. And they'll flex in favor of continuing an investigation as far as they can flex outside of like wanton unreasonableness. Now, what may happen as a result of that is you get to court and the guy makes a very nice, your attorney makes a very nice motion about why their actions violated the Fourth Amendment. And then thus the evidence from those particular actions becomes inadmissible. That doesn't mean you win, by the way. An unconstitutional search does not mean that you are not criminally liable and will not be found guilty. It just means that the evidence as a result of that criminal search must be excluded. Sometimes
Right.
that goes all the way down the chain of evidence. Sometimes it's just a portion of the evidence and it's not sufficient to make you not guilty. So, but that's all academic arguments that happen between very well-educated people with very particular interests. This guy is a cop training guy. All of his Fourth Amendment arguments are going to end up flexing in favor of a police officer
Right.
furthering his investigation. So if you ask him to explain to a jury who are not lawyers the Fourth Amendment, he's going to tell you exactly why cops get to do much more than they actually get to do from a
Right.
position of authority. And you've just told him to tell him that. He should never make that legal determination. And if a lawyer gets in a Fourth Amendment discussion with a cop, the lawyer is disagreeing. If it's a defense attorney, they're disagreeing about all of it immediately.
Right. You're going to get
No,
the
you can't do
pro-cop version. I mean,
Right.
You're not going to get the anti-cop version.
And so
It's
he
just going to
asked-
reinforce that the defendant had privilege to be there.
Right. And one of the ones that he said, it was like, wait, so if the gate's unlocked, they should just open it and go through it. He's like, yeah, of course. Because that's the practical in the field way. Like, oh yeah, I have exigent circumstances. Does he have exigent circumstances in this case? I think for the purposes of what happened here, yes. But if they had discovered evidence that led to the arrest of someone in that house do they have exigent circumstances? We're in a completely different perspective here, because now we're focused on whether the defendant who's being oppressed by the state, who is now a person who has evidence gathered by the state, if the state overstepped in gathering that evidence. That's a way different question than whether or not this cop believed he had a reasonable purpose in being in that backyard for this instance. Remember, in this case, we are presuming innocence of the officer because he is charged under the system. In the other case, we'd be presuming innocence of the defendant who the officer used to collect and whose rights were potentially violated. So that's the difference in perspective here, and why it mattered so much why it actually didn't matter. The exigent circumstances argument doesn't matter and should probably be avoided by the prosecution here because, as Andrew said, they didn't charge this guy with trespass, and trespass hasn't been an issue. Most people don't know the Fourth Amendment as much as the chat. You guys, who specifically ones who are suspicious of cops and the government, like me, you look into this and you go, I don't really want cops creeping around my house or whatever. Lots of people, especially in low-income neighborhoods, think cops keep creeping around the house in the middle of the night. Probably isn't that weird. Might have happened to their neighbors the night before, right? Like that. So just giving him the opportunity to do that, in my opinion, huge tactical mistake, because they set him up as an authority on it and just asked him to give a class. And we know how that class is going to go. So that's like asking Joe Biden what the merits of higher taxation on marginal tax rates are. Like, of course, he's going to give the answer you expect. Anyway, Evil Bunny says, Bunny, howdy all, especially Mr. Branca. I guess hi to the rest of the panel too. Hey, what's up, Evil
Hey.
Bunny? How you doing?
Addy.
Okay.
I guess.
Tada Tie-Dye says, just sitting here wondering how much we need to raise to get Branca to do a stream wearing head-to-toe tie-dye. Head over to tadatiedye.com. Use coupon code HippieNick to get 15% off your order. That's Tada tie-dye. That's 4 A's on the da. So TADAAA tiedye.com. And you can use Hippie Nick to get 15% off. So very, very cool. Thank you guys for that. Speaking of getting a percentage off, I can't get you a percentage off, but what I can do is get you a percentage of security by checking out birchgold.com/knows, a sponsor of the show today, and really every show in December. Birch Gold, the Birch Gold Group, is here to give you information on how to protect your IRA or 401k against things like market volatility and inflation by adding precious metals, particularly gold and silver, to those. Lots of people don't know that you can hold those in your qualified accounts, but you actually can. Birch Gold has information on how to do it. That's what they're selling here, is the information. And they're selling it for the low, low price of literally fucking nothing. You just click on this green button. They'll get in contact with you and tell you how you can do this. You then get to decide if it's a good idea or a bad idea for your own situation, your own retirement account, your own future, your own risk tolerance. All of that is stuff that you choose based on having more info. Birch Gold is here to provide you that info, and they've asked me to help spread the word about it. birchgold.com/knows. Get your gold today with your birchgold.com thing. Also, if you do choose to invest in gold and silver through your IRA or 401k, for every 5,000 you trust to Birch Gold, they will send you some gold backs, or a gold back. I'm not sure exactly how many, but these are gold currency. They're actual gold. They're real things. And they each contain a specific amount of gold. Like they go from the 1, which has 1/1000th of a troy ounce of gold, a couple dollars there, all the way up to the 50, which has 1/20th of a troy ounce of gold in them. They're these pretty cool things. I don't know what you can do with them. I guess you could trade them in somewhere for money. But they'll send them to you if you decide to invest by December 22nd. So big friends of the show, Birch Gold, big shout out to them. And again, my favorite part about them is they've never asked me to say anything specific other than let people know about their offers. And they've never asked me not to say anything. So there we are. There we are. Thank you to Birch Gold. They started out in porn and they ended up in precious metals. birchgold.com/knows/porn.
Hey, as long as we're grifting,
Of course. That's what the breaks are for.
I shared the screen. Hey, folks, a little word on American Law courses. These are law school level courses. Just as all of us lawyers here, were taught them in first year law school at a fraction of the cost and time commitment of actually going to law school, and without the toxic politics of today's law school environments. If you like this legal stuff and would like to be able to understand it like a lawyer is trained to understand it, I would encourage you to take a look at American Law courses. We teach traditional American law in the traditional American way. This spring, we have courses on evidence and on property being taught. We also have Steve Gosney, who's in the chat, just finished up his criminal law course this fall. We'll have a recorded version of that available. We have criminal law 2, or criminal procedure, being taught by Steve later this year, constitutional law, criminal justice, and maybe I can talk legal vices into doing a maritime law course. We'll see if I can convince him to do that. But if you'd like to learn more about American Law courses, this would be the couple of weeks to do it, folks, because until the end of the year, but only until the end of the year, we're in the pre-registration period for the evidence and property courses this spring. Save 50%. You do get, well, there's no diploma per se. You get a certificate in these courses if you pass the final exam. There is a final exam for each of these courses. If you'd like to learn more about that, I would encourage you to do that now while you're still in the 50% off pre-registration period at AmericanLawCourses.com/Nick.
There you go.
All right.
Absolutely. And guys, getting tons of good feedback on that. People like the courses. The most important part is the instructors are not bitches.
No, they're good, man.
When you go to
you all
law
know
school,
Steve Gosney, right? The property course this spring is being taught by Andrew Esquire. You all know him. He's been on Nick's show. He's got his own YouTube channel. And we have evidence law being taught by an attorney with over 200 trials under his belt. And there's no better way to learn evidence than to apply it in practice and trials.
Yeah, when you go to law school, what you'll find is your professors are of questionable everything.
Political motivation.
And there's a difference between practical law professors who have practiced and law professors who have not, who are academics. And you'll get very different sorts of ideas from all of them. Look, with Andrew's classes here, with many of the professors, you get to know who they are. Obviously, Steve Gosney, you could see him on my show. You could see him on Andrew's show beforehand. Now you can see him on his own channel on Rumble.
Yeah, I should mention all these courses are taught live. So they're streamed on Zoom, taught live, one course a week on a semester basis. They're not just a set of DVDs or something. So you're actually interacting with the professor in real time.
And I could say a lot about law professors personally, but what you run into is a lot of ideology, a lot of it, and a lot of academia ideology as well as political ideology, just sort of that academic perspective on things that comes from law school. You're not going to be getting that. You're going to be getting good information from people who live in the real world in these courses. So
and lots of real world examples. So real cases, real trials that you've heard about will be used to illustrate the legal principles you're learning, not just dry textbook stuff.
To be fair to my evidence class, it was taught by a judge.
Yeah, mine too. It was awesome.
Yeah, we were a magistrate.
And he just used My Cousin Vinny for most of it.
Oh yeah, well, it's not a bad choice.
Yeah, it's like one of the only law movies where they did law pretty well.
Yeah, very well.
Funny that he wasn't even a licensed attorney the entire time. So that's great.
Gee, my magistrate evidence professor used his $550 book and his $150 supplement.
Oh, I had those too.
Professor Boyce required us to buy Boyce on evidence.
Oh man. No, our professor did not write the book. He made us buy probably his friend's book.
Right.
Is how that works out. My civil procedure professor had to buy all of his books. Roger Haydock on civil procedure. That dude had a pair of glasses that matched literally every single outfit, a different pair for every outfit.
Well, with those kind of book sales.
Yeah. And he was I like to talk about him because he was so like flamboyant. He had lots of rings and bracelets too. But he and loved motorcycles. You'd probably get along with him pretty well.
All right.
But he was a special master for the Bayer Aspirin lawsuit that's been going, that had been at the time going on forever. It might still be going on, but they couldn't do a class action, and it's aspirin. So the amount of plaintiffs was in the multiple thousands. And so, I mean, it's just like 15 years of just getting paid constantly.
Yeah, nice, sweet. That's a sweet gig.
Yeah. When are you going to teach a tree law course? Man, tree law is something else. Oh my God. If you can get it, if you can get those tree law cases.
I mean, Utah has one of the biggest water law bodies of law in the entire country.
I bet.
Yeah, all these states out here, Utah, Colorado, water rights are unbelievably complicated here.
The water stuff here is all just what the government can fuck you with.
Yeah.
Rather than like private ownership. And because so water law gets complicated because you have to go like who bought the property when, and who's upstream from who, and
who's downstream.
Right.
So here in Colorado, you weren't even allowed, until a few years ago, you weren't even allowed to use a rain barrel to capture rain that fell from the sky on your roof into your gutters, into a rain barrel. That was prohibited because of the water rights of the people downstream. You were stealing their water, basically.
Yeah. And here in Minnesota, we mostly like our wetland stuff is insane. You can't, if you want to build any structure, they have to do an assessment to make sure that the runoff from your property will not be impacting a wetland somewhere else. And if you build it in a way that it does obstruct, they make you just completely undo it. If you destroy a wetland, you can accidentally create a wetland by having standing water in a certain spot and having certain grass seed land there from wind.
Don't do that. And don't allow that to happen.
Right. You get aquatic grasses in the middle of your yard. Suddenly you have a pond that you didn't want, and it's dry 99% of the time, but it doesn't matter. And then they came up with this weird fucking thing where if you could basically set a canoe in it,
it becomes a navigable waterway.
Yeah. It's like, but they can't go anywhere. It's like a kiddie pool. Too bad. God, I hate it. But tree law is this beautiful thing where when you fuck up someone else's trees, you're replacing a tree. Do you know how expensive it is to replace like 100-year-old white oak?
Oh, I don't even want to think about it.
First, you got to find one. Then you got to dig it up. Then you got to transport it. And then, if you accidentally destroy or chop down someone's tree through negligence that you don't have a right to, you are paying massive amounts, and you're paying triple in Minnesota. You're paying triple damages on that.
Yeah, so where I live, it's really high desert, so there's no natural trees here at all. But of course, it's an HOA, so the HOA demands you have a tree in your front yard. Every house has to have one, and God forbid your tree dies.
Seriously.
The cost of putting in a 10 or 15-foot tree here is unbelievable.
Yeah. Whew. You're well into 5 figures, I would imagine. Let's see. Oh, here we go. Jonathan says unrumbled because no waifu runkle. Danny's not available today. I was going to go on our show last night, but I have been so tired lately. I just passed out completely.
She's doing good though. She's starting off right. She's doing the right thing.
Yeah,
Yeah, I like Danny. She's smart.
Yeah.
Smart girl. Smart
she was
woman.
covering the Twitter files, and I really want to cover them, and I was hoping to get caught up on them, but after my D&D stream, I was just like, I went upstairs, I got on my bed, and I woke up on top of the covers and then went under them later. It's like, Jesus. Jonathan, his mistake. You can't rattle someone with that kind of mustache. Impossible.
Right. If Tom
I
Cruise
agree.
couldn't do it.
Yeah, that guy had. See, the prosecutor, he was able to rattle this cop because the cop probably has emotions and regrets associated with his actions that day. So he's able to play on that, be loud, belligerent, exasperated. Huh, I can't believe that you killed
Hey.
someone.
Hey, Danny's in the chat.
Yeah.
Oh, hey, what's
Talking about
up,
Utah's
Danny?
weird tree laws.
Because the pioneers settling the valley, you can't cut your neighbor's tree branches encroaching on your property. God, that'd be
Yep.
annoying. But yeah, so his plan was to be loud and belligerent. It worked with the defendant because the defendant is full of regret over his actions. The expert doesn't give a shit. Like, not to be crude, but he doesn't know this woman. He doesn't know this cop. He's just there to go and testify about police training and his expertise. So assuming the way to maybe do it would have been to attack his credentials, would have been to attack like his performance as a police officer, which he kind of leaned towards at the end.
Yeah.
Like, I'm surprised. Oh, wait, you're only a cop for 3 years? Oh my goodness. That's not really, I mean, you're an expert now. So you haven't spent a ton of time in the field. Most of the time has been behind a desk, right? Like, he could have started to go after his expertise and tried to rattle him that way, but he tried to rattle him with facts of the case. This guy doesn't care. And so he kept his cool, and it was a misstep on that one, in my opinion. The Dragon's Treasure says, I'm too lazy to remember what the coupon code for the Dragon's Treasure was. So just type in lazy in the coupon section and see if that works. Stock up on anime themed teas or else this is a threat. So that's the dragonstreasure.com. Really terrific tea if you like tea and tea accessories. I'm here to sell you tea and tea accessories. You can go to the dragonstreasure.com, use coupon code lazy to get yourself a little discount on that and find yourself a new passion. Jason of TGA says, is it Rumble exclusive because YouTube dislikes seeing Soros DAs annihilated? Well, this stream is not Rumble exclusive. To be very clear, trial streams are broadcast on Rumble and YouTube. And when I have time to set it up, Odyssey, I was having internet trouble this morning, so I did not have time to set up an Odyssey stream because their process, which I really like Odyssey. I like those guys a lot, but their stream setup process has this long delay between when you request a stream key and when that stream actually becomes like valid. And it's really annoying to do. I was running behind because my internet just wasn't working this morning. And by the time I got it set up, I didn't have time to get Odyssey.
Rumble's a pain in the ass too. Why do they make you make that little 30-second video for every stream?
I don't know. It's one of the things I'm working on them for because I'm like, this is terrible. Don't do this. Like, and I'm hoping to get that removed and to get an API to automatically assign a stream key like YouTube has through things like StreamYard, so that I can just go to one place, set up a stream, and it sets it up in all of the places. That would be ideal. And hopefully that's something they're going to be working on because I think it's better for streamers, better for audiences. If I want to start a show now, going on Odyssey and Rumble, I can't start a show now. I can start a show a few minutes from now. If I want to start a show on YouTube, it takes 10 seconds.
Yep.
So But we'll get it. We'll hopefully get that fixed on their end. But I think that is unfortunately one of those changes that takes a little bit more time to make because of how they built their streaming service, which wasn't a streaming service, but how they built their service back when it was being built. And so we'll get that. That's high on my priority list, by the way. Karamachet says chokeholds are illegal rackets. Garner died of not being able to breathe, not being fat, and that's unethical and massively illegal. Garner died, if I remember correctly. There was a chokehold takedown applied, but what ultimately happened was he was a man. I thought that the guy briefly used a chokehold takedown, but what ended up happening was he was not choked on the ground, but he was on his stomach, and the guy's like 350 pounds. And that being on his stomach caused basically a self-asphyxiation. I don't know that the cop was even on top of him when he
they use what's called a seatbelt takedown, and if you imagine how a seatbelt works, that's the takedown that they
like
use on
across
him. He was never choked.
chest like
His
this.
breathing was never constrained by an arm around the neck or the blood flow by an arm around the neck. That didn't happen.
There you go.
But basically, he's a giant guy, and the cop was half his size or less, and the cop, they jump on him, they wrap an arm around your shoulder and chest, and they bring you to the ground. And then on the ground, he was still talking. I mean, he wasn't being choked.
So Karamachet saying asthma and then saying fuck off. I mean, again, if it's asthma, it's still not the officer's intent to kill him. That was the main point of that. It was very unfortunate. But I don't believe an actual like a chokehold as we would understand it would apply or was applied. I know that was much more of a controversy in the Chauvin thing, and people can argue about it all day. I'm not here to rehash Chauvin. I've said so much about Chauvin throughout the years since it happened that I'm not here to get into a fucking Chauvin argument because I really don't give a fucking shit about Derek Chauvin either way. George Floyd's not a good guy. I don't see Chauvin as the best guy either, but that's me. Zadok Attack says, I have a great uncle who had to reduce his pond from 20 plus acres to just below 15 acres because in Indiana, if your personal body of water exceeds 15 acres, the DNR gets to tell you how to manage it. Oh, you get 15 acres? God.
That's a lot. That's a big pond.
That's a blessing.
That's a lake out here.
Goodness. Oh. Yeah. If you have 15 acres of water on your property here, you definitely, they tell you what to do. If you have a quarter acre of water on your property here, the DNR gets to tell you how to manage it. My last house had a man-made pond. It was not naturally fed. It was literally just a cauldron that collected water. Yep. Wetland. If you
koi pond,
you try and destroy it, is that the guy dug it for his kids back in like the 70s. And he, it was their swimming hole that he made. But yeah, you fuck with that. Have fun. Government will just mess with you.
No, that was thinking in my hometown. We've got a really high water table, and the guy that had these huge amounts of cornfield, he decided to start digging some trenches to test the water table. Well, congratulations. You've now created wetlands where you had farmland before you did that you can't touch.
Yeah, it's the mess. It's actually, I had a client who we had some issues with. So he had farmland, and on it there's a slough that was created by the government because there was a stream that ran and fed into a lake, and they wanted to control the flow of water into the lake for all the nice lake properties. And so they built this dam, basically a small dam, and they added these logs to raise the level of the slough, lower the level of the lake. Well, that eats up his farmland. Then you get the problem of upstream from the slough, beavers will build shit in your in the stream and cause a second slough. So he went through and just cleared that shit out, which you can do. You can clear out beaver dams from the ditch, basically, leading into the slough. But the DNR flew a drone over his property and took pictures while he was in the process of getting the stuff out of the slough or out of the ditch, and he had it set up alongside it. He hadn't actually moved it yet. So they said he was adding material to the wetland. Even though it was from the wetland, he was corrupting the wetland with stuff from inside of it, based on their aerial photos. And they were like threatening criminal charges and all this stuff if he didn't comply. We finally got, he was kind of belligerent with the government, which is why I was there.
Doesn't help.
And so I'm finally talking. What do you want him to do? They're like, we just need this stuff moved. Like, that's it. Like, he's going to move it anyway. Like, so he just had to get a bulldozer out there and just move that shit out of the wetland, which was already the plan because he didn't want it there in the first place. But it's like this huge thing. They're threatening like criminal charges and daily fines and stuff. And all it took was like them just saying, yeah, that stuff's not. It's like, well, he wasn't done with the job yet, you idiots. The only reason he stopped doing the job is because you told him that working in the wetland was illegal. I hate them. I hate DNR. I hate county watersheds. I hate everybody involved with land management. Fuck off. I bought it. It's mine. Leave me alone.
That's why to this day, the scariest thing in my hometown is BLM. It's not the Black Lives Matter, it's the Bureau of Land Management.
Do they even have black people in Utah?
4. They all play for the sports teams.
I was going to say, I think they were excluded from Salt Lake City until about 1978 under the
Parts of Salt Lake City are pretty sketchy these days.
Yeah, these days.
Yeah, well, it's after Katrina. Katrina was a major relocation center.
Yeah,
Salt Lake was. Yeah.
Yep. Same with Houston, but you couldn't really tell.
Right. Couldn't tell.
It's kind of the same before and after. Adam Trapp, our scout camp wants to remodel a building. Government wants to inspect every drain field on property. Every water spigot will cost us $75,000 to $100,000. There you go. That's how it goes. Oof. Let's see. We've got Jonathan says, take the side of the defense, bootlicker. Take the side of the state, bootlicker. It's kind of how this one is. That's how all these police shootings are. Like Kim Potter, I really wish she hadn't shot Dante Wright, I guess. Like, I don't really particularly care about Dante Wright other than I don't want cops shooting people if they don't have to. But like, the facts didn't support criminal facts and law specifically really didn't support a criminal conviction for her. And I think the judge kind of really took that into account with her sentencing. The Dragon's Treasure says, if someone asks you how many noodles do you want, is there any acceptable answer outside of oodles? I hate you. He also says, finally, Nick, I still haven't gotten that $30,000 you definitely promised me. Time is running out. You still haven't given me a reason to give you $30,000. Not that I'm gonna. I just want to know what your stupid reason is. Just keeps asking. All right, here we go. Rogue of Enwy says, what can states do to incentivize prosecutors pursuing truth, justice, as opposed to prosecution conviction, no matter what? Well, they have state ethical rules and they should, in theory, be disciplined under them, but they don't get disciplined under them. I mean, it takes a lot to do that. They have a lot of discretion in how they conduct their lawyering. So what can states do? Enforce the ethical rules, I guess. Maybe have a citizen review board or something. But I don't know that that's better, because that'll just be inflated by a certain type of political activist, because they're the people who have time to be on a citizen review board. And then, every prosecution of one group of people will be bad and every prosecution of another group of people will be good. So it's a mess. Judges could start calling them out on some bullshit. That would be nice too, if they did that. Sanction some prosecutors from time to time, and not the prosecutor's office, but the prosecutor themselves.
Exactly.
Wait, Senor
Especially
Spielberg.
if it's a not guilty verdict.
Senor Spielbergo says, wasn't it because you streamed over his stream on Saturday? Wait, what are you talking about? Danny says, if you give me $30,000, I will use it as a cash down on a larger loan to open a business, and I'll pay you back 10% per month and 15% on monthly net revenue.
I'll just
That's a
spend
better
it on
re-
some dumb shit.
That's a better reason than Dragon's Treasure. That's a loan. He's just
Yeah.
like, give me money.
Can't fault him. Yeah.
Oh, the T-Man. Okay, that's why. That's what he's saying. Senor Spielbergo, because I streamed over the T-Man stream. Yeah, well, too bad. Too bad. Let's see. Going back to the beginning of the stream here. Start hitting these. What we're waiting for, by the way, if people don't know, the defense has rested in the Aaron Dean case. They're at lunch. What they will do when they return from lunch is determine if there is a rebuttal case for the state. And if there is not, they will move into closing arguments, or they will recess and do closing arguments the next day. Depends on what the judge wants to do.
Do you think they need a rebuttal case, or do you think the expert did a better job of doing that than they would?
Well, I mean, the rebuttal case would be for the prosecutor, so
Yeah.
they might want something, but I don't know what, unless they have a competing expert to take him down, they're not getting anything out of anybody else. There's only 3 people who testified for the defense in this case: Aaron Dean, the defendant, and the video expert, and then the police tactics expert. So unless they're gonna, like, the video expert was horrifically boring and completely pointless. They just told us why we couldn't see the woman through the camera lens effectively. Like that was the whole purpose of that, like, what, 4 or 5 hour testimony.
It was brutal.
And the tactics expert was nice and short. But I mean, really kind of dismantles the state's case. So unless they have a tactics expert that they're going to bring to try and rehab their case there, which they might, I don't see much of a rebuttal, because they got what they wanted out of Aaron Dean.
Yeah, that's what I'm thinking. They probably wouldn't, because they did him a good number, and I think they did sufficiently well in cross-examining the expert to not. Yeah. I mean, it wasn't good, but it wasn't good. But
The question is, can they get more? Right? Like, can they
Yeah.
get more out of someone else? And I don't know that they can, but they might try. But either way, if they don't do that, we might get some jury instruction argument, I guess. And then, they have plenty of time to do closing arguments today. If these closing arguments are longer than about 45 minutes, it shouldn't exist. And I think that's a lot.
The openings were 20, 25 minutes
Yeah.
each.
We're not going to see like Curtis Reeves closing argument or whatever. There's just not a lot here to discuss. Not a lot of witnesses, not a lot of evidence. Heavy on law or emotion is what you got, and it should be quick and dirty on those things. And not a lot of charges either. Some of these cases that we've covered, like Darrell Brooks, you got 70 charges. So you got a lot of arguing to do. Talking Trash and Truth says, hit the plussy, please, and thank you again. Yes, back to if you're in Rumble Land, please hit that plus button. It really helps move the show up the actual leaderboard that exists there. It is a tangible result, and I really appreciate that. Hold on, I gotta find out exactly where we were. Azteca 1 is the first one I've got here. Okay. The Four Stooges says Nina was right, late and gay. I wouldn't have been late today. I was so mad. My internet was just I can show you, I think. Here, this is what I woke up to today. There's my speed test. That's what I woke up to today, trying to set the stream up. I couldn't I couldn't even open Twitter. Like I couldn't open it on my computer. 0.55 megabits per second. Great. I texted Andrew. I'm like, my internet's fucking broke. So I was up at 8:10. I was ready to get everything going. I was very mad. Chris Chan says, can I get an interview? I want to tell my side of the story. That's not Chris Chan. But absolutely, if Chris Chan wants to do an interview, 100,000%, I would
Whatever
interview
you may
Chris
say
Chan.
about him, you have to give him credit. He did love his mother.
You bastard.
Just saying.
Oh, God.
Shit.
Okay. Ranjikar Patel says, where lady lawyer, I enjoy face but no speaking. Oh, that's what we need more of. Ranjikar. I love you. I love you. Oh my God.
I just think Branka's lucky for not knowing this one. The internet is just a dirty, dirty place.
I love it.
Fucking internet.
This is why I'm so like, I get so vehemently and viscerally angry at like censorship and these weird, like anything to clamp down. Well, we don't want mean stuff on the internet. It's like, no, we do. We want everything, all of it, everything, everywhere, all at once. Like that stupid movie, which is about a Chinese thing. I don't even know what it is, but like all of it, because it's pure and purity is beautiful and desirable. And we could just, God, we can have Ranjikar come in. we can have a Chris Chan, because Chris Chan exists, whether the internet does or not. At least we get to laugh at this one and be horrified in equal measure. Okay. Amateur Anth, Nick, I haven't been paying attention to this case. Can you tell me who shot who? Also, who on the panel has the biggest milkers?
I win that one.
I'll concede. I'll concede to it. Yeah, so here's a rundown of the case. Aaron Dean is a police officer in Dallas who is responding to an open structure call. Basically, someone makes a phone call that around 2 a.m, all the doors in this house are open, which is not characteristic of that time of day. They don't see people. What they see is open doors into a house. For some people, that's, that could be a burglary. It could be some sort of distress. There could be anything going on in that house. It's just out of the ordinary. It's the middle of the night. Doesn't fit. They call police. Should cops be responding to that stuff? That's a policy question. In this policy, they do. And that's the most important part here. Is the policy here is they do respond to that. And how they responded is they approached the house. They treated it as a potential burglary in progress, not a former burglary. So they park their cars across the street. They proceed to the house. They start making their way around the house. The officer, Aaron Dean, looks into a window on either the side or the back of the house. Kind of might depend on your perspective. I don't know. I think it's the back of the house. He looks into a window. He sees a figure bent over in the window. He's got a flashlight that allows him to see inside the window because it's dark in that room. It's lit up in other parts of the house that they pass. Also, the house is in disarray of some sort. There's stuff on the floor. It's kind of messy. It looks probably like my house looks most of the time. I've got kids. They throw shit all over the place. But in either case, it's consistent with the possibility of a burglary in progress. He proceeds around the house. He sees this back window. He looks inside of it. And when he looks inside of it, he sees a person bent over. He asks the person to, or the person I think stands up at that point. He says, "Show me your hands." When he looks down where the hands should be, he sees a gun pointed at him through the window. He fires, and killing the person inside. He shoots right through the heart. They're out very quickly. One shot. He then proceeds inside with his partner into the house, notices there is a gun, which he claims he saw a gun when he shot them. So I guess confirms there's a gun. I don't know. That's a fact point for the jury to determine if they believe him that he saw the gun when he shot. That credibility aspect will be critical to their decision. When he gets there, there is a gun. He kicks the gun away from the person, does not administer any life-saving care for, I believe, about 60 seconds till backup officers arrive and do first aid training. He has no specific first aid training. Although, didn't he put an Afghan on the wound? Right.
Not that
very
it would have
effective.
mattered.
He should have put a Jordanian on the wound. I hear they're better at stanching bleeding.
I mean, she was shot through the heart, so it was a
Sure, who's to
non-survivable
blame?
wound.
Who's to blame? You know?
Going there. You give cops a bad name. Anyway, so she dies. There's an 8-year-old boy at the time. He's 11 now, who witnesses the shooting. At the time, 2 hours after the shooting, he mentions that this is his aunt, that she was pointing the gun at the police officer. In testimony at trial, he changed his story and said he wasn't. So that's something for the jury to consider. Whether they believe him now or believe him then is a question there. But that was the ultimate, that's part of this, the factors involved in this case. And then that's it. I mean, that's the whole real fact scenario. Other things you get into around the case are questions of law that get more complicated. Was a police officer in the wrong to be where he was? Did he provoke the encounter? If provocation is unreasonable, then it can defeat a self-defense argument. But this is a self-defense case ultimately. Officers claim, I see gun pointed at me, deadly threat. I respond with deadly force. And the state's job then becomes to disprove that reasonable perception of a deadly threat beyond any reasonable doubt. They have to disprove that to defeat a self-defense argument, because he's not arguing that he didn't shoot the person. We know who the killer is. We know that the killer is this police officer who acted with the intent requisite to manifest at least manslaughter, if not murder. The degrees of murder are a different question, but he pointed a gun and pulled the trigger, and he knows that that's a deadly force move. So all of those facts are admitted to. He's arguing justification. So that's the ultimate question for the jury. What we've gotten to the past 2 days, which is where I started watching, is a lot of questions about tactical choices that have almost nothing to do with the actual shooting itself from the justification side, which I think is a problem.
Also,
for the,
the merits of the homeowner here arming herself with a gun, as it's not required that the victim here did anything wrong in order for this shooting to be legally justified. People keep tripping over that.
Right. We can just flat out say I will say the only thing the homeowner did wrong is not shooting the officer who she seemed to believe was a prowler. But maybe she drew the gun thinking it was a prowler of some sort, or some sort of, maybe a potential burglar, and she saw his badge. That's a possibility, that she saw something that caused her to hesitate and not fire. But at the time that she did that, he is already in the motion of perceiving a threat and firing. So it's a really unfortunate case. But I feel like the prosecution in this case, and maybe correct me if I'm mistaken here, I feel like they're really building the lesser included manslaughter charge. They're building that case out, but they're failing to address the critical element, which is overcoming the self-defense justification. Is that a fair assessment? Based on what you watched? Because I didn't watch.
It's weird because we never, maybe. So reckless manslaughter would be a lesser included. of first-degree murder here. They've
Right.
got to get to recklessness. I don't know if they think they got there by asking this cop 40 times if he thought that was bad police work or gave himself a bad grade. He didn't actually violate any policies.
Right. That's the
so
but that's the argument I was thinking. Like, why are they focused so far on all these events leading up to the shooting? They're trying, in my opinion, they're trying to argue that he created an inherently dangerous scenario by presenting as a prowler and violating whatever. I can't think of why else they're doing it. Legally.
Right. But of course, recklessness requires not just creating a dangerous scenario, but an unjustified dangerous scenario, right? Like drunk driving and you kill someone drunk driving. That would be a reckless manslaughter. You didn't intend to kill anybody. You were just trying to get home, but you were drunk. Driving a car drunk creates a risk of death to others. You ignored the risk. You did it anyway. And that's not a justifiable risk, simply drunk driving. In this case, he was creating risk. He did create the risk that he would be perceived as a prowler, be engaged by the homeowner, but he was doing it in the course of responding to an apparent burglary call. So it's not an unjustified creation of risk. It's a justified creation of risk.
Right.
And correct me if I'm wrong, but I don't even think, was the boy correct when he was 8 years old and said he did point, or when he said he didn't? My understanding is it doesn't even really matter whether or not she actually pointed the gun at him. Did he perceive her as having pointed the gun at him? Did he have that perception that there was a gun being pointed at him? Is that sufficient for the
It's not required, but it's nice to have the corroboration of the boy's initial testimony.
Right.
Because you can't see it on the camera, on the body camera footage. So
yeah, and that's of course the issue is if the jury believes the boy that there wasn't a gun pointed. We know a gun was there, but if the jury believes the boy, well, I guess do we know? Maybe the body cam footage shows the gun being swept away. I mean, he's testified that he swept the gun away.
they have this blur, right? There's a motion blur.
Yeah.
They talk about the photography expert. Frankly, it was so boring I couldn't really pay attention to his testimony, but I vaguely remember that point. I guess the motion blur is supposed to be representative of the gun being raised.
Well, I meant when he gets in the house after the death.
Oh,
because he testifies that they find a gun next to, next to her hand or whatever.
Right.
So, but assuming that if the jury believes the boy now that there wasn't a gun being pointed at him, then they would just say that the officers, statements would be self-serving and they don't believe him. If they find him not credible, then they could just convict and say, no, he was shooting this person unjustified. Right. So that would be the argument there. But I think that's a pretty big stretch because you do ultimately have the gun.
I mean, what would be the basis for giving the boy's latest testimony more weight than his earlier testimony 2 hours after the event?
Yeah,
right?
There doesn't seem to be a good basis. And unless they got him to testify that some officer pressured him to say that at the scene, or they somehow drew that specter of authority weighing in on the thing. But
he's older now. He understands what pointing a gun at someone means, where maybe he didn't understand that when he was 8.
Right. They would need to have fleshed that out. And my understanding is they didn't do that.
I mean, it's too late now. We can't bring the child psychologists and whatnot in at this point.
Why didn't the cop shoot the boy? He did not see the boy until after the shot, is what he testified to. That was part of the thing that really took him aback. Because when he shoots the person, if he's being truthful, he's of the mind that he's shooting an intruder who's armed, who's maybe putting someone in the house in danger. But when he sees a little boy crying after shooting this person, that's when his brain goes, oh shit. This is not what I thought it was.
I thought it was clever.
I got.
Clever of the expert to refer to the prospective burglar, right? The suspected burglar in the house could be either he or a she.
Right. Yeah.
But in any case, the cop's testimony, defendant's testimony is he didn't see a woman or even a person of color. He just saw a silhouette and the muzzle of the gun.
Right. Okay. So next we've got Vince Clortho, welcome to Paralegal Status. Arcad says, hey, Nick, I've missed your streams recently. Can you give a lazy bum the rundown of this? I just did that. And this is only the second day I've been covering the trial. Andrew has been covering it from the start. So, and those videos are up on your channel, correct?
Yes.
Let me make sure. And
Law
add-
Self-Defense YouTube channel, or well, on our Law Self-Defense blog, but that's for members only.
Law of Self-Defense.
Additional
and-
content there.
There we go. Law of Self-Defense and Legal Vices are now in the description if you want to go check out their channels, which I would highly encourage you to
Please
do.
do. Yeah.
Yeah, go.
I don't have books, but I got a decent mustache, and I think I'm kind of funny sometimes.
Only on YouTube do I have these in the description because they allow tagging. So on YouTube, you can go to their the description. You can click on Legal Vices or Law of Self-Defense. It'll take you right to their channels, and you can check it out. Let's see.
Hey, you know what might be
Knuckles-
interesting after this trial's over is that Courtney Clenny case, the OnlyFans
yeah.
model. Her trial got delayed to, well, at least till February. They haven't, the next,
Yeah,
it was supposed to be December 19th, next Monday, but they canceled that.
Yeah.
And now there's a status update hearing on February 6th. And the trial presumably will be some date after that, which is great. It's not going to be over the Christmas holidays. But last month they did do several hours of hearings trying to get her out of pretrial detention. And there was a lot of testimony.
2-day bond hearing.
Yeah, 2 days, about 8 hours altogether of testimony. She ended up being denied bond. But in the course of those hearings, there was a lot of testimony, like 4 hours from the lead detective on the case, the medical examiner, her own father testified. It may be worth breaking down some of that sometime before the trial, just to put it on your radar screen, Nick, because there's a lot of rich fact data there if you dig it out. And of course, the defense also made their arguments for why she, should be released. So they gave their narrative favorable to her. I have to say it wasn't very compelling.
Which is crazy because in theory, in a academic world of self-defense theory, the state should have a really tough case here. No witnesses to it. She's a woman who's claiming that she's defending herself from being abused by someone. Like, a lot of the sort of traditional factors would weigh in favor of a self-defense claim absent something else. But she has complicated this by having several instances of abuse against him that have been in some level recorded,
including
or
stabbing him.
Stabbing him
Right.
in the thigh. Yeah.
She stabbed him. She's repeatedly stabbed them before.
Yeah,
including
like
in the face.
chick. She must
Stabbed
have
them
been
in the
an
face.
absolute lion in the sack to deal with being fucking stabbed.
Well, then the
She's
rumor
not
has
that
it
good
she was
looking,
having
man.
She was having an affair with a Mr. Olympia and broke his jaw.
Well, maybe all the
Also,
steroids
her
made
explanation
weak
for
bones.
how she ended up fatally stabbing him just didn't really make sense.
Okay, angles do not like this girl, and angles have some issues here. Guys, this is what you should be on the lookout for. I'm gonna bring up some side by sides.
Yeah.
Do not be fooled, gentlemen, by the makeup. If this is how she's presenting in court, she is doing everything incorrect, and she needs to go to the Ricada Law School of how to be hot in court. Dear God, what a mess. Let me get another picture of her.
You got it side by side?
I'm about to,
because she looks like a different human being than from her her TikTok images.
Yeah, I'm picking the right.
Different.
I'm picking the right images here.
And the TikTok images are only months old.
Here we go. Just
well, there's her. I hope one of them's in her orange gear with the pimples.
Yeah, that's the one I've got. Hold on. Oh shit, I lost all my windows. One sec. I accidentally did that thing on
I hate that.
Where you shake the mouse, or you're holding a window and you shake the mouse and it clears your whole fucking desktop. Like, I don't want that ever to happen, but okay.
Why would you have that function anyway?
I don't know. This is a weird one. All right.
Like,
So
oh my
yeah.
God, the buck caught me. Yeah.
Right.
The
Are
Courtney
these the
Clenny
same
on
people?
the Courtney Clenny on Amazon, the Courtney Clenny from wish.com. No. This is not what I paid for. Shit. She needs to show up looking like a toned down version of this in court.
Yeah. Yep.
Talked about this a lot with Amber Heard. I think, and it's not fair. It applies to both men and women, but specifically for women, she needs to go in presenting as a pretty girl, not a slutty hot girl, but a pretty girl who is there just defending herself. She cannot look ugly, and she cannot look stacked out. And again, that's not a fair thing, but guys, it's your life. Your life is on the line. This is what we were saying with Amber Heard. Like, your entire financial future and reputation is on the line. You should have, and you have tons of, you have a bunch of money and access to the best stylists in the world. You should come in looking soft and approachable, because the jury wants to see soft and approachable Amber Heard. They don't want to see cold Nazi bitch Amber Heard. They're not gonna listen to you. I got a lot of criticism for my looks critiques on that one, but I will contend that I was fucking right on that stuff.
So I didn't know who Amber Heard was, and until that trial started, and I was looking at her, I was like, I mean, she's fine looking, but I don't get what everyone's raving about. And then I went back and I saw that footage from her in that zombie movie, and holy crap, she was hot.
Yeah, Amber Heard was very hot, and if you just go look at her red carpet pictures, stunning woman for a while. She didn't present that way in the case, and I think that really hurt her, frankly. I don't know that she could have turned the whole thing around, because she's just an awful monster. But for Courtney Clenny, I mean, you still got a shot, girl. I mean, so what? You stabbed and killed a guy. I mean, who hasn't done that from time to time? But yeah, you got to be hot when you stab someone. Okay. The Dragon's Treasure says, I literally cannot grow anymore because my apartment is too small. Need a new home to expand. Once current loans are paid off, income will increase by $2,000 to $3,000 per month, but I need down payment money. Oh, I see. That's why you want 30 grand. He says, no, I don't actually expect 30K. I'm just trolling for the fun of it.
Shark Tank.
Thanks for explaining the joke. You're going to owe me 30 grand for the School of Comedy, Dragon's Treasure. My God. Squizgar 2322. If Branca is still on, would he ever consider a Second Amendment law course? Like, not self-defense, but law surrounding Second Amendment regulation and whatnot.
Would I consider it? Maybe. So I was talking with someone who's quite expert in it. I actually wrote a law school textbook on it, but it got complicated because he wanted to coordinate with other professors to teach some of the courses, and he wanted the students to have to buy his textbook, which was a good chunk of the whole price of the course of the class by itself. So I'm not sure what's happening with that. We're still kind of in discussions.
I know a couple Second Amendment practitioners who might be interested.
Yeah, I'd be interested in hearing from them if you can connect us.
Yeah, I can definitely do that. So here we go. Locals Chad's dropped a meme. 5'11", 6 foot. Oh my God. All right. What do we got
Not
next?
funny.
Wait, what?
It's not funny.
Why are you 5'11"?
Yeah. 5'10" and 3/4.
Oh no. Get one of those gravity inversion tables. I can grow. Oh my God.
It's terrible. I heard a statistic that on these various dating apps that 80% of women set their height requirement for men at 6 feet. So if you're half an inch under 6 feet, you just never appear under their filters.
Let's see. Has Knuckles says it's nice to see the Law Pope and the Law Racks on a stream together. And of course, we can't forget you, Bronco. Thank you. Oh, I've heard big news of the day. Pope Hat is leaving Twitter. I mean, Twitter is really, it's really going to be less of a great place without Ken fucking White, the absolute loser of law Twitter, I guess. Pope Hat will be leaving. The reason I have a Pope Hat was literally to mock Ken White. That was the entire purpose. And
Is that why it was?
yeah, that was it. A guy who used to be a strong First Amendment supporter and free speech supporter in principle turned into an absolute bitch the moment Trump got into office. Like
He broke
many
so many people, man. Yep.
And it's like, dude, so good fucking riddance, Pope Hat. See you on Mastodon. Have fun there. I hope they greet you with demanding you say the N-word over and over until you quit and cry. What a chump. Oh, the fragility of these people. My favorite part is, I don't know if you guys are familiar with like these concepts of white fragility or male fragility that get thrown around on the liberal sides of Twitter. And then you get to them and they're like, Elon Musk bought my platform. I gotta leave. Someone said a word I don't like. It's like, you're talking about fragility. We're talking about like, when you're talking about like male fragility, we're talking about you can't get a job as a white male in some parts of the countries or in some industries, or you can't get into college. Like, they will not consider your application based on your race and your gender. And like, we're saying that that's a problem. And you're mad that someone said something mean about the Jews on Twitter, so you'll leave it forever in a huff and make a big public display about it. It's like, which one of those is actual fragility here, man? Like, you're worried about a word. People are worried about their economic future. Okay. Oh my God. It drives me nuts. Flamingo Key. How much of this can fall on police leaving the ranks due to all the fallout from protests, which leaves to inexperienced officers in that situation?
Yeah.
I mean, yes.
I mean, just look at the Chauvin case, right? So Chauvin had been a cop for 20 years, but the other 3 officers involved were all rookies. One of them, it was his first call out. In this case, this defendant was 1 year on the job and his backup partner was 3 weeks on the job. So what's happening is all this defund the police, all this BLM stuff, all these prosecutions, any cop who can is getting off the streets. Either they're retiring or they're taking academy jobs or headquarters jobs or public affairs jobs, anything to get off the streets. So they're not at risk of having to go hands-on with a suspect and find themselves a defendant in this kind of prosecution. So all those street cop spots are being filled by brand new police officers. And we're not going to get better decision-making out of brand new cops than we are out of cops who've been on the force 10 or 15 years.
When we saw that, and we saw that in George Floyd, right? 2 of the cops, the initial responding cops, very new to the force at that point in time. There was thoughts that Kim Potter was like recently on the force, but that turned out to be not quite accurate when testimony
or that she wasn't on the street very much, but that was not accurate either. She was on the street a lot.
Right.
But
So
mostly doing soft community relations type of stuff.
Right. But yeah, no, I mean, definitely when you have an exodus of officers and you also have some other things. There's been a lowering of standards going on in police work for quite some time due to various factors that are involved. And those factors are different in different parts of the country. But for example, in some places, you're not allowed to administer an IQ test, where they used to administer IQ tests for police officers and other jobs because IQ tests have been found to be racist by some people. So that determined a race-based factor in hiring, and that is unlawful under the Civil Rights Act. In some places, first responders, not just police officers, used to have to take a swimming test because they may have to do water rescues. Again, another thing that was found to be racist. I think that was down in Louisiana, which, interestingly enough, in Louisiana, lots of situations where you may need to do water stuff, but that was found to be a racist barrier to hiring. So that was a problem there. in other places, physical standards have been reduced because of female cadets not being able to pass. So those types of things have been going on for a while. What do we have here? We're gonna rebuttal expert in hearing is my guess.
Rebuttal?
Yeah, that's what I would guess.
Well, that's
I've
warming
seen
up.
this guy bring the judge that mug like 5 times now.
Gin. I'm hitting the 4 a.m. wall here, gentlemen, so I will be excusing myself to catch a few hours of shut-eye.
Always a pleasure, buddy. Thanks for coming on.
We'll see you
Take
soon.
care, Jeff.
Hey, I got a channel over there if you want to get to it. Legal Vices, that's me.
Jon.
Go check him out, guys. It's in the description.
It's an easy grift. Good night, gentlemen.
See you, buddy. But then those lack of the decline in standards, what I wanted to get to and round out that point, the decline in standards starts, but it's going to be only exacerbated by having lower and lower quality candidates because people aren't signing up to be police officers at the rate that they used to because they see what happens with all of their decisions. Maybe that's good. Maybe that's bad. I don't know. But it's going to require some policy changes at some point in some way to start mitigating these perceptions and mitigating these bad encounters. But we should say the overwhelming majority of police encounters don't involve anybody dying, like by a shocking degree. These are all edge cases. They're just in the public perception because when the state kills a citizen, everybody takes notice.
Absolutely, yeah. All right, outside the presence of the jury, we're doing this pursuant to Rule 705. Is the state ready to proceed?
Stage ready.
And defense is ready.
Yes, Your Honor.
Mr. Smith, go ahead.
Would you introduce yourself to the court reporter, please, sir?
Sure. It's Jonathan Priest, JONATHYNPRIEST.
Mr. Priest.
He's a
how are you
priest.
currently employed?
I'm a forensic analyst and instructor with Revel Gardner and Associates, which is a group of like individuals. We teach a number of forensic
His mic
courses,
is fucking hot.
nationally and internationally.
Jeez.
And so what does that mean to teach? Who do you teach classes to?
Well, we teach classes to those people in criminal justice system, law enforcement, attorneys, college students.
But the state couldn't bring one person from the actual police force to say what this kid did, what this defendant did was wrong.
There as well?
Yeah.
We do, and again, both nationally and internationally. Primarily, my focus is primarily the United States, dealing with a number of different disciplines.
And what do you personally provide? In what areas do you personally provide consultation services?
Death investigations, officer-involved shooting investigations, use of force investigations, procedures, policies, blood stain pattern analysis, shooting incident reconstruction, interview and interrogation, and just a little side of underwater evidence collection and documentation.
So, what did you do before you got a job with this firm?
I was with the Denver Police Department. I was there 32 years. 27 of those 32 years, I was in the homicide unit.
And what other responsibilities do you have at the Denver Police Department?
Well, I began as a police officer, patrol duties and things of that nature. Moved from there into the Vice and Narcotics Bureau, where I spent time doing that type of investigation. Moved from there to the Complex Vehicle Crimes Unit, where we did complex vehicle theft, cut shop investigations, and then into the Crimes Against Persons Bureau, which is where I began working in the homicide unit. I was promoted to sergeant, spent a brief time back on the street per agency policy, moved to the Internal Affairs Bureau, doing internal affairs investigations, moved back to the homicide unit as a supervisor, stayed there until 2000 when I was promoted to lieutenant and became the commander of the major crime section, which included the homicide unit, the sex crimes unit, robbery unit, child abuse unit, bomb squad, and our night shift. And I did that until I retired in 2011.
And what's your educational history?
I've got some college background. I probably got enough hours for a degree. I just never had a formal degree. Thousands of hours in forensic disciplines, death investigations, interview and interrogation, bloodstain pattern analysis, crime scene reconstruction, shooting incident reconstruction.
So, have you testified as an expert in officer-involved shootings before?
Many times.
And how many states?
32.
And have you done it in Texas?
I have.
And have you done it in Tarrant County, Texas?
I have.
Just this year, is that correct?
Yes.
What kind of training have you received to make you an expert in officer-involved shootings?
Well, again, as a police officer, my time in the homicide unit, one of our responsibilities was investigating critical use of force incidents, which included officer-involved shooting incidents. I was part of a group of individuals, myself and 2 deputy district attorneys, who created the investigative protocols for the Denver Police Department, which were reviewed and accepted as best practices from the Police Executive Research Forum, PERF, in how to do officer-involved shooting investigations. Those policies were reviewed back in the 80s by a group known as the Erickson Commission, were reviewed in the 90s by a group as the Park Commission. And although difficulties and issues were discovered, those were worked on, and again, our policies and procedures were found as best practices nationally.
Found by whom as best practices?
Erickson Commission, Park, and PERF, all 3 of those.
But who cares what his policies were? They're not relevant here.
Yeah.
The Denver PD policies are not relevant here.
And what other training experience do you have that makes you, as a use of force expert or a police officer involved shooting expert?
Well, police shootings, criminal incidents to begin with, and the basic crime scene investigative protocols that we get while we're in the academy. I've been through the Louisville homicide course. I've been through a number of FBI courses. I've been through crime scene courses all over the country in various stages. I've been through the force science course. I regularly teach in the area of officer-involved shooting and use of force investigations on a national and international level. I've got easily over 1,000 hours of training in areas of that.
Now approach the witness, Your Honor.
Had a mouthful
For
of
the
water,
record, he said
sorry.
yes.
Yeah, had a mouthful of water. Bad timing.
I'm showing you what's been marked State Exhibit 121. Do you recognize that?
I do.
And what is it?
This is my curriculum vitae. I don't know. It's probably pretty close to recent.
This time, Your Honor,
State of Office, State Exhibit 121 for purposes of the record. This hearing only.
Stage 121 is there for purposes of the record.
So whenever you go teach, discuss, or testify about police officer involved shootings and use of force, what type of fundamentals and principles are you discussing?
Well, a number of areas, certainly investigative areas, how to investigate those, how to look at the crime scene, what significant issues are related to the crime scene. Interviewing, how the interviews are done, the nature of the interviewing, the issues that may arise as a result of that. And then secondarily, from a tactical standpoint, how was the incident, how did it occur? Were best practices followed? How did they adhere to policy and procedure? What
This ought to be all nonsense, easily handled by the defense if they're competent.
what issues may be of a concern for
They
a
seem to
particular
be
policy
competent, but we'll
change or an
see.
educational
He's-
training?
This defendant's not charged with the crime of poor tactics.
Hiring practices and how we teach officers in the academy level when these types of incidents occur. Is this something that can be avoided in the future? Is this something where risk can be reduced in the future? So we would look at them from a number of levels in respect to that.
Yeah, and from that perspective, sure, this could be avoided in the future and this could be reduced in the future. The question is, under the current law, is he guilty? And it kind of looks like he's not. As shitty as that may be, this is a discussion going on in
Cross-examination?
my locals chat right now.
Hello.
How do you convict someone under law that doesn't support it?
Yes, sir.
What's your first opinion you're gonna do?
That there are a number of mistakes that were made in this particular case, that the officers certainly could have followed better practices in how they would approach the scene. That from a tactical aspect, there were difficulties in how the shooting actually occurred.
Okay, that's all one opinion?
With respect to that, yes.
What documents did you use to form that opinion or material?
I had the case file with respect to, I don't believe I had the entire case file, but I had a number of photographs, a couple hundred photographs of video, policy documents, statements, investigative reports, autopsy photographs, an autopsy report.
What learned treatise or other journals, scientific or otherwise, did you use to reference?
Nothing off the top of my head, mostly based on my experience, background, and training.
Oh, no.
I don't recall using any particular book to
They should
compare
disqualify him, or they should move to
my
disqualify him.
analysis to. Again,
He doesn't have a degree,
32 years of
didn't use any
experience in dealing with this sort of thing.
academic journals,
Do you
or
agree that your CV that was admitted doesn't have any of your 32 years of testimony on it?
Yes, that's just my CV. It's not my testimony record.
Is that something that's commonly asked of individuals such as yourself at trial or getting ready for trial so the other side can see what you've done?
When requested, I provide that. I wasn't requested in this particular case. I typically, for criminal cases, I'm not requested to provide that. Civil cases, yes, but I
I mean, don't get me
rarely am
wrong.
requested in criminal.
I don't
cases
think
to provide that
degrees
information.
matter all that much. This guy seems to
I
have
do not.
a lot of practical experience, but if I'm the
It's in my
defense,
computer, which is not here.
I'm going to be calling into question his,
It is.
Is this something you have an email from previous cases where you've been a civil expert that you could find the most recent copy? Like you don't have your most recent copy of your CV book, correct?
Again, it looks like my most recent. I don't know when I last updated the CV from the date that that one.
He just comes across as shoddy, but this judge has been letting everything in.
Other lawyers that practice law and civil practice, that you could get to that in your email from your phone and forward a copy to the government so I could look at it.
I can certainly forward a copy of it to you. I can't do it at this particular moment in time.
If it's something that would be on your phone, if you put it right into the email.
Wait, so the defense never had any notice of this guy?
I don't know who I would contact.
So you or attach that to an email that sends a.
he doesn't have his own CV.
No.
So how do the civil attorneys that retain your services ever get a copy?
I typically send it Dropbox or some fashion like that.
So is it stored in your Dropbox?
I don't have it on there. I don't have it with me. I don't have an ability where I'm sitting to get it at this moment.
What the hell?
Appreciate that. Since I built the computer technology in this building, let me ask the next question. If you have Dropbox, if it's stored in your Dropbox, you can log into that on anybody's computer. That's the nature of Dropbox. You agree with that?
I would.
So is this record of your testimony stored in Dropbox?
I doubt it.
Do you purge and delete stuff in Dropbox?
all the time.
Do you have another opinion you'd like to form? Elicit from the jury?
It depends on what I'm asked. I mean, if I'm asked, it just depends on what I'm asked.
Judge, maybe I ought to pass this back and let the state go through, but I'd like to know what his opinion is, what you base it on, what we're going to treat as other documents.
Yes,
A true set
of course.
Yeah.
He's just not allowed to come in blind and ambush the defense.
What's your opinion on how
How do you not bring your CV?
and Officer Darch approached the home on East Allen Avenue after being dispatched on the open structure call?
It was tactically inefficient and in violation of a number of the policies and procedures of the Fort Worth Police Department.
Could you elaborate on that, please?
Upon coming up to the open door, basically at this point, they have a point of entry to a home where they suspect that from their analysis that they have a burglary in progress. Once they made that assessment, policy and procedure tells them that they should back up and secure the location. So they should have called for cover, had additional people brought into the scene. That's not what occurred. Once they began doing the search of the house, there are a number of things that they could have done or should have done. Clearing the home from a tactical standpoint, they were way too close to the windows and doors as they're doing the search. Whitewash was illuminating.
Wait, I thought they
them.
weren't close enough to that side window.
They left vehicles behind them with a very cursory analysis of the cars. They went to a garage that they left pretty much completely unsearched. They moved to a backyard where now we're dealing with.
This is like the prosecutor's cousin just coming in to repeat all the claims the prosecutor made.
Closed gate to get into a secure backyard with no exigent circumstances that I saw. So from a tactical standpoint, at this point, they're not only going into a blind area through a closed wooden fenced yard, they're also violating their policy, their procedures, and it made zero tactical sense.
What about after Tatiana Jefferson was shot? Do you have any opinion on how the officers entered that home and cleared that home and trying to get back to the bedroom where she was laying on the floor?
I do.
And what are those issues that you have?
After she was shot, the officers both left that position and ran into the home with what appeared to be a goal of getting to her location. No one was left to cover her. I mean, an officer has just fired, put an individual down on the ground. We don't know a number of things. We don't know that she was actually shot. She hadn't been analyzed. We don't know that she can't get up, and we have an officer that states she had a gun. We don't know that she can't pick this gun up and now re-engage these officers. We don't know who else might be in that room, so the officer should have stayed there maintaining cover on her while the partner or other officers were brought into the scene to make entry into the home. That wasn't done here.
And what about actually clearing those rooms in the home?
Well, clearing, there was little, if any, clearance that was done. I've heard the statements about quick clearance. They looked in the rooms, was basically it. If you're doing a tactical entry.
So my
you
objection
don't
here,
need any
not a legal
unsecured
objection,
room
my
or
objection to
unsearched
this
room
process right
because
now is that
because
clearly
that's
we
not
know
the
from the
for any
prosecutor's
officers to move
questions
forward from that.
that he
Each
intended to call this
room
guy to
as
say this
they are
the whole time.
Going into the home.
And he never disclosed
should
this
be
expert to the
searched and
defense.
cleared before they move
Yep.
to the next successive room.
And what-
So this isn't a genuine rebuttal.
Background
he's-
training, experience,
He's not rebutting the
knowledge
this-
of
the
how
defense
officers
expert.
typically
He's just
would do a
going with the narrative of the
search
state.
a home, what officers do after they're involved in critical incidents, how they maintain security of the individual who is.
Because clearly this is
shot,
an
gets
ambush
shot,
expert on the
or
defense.
an
They've never heard of
individual
this guy.
who
They don't have his
technically they're
CV.
in custody.
He doesn't have his
Because when you
CV.
shoot somebody, you have seized them, so they are now under arrest from a technical standpoint, and you should maintain security of that individual.
Did you also base this
From outside the house? I thought they weren't allowed to go in.
before today?
The Forward General Orders certainly support many of the things that I've just discussed.
And also your training experience, have you testified to matters, these opinions, to similar opinions in other cases before?
Yes,
both in favor and against police officers?
Yes,
And the court allowed you to testify as an expert in those cases?
yes.
And again, just a summary, what are you basing on what are you basing these opinions on?
My training, background, and experience, and the policies and procedures of the Fort Worth Police Department.
We'll pass witness for the purpose of this hearing, Your Honor.
Mr. Brissett? Based on what you just told Mr. Smith, did you use any learned treatise or other documents that are published to form those opinions?
Other than the policy and procedure manual, no.
Did you review any documents other than the policy and procedure manual in preparation for your testimony today before this court?
Only the materials that were provided being by the district attorney's office, which I just mentioned.
Do you recall what date you were retained, your services retained for this matter?
Off the top of my head, I do not.
It wasn't last week,
No, it was sometime this year.
sometime in 2022.
Oh, man.
Do you have your notes where I could review your notes in preparation that you've made in preparation for this case?
I don't have any notes that I've maintained, no.
Come on.
Oh, my God.
You're in court this week, you haven't made any notes.
Other than what I've heard other witnesses talk about.
So those are some notes you made in preparation for your testimony today.
Not in preparation for my testimony, they're notes that I, from analysis of the witnesses.
What is
How's
this?
that not in preparation?
No notes in getting ready in discussions on how you're going to formulate your opinions in this case.
That's correct. Typically, I would write a report. I didn't write a report in this matter.
Disqualify him.
Asked not to write a report?
No,
Why did you choose not to write a report today?
didn't write a report.
So you mentioned no notes that you maintained. Did you destroy evidence and shred notes?
I wrote no notes that I destroyed. I made no notes in relation to this. I
This guy
reviewed
hasn't
the
provided,
materials,
they've provided nothing to the
provided my
defense.
verbal opinion to the district attorney.
Oh, this guy should be disqualified.
Your scene visit?
I haven't been to the scene.
When did you arrive in town from Denver?
Last Saturday, no, Monday.
When you've been here, when you were here for the Arlington police officer case, you didn't go down to the scene and take a look at it then?
I did.
So
I did.
You did?
you did?
For the Arlington police officer shooting, I did.
You went to that scene, but this scene, you didn't make a site visit.
That's correct.
Do you, as part of your testimony, you relying off of any measurements given to you by the Fort Worth Police Department?
I'm aware of measurements that were taken, but it doesn't have anything to do with the opinion that I'm going to be discussing today.
By the way, no, the jury is not in right now, guys.
Measurements to speak of. What measurements were you given?
I have a document that shows measurements of where the defect was to the glass in the bedroom.
Did you ever see you and I would refer to as a crime scene diagram, either the scale or not scale, that was a CAD drawing?
No.
And he's been there since Monday. So the state knew they were going to call him.
He was not hired last week. They said he was hired earlier in 2022.
Experience, is it 32 states?
32 years of experience.
How many states?
32.
That's an easy number to remember then.
It's very coincidental.
Okay, but what I can't do from my end, representing my client, is see any of the places you testified, because you don't bring the documents with you, correct?
I wasn't asked to. And I typically don't provide those, and I'm typically not asked to in criminal cases. So it would be unusual for me to provide those in a criminal case.
Remember, the
Say I
state
wouldn't.
had other testimony
ask
of the defense expert they could use to try to impeach the defense expert. They could prepare. The defense is not given the opportunity here.
Prosecutors over here, we'd like to see it.
I don't have it.
Well, no, I mean, I can probably go get it. It's take me a little while to do that.
No notes, no whip out pad, nothing?
No.
So when your final bill sent to the DA's office, it won't be for typing any notes or anything like that?
Right.
Just curious, what's your rate per hour?
Devil Gardner charges $295 an hour. I get 200 of that.
Does
Not a very
your
high paid
firm
witness.
Have a set of standard operating procedures that your firm follows?
We do.
All right, it's part of the best practices guide that tells how, I pronounce that right?
Devil Gardner and Associates, BGA.
Okay, your firm. Does your SOP at your firm, when you're doing critical incident research like this, require you to make notes and keep accurate records for billing purposes?
No,
What?
Does it prepare reports? Does it make accurate notes in all their cases?
no, we typically make reports. I typically do not write down notes. I write a report. I didn't do that in this case.
How do you write a report without writing notes first?
I mean, look, I did it in high school.
You just decided not to write it on your own. Nobody asked you not to write it.
Nobody asked me not to write it. I didn't write a report.
What the fuck is this guy's purpose here?
Write a report?
No.
Like, what is this?
Mr. Smith,
Nothing further for the purpose of this hearing, Your Honor.
any objections?
Yeah,
I'd like to see where he's testified.
just object.
I don't want to stop the trial, though.
No, just object to him.
Dropbox, if you got creative on Mr. Smith's computer or mine, you could probably get to it.
No, just
Stuff's in Dropbox. It's there. He's got a whole firm back in Denver that he works for, a big firm. They should have copies of his testimony.
All right, let's do this. Let's
But
take
just
about 10 minutes. You two lawyers get with him, see if we can figure this out and go from there.
May I put this on the record?
Yes, sir.
Mr. Priest's CV was attached to TSP on December 14th of 2021. He's been on the witness list for the state of Texas, I believe, at least over a year. And there's been no request formally or informally from the defense for any lists of prior testimony from the defendant or from the expert witness in this case.
Not assigning fault to anybody. Let's see if we can get over this hurdle. All right, we'll be in recess for 15 minutes.
Fascinating. Well, that's interesting. So
I'm
the,
just trying to figure out why they didn't just object. This guy, okay, he's got, look, I am not a CV snob, okay? I am not, and I know expertise comes from a lot of ways, but we're not talking about just general argument here. We're talking about, is this guy fit to be an expert witness in a criminal case where if your client is guilty, he goes to jail forever? 99 years.
but the
right?
state just said the guy's been on the witness list for a year.
Yeah.
So that makes it awkward to object now. I mean, I was assuming this guy was a genuine ambush expert that the
Right.
defense had no notice of. But if they had notice of him, why the F weren't they asking for all this before?
Maybe they just, well, they did say they wanted the most recent CV. Because, I mean, they got his CV is a year old. And he's clearly testified in cases since then. I mean, they just mentioned the Arlington case. So if they're asking for an updated CV, that's fine. But then, but let me go back, because I'm not talking about his CV, like the document specifically. I am, and your point is good. Why didn't they object to him earlier? But this guy has no degree. He's got enough hours of college to get a degree, but he never got one. I mean, yeah, I've heard that excuse from family members who will stay in college for 20 years and never graduate. Like, they have enough hours, but what hours? Like, what hours are those in? What college hours do you have that you just didn't close the deal and get the degree? And why not? That's a question. So next, he's got the only reference that he has is his own training and experience, but we don't know what that training and experience actually is.
Right.
And so he's got 32 years of that, but then he doesn't have any academic materials. There's no reference books. There's no, he doesn't have any other states' department reports, other states' general orders. He has nothing. No references here. The last guy was talking about a book by John Boyd. At least there's something there talking about tactical approaches to something. So what is he basing the opinion off of other than his training and experience? Is nothing. He has no notes. He has no report. He's reviewed no documents other than some documents related to this. They asked him for did they have the crime scene diagram from the state. No, he doesn't. He didn't review that. So what is his opinion based on? We still don't actually know. So why is this expert in court? What is he doing there? What particular special expertise is he going to use to rebut the other expert? And this is the whole purpose of a Daubert hearing. And in Daubert states, an unqualified expert doesn't get to testify. And so I'm just trying to figure out why they don't flat out object to him. I guess maybe it's the oversight of just not asking about him before that's making it awkward, like you mentioned. But
Yeah.
I think you'd go for it. Like, Your Honor, this guy's going to come in and say, well, my opinion is based on my opinion for the past 30 years, but no writings, no policies, no notes,
Yeah.
no observation of the scene, no observation of any documents about the scene.
The problem is the prior notification.
Yeah.
Because it begins to feel like invited error on the part of the defense, right? They could have
Right.
requested all this if he's been on the witness list for a year.
Yeah, no, 100%. But the argument, I don't know. It's kind of blowing my mind right now, though. Like, because again, invited error or not, I feel like the state should have the burden to provide this in a criminal trial. Just as a matter of course, they should. But I guess. That's that was a weird hearing. When he first passed him back, I don't know why he passed him back.
Yeah.
I would have objected then. The state had the opportunity to present this guy as an expert, and they've given me no reason to believe he has any expertise in this at all. He works for a firm that does this. I don't know what he does for that firm. State hasn't provided that. I don't know why the firm hired him in the first place. I don't know what trials that he's testified in, that because he testified about civil trials, or he talked a little bit about civil trials, talked a little bit about criminal trials, but we don't have it. It's the state's burden to produce those things, I would think, to qualify him as an expert on their direct. Because we've seen that in other cases that we've covered. During the state's direct, I'm always complaining about them going through the giant CV that their guy has because it's so self-serving, but then they don't do it at all. And now I feel like it's lost. I feel like Stockholmed into the CV review. I don't know. You've testified as an expert before, right?
Not in court. So all my legal practice now is as an expert on use of force law. But my deliverable is a very extensive report, usually a couple hundred pages long. And usually that's the end of it. It's weird for a lawyer to be called as an expert in court because
Right.
the legal expert in court is supposed to be the judge, listening to the arguments of the lawyers. So usually what I'm doing is framing out the legal narrative well before trial ever happens.
Right, as a consultant for the party or for
Right.
the party's legal team.
For the defense, of course.
Right.
I mean, I guess I could do it for the state, but the state's never wanted to pay me. So
Yeah. I just can't imagine, like, I can't imagine bringing your expert and not going through why they're an expert on your direct examination in a Daubert hearing. Like, I just don't get it. I'm befuddled by this one.
I mean, obviously, all we're going to hear is these superficial statements affirming everything the defense has said. I mean, sorry, the state prosecutor has said on his cross of the defense expert.
Yeah. Right. They're going to go through. But again, the problem with the bringing an expert who's an authority is he's going to come in and say these things. And the defense is saying, but I don't know why he's saying these things.
Right.
I don't know what, like, you could just grab a guy and bring him in off the street and be like, yeah, well, this guy says
There's no
this.
prep. There's no notes. There's no prior testimony in similar cases. And listen, if the defense had asked for that stuff and not gotten it, or if this was genuinely an ambush witness they had no idea could appear, that's what I thought must be happening here. But I don't know. At the same time, I think you're right. The burden is on the state to do this. I'm not sure the burden goes away just because the defense didn't ask for it.
Right. Okay. Like in other situations, if you're bringing the claim, you're the claimant, you have to lay out the basis for the claim. That's on you before the defense has to say a word, because you're the one bringing that thing. That's the whole point of the burden. And here, like, the claim is this guy is our expert, and they didn't lay the foundation for him to be in the courtroom at all. And I have a huge problem with that. And I've got a real problem with the defense now, not just saying that. All right, Your Honor, we're satisfied with his testimony, and we completely object to this person. We don't even need to cross-examine him because, frankly, they didn't lay foundation as for why the hell he's here. I'm glad that they paid him. I'm glad he sat in court and watched and didn't take them any notes and won't provide them any useful feedback. That's fantastic. Well, of course, they didn't get to that until later, but object then. Then make the judge say, well, why don't you cross-examine him first and ask some questions, see if you can answer those. You ask the questions. Did you take any notes? Did you prepare a report? Did you go to the scene? No. Okay, Your Honor. They didn't qualify him to be in here. And then his analysis, frankly, is unreviewable. So what's the purpose? We don't even get to look at his analysis and take it apart, and ask questions about it, because he's just going to spout it off here as a complete surprise. This is crazy. It's not how you do court.
Yeah. Right.
So,
I mean, where's his report that we could show to our expert? So our expert could tell us what's wrong with this report, right?
Yeah. Donna Tripp in chat says, why do you want them to lose? On this case, I have no investment in the outcome of the case. I am frustrated that a police officer shot a woman in her home. I think that is a violation of that person's rights by the state. For this guy, though, it's kind of unfair to put bad policy of the state on his shoulders entirely. So if he's justified in shooting it under the law, and this is what we got to in my locals chat, one of the last things I said about it, because I can't just keep engaging in discussion there, I have to be on the show too, is Texas likes its self-defense policy. Texas is proud of its self-defense law. Like, they're a state that is heavy on self-defense with a gun, particular. Like, that's part of the hype of Texas as a place. This guy followed Texas law on doing this. Now, of course, it's the state and they're in someone's backyard and they're shooting into their house. That's all bad. But on the nuts and bolts of it, if you strip away that he's a police officer, I guess he has to remain a police officer to lawfully be where he was. So that makes it kind of complicated. But on the nuts and bolts of self-defense law, the guy sees a threat and deals with it with a gun. And that is what Texas likes. So if he wins, I'm fine. If he loses, I'm fine. I don't particularly care about it. But what I do care about is the state, in this case, being the state, has a burden to prove something beyond a reasonable doubt, and they're not doing it very well. that should be a problem. Because imagine you're the defendant in Dallas, Texas, and the state's process here gets applied to you. You're not a former cop. You don't have all the deference that gets to go into that. You don't get what I call the blue bias from the jury, or the uniform bias, however you want to do it, from the jury, from the judge, from anybody. You don't get any of that. You're just a person. And then the state comes in, they call an expert against you on anything, and they bring this. You should be furious about that.
And I still can't help but wonder why the state doesn't just call someone from the academy in Fort Worth. I mean, someone who trains police officers, a Fort Worth trainer, to say, no, what he did was wrong. They haven't produced that. They had to drag a guy from Denver, Colorado down there.
Yeah. And it's like,
and they wouldn't have to pay a Fort Worth police officer, right? They wouldn't have to pay him anything.
They should be able to do that. They should be able to find one guy who says this is bad somewhere. I think. Surely one trainer is like, this did not turn out the way our training is supposed to have this turn out.
Right.
And that's some bullshit. Like, because we take pride in doing this, and this guy violated something. Even if he's the minority, even if he's the one guy, they should be able to have interviewed somebody and found him. Hey, who's the most skeptical and hard-ass trainer out there who would say this guy did a bad job? Oh, that's Eric? Okay, we'll go talk to Eric then. Like that. I don't know. This is weird. And yeah, why is this Denver guy commenting on Dallas policy? And why doesn't he just say, Yeah, well, actually, I compared it against the Denver police policy, and we found some things lacking in this policy, or no, we found it very similarly worded, but the intent in Denver and the way they actually follow and implement this policy in Denver is way different than how this guy did it in Dallas. And we don't think that there's actual discrepancy in police work. We think there's a discrepancy in how this guy did it. So, like, tell us how you're comparing this to Denver or to any other metropolitan police force that he may have testified about in his 32 states, 32 years of experience. Like, any of these things he could do, he's not doing that. So yeah, I'm just annoyed about the I'm annoyed with shoddy lawyering, and I'm really annoyed about the risk of the state getting away with bullshit. I hate that.
It doesn't feel like zealous defense of their client, right? They should have been outraged.
Yeah, right. And you wondering if they're going, oh fuck, how did we miss this?
They're also so low key. They're like, well, Your Honor, we don't want to delay anything, but it's it would feel kind of wishy-washy about this.
Big Papa War Machine says,
again, this guy could provide an excuse for the jury to convict, right?
Right. In theory, like, that's his purpose, is to be there to provide the excuse. Big Papa War Machine says, say it's Dallas one more time and I'm going to take my shirt off. It's Fort Worth. We got pride here being the sleepiest city in Texas. You're right. It is Fort Worth. My humblest apologies to the people of Fort Worth. I never meant to besmirch the good name of Dallas, I guess, or Fort Worth. Which one do you wait? You're from Fort Worth. You want it to be Fort Worth. Okay, there you go. The last time I drove through Fort Worth, it was during a horrific ice storm. Wait, that's not true. That was 2 or 3 times ago. And I mean, everything was in the ditch. I'm of course just driving because I'm from Minnesota and I have snow tires. So I'm going like 70 miles an hour and everybody else is careening off the road. Every RV you've ever seen was just in shambles in the ditch, just shredded completely. Trucks, because they only plow directly up to the shoulder in Dallas, in that area. They don't have they don't have enough plows.
Would you introduce yourself to the jury, please?
Sure, it's
Oh
Jonathan
gosh.
Priest.
Well,
Jon,
he's in.
ATHYN PRIEST.
And how are you currently employed?
I'm a forensic analyst and instructor with Bevel Gardner and Associates.
I'll be right back,
which is
since
a,
I heard this
forensic,
intro part already.
Educational and consulting group.
And where is that located?
Bevel Gardner and Associates, the primary offices are located in Oklahoma. We have instructors and individuals that work with Bevel Gardner and Associates around the country.
And where do you currently live? What state?
Denver, Colorado.
And you work for Bevel Gardner there in Denver?
I work for Bevel Gardner out of Colorado, yes.
Colorado. What do you do for Bevel Gardner?
Primarily, I teach courses in basically forensic disciplines, but I also consult on a national and international level.
What kind of cases do you consult on?
A number of different cases: homicide cases, officer-involved shooting cases, use of force cases, in a number of different disciplines with respect to those things.
And where'd you work before Bevel Gardner?
I was a police officer with the city and county of Denver in Colorado,
How long were you there?
32 years.
Could you give the jury a brief synopsis of your duties and jobs there at the Denver Police Department?
Certainly. I was a police officer again with Denver for 32 years. I spent time as a patrol officer. From there, I went into the Vice and Narcotics Bureau, where I did that type of investigation for a period of time, moved from there to the Complex Vehicle Crimes Unit of the Denver Police Department, doing basically that, complex vehicle crimes investigations. From there, I went to the Crimes Against Persons Bureau, where I began working in the homicide unit. I did that as an investigator, as a detective for a number of years, was promoted to sergeant. Briefly went back to patrol duties and then into our Internal Affairs Bureau, where I did internal affairs investigations. Moved back to the homicide unit as a supervisor. Stayed there until 2000, was promoted to lieutenant and became the commander of the major crime section, which included the homicide unit, the sex crimes unit, robbery unit, child abuse unit, our bomb squad, and our night shift. And I did that until I retired in 2011.
So what makes you qualified to offer opinions on officer-involved shootings?
During my time as a homicide investigator, one of our responsibilities was the investigation of officer-involved critical incidents, which included officer-involved shootings and in-custody death investigations. As a supervisor, I was responsible for the investigators' investigations of those incidents, and also responsible for many of the interviews of involved officers and the processing of the crime scenes related to that. Also, as a supervisor, I began working with our district attorney's office, where we created many of the policies and procedures for the Denver Police Department dealing with investigation of officer-involved critical incidents and officer-involved shooting investigations. That continued after I was promoted to lieutenant and became the commander of the major crime section, where now I have the responsibility over all the investigations related to officer-involved critical incidents, and did that again until I retired.
And did you mention the policies and procedures that you created?
Yes, I worked with the Denver District Attorney's Office. There was myself and 2 Denver DAs who basically created the investigative protocols for officer-involved shootings and officer-involved critical incidents, which included in-custody death situations and other uses of force that might result in critical injury or death.
What happened after you all created them?
Those were incorporated into the policy and procedure manual. They were reviewed by a number of entities. The Erickson Commission was one that's I recall off the top of my head. The Park Commission, which is a group of independent investigators that look at policies and procedures of police agencies in relation to their use of force policies and how they investigate use of force incidents. We also were mentioned with the Police Executive Research Forum as having policies and procedures that met national best practices.
Have you testified as an expert before in officer-involved shootings?
I have.
Few times or many?
Lots.
How many states have you testified as an expert?
Well, I've investigated cases in 32 states around the country. I believe I've testified in about that many.
And have you testified in Tarrant County as an expert in officer-involved shootings?
I have.
And when did you do that?
It was just earlier this year that I did that.
But in the same building, as a matter of fact, correct?
It was. I'm not sure if it was the same courtroom, but same building.
Are you a contributing author to any publications?
A number.
Could you tell the jury about a few of those publications?
I'm a contributing author. I can't remember the titles off the top of my head. I have the worst memory.
This should be in your CV.
A book on interview and interrogation dealing with video interviewing and
A book on it. Okay. Which one?
identification of suspects, witness identification. Also a contributing author in a photo book or a photography book dealing with shooting incident reconstruction.
What all did you review before testifying in this case?
Number of photographs, policies and procedures for the Fort Worth Police Department, autopsy photographs, autopsy report, statements, investigative reports.
Did you also take a look at Officer Darch's statements?
I did.
And were you present yesterday when the defendant testified
I was.
in the courtroom and you watched it all?
Yes.
Were you present this morning when Dr. Coons testified as an expert for the defense?
I was.
So You have some different opinions of from Dr. Coons of how Officer Darch and the defendant performed on the early morning hours of October 12th, 2019 at Tatiana's home on East Allen Avenue.
Some,
Let's just start at the beginning. How do you feel about the manner in which Officer Darch and the defendant approached the home on this open structure?
His feelings?
I think their approach
Yeah, Paul says
wasn't terrible.
he
but
literally
it
just
likely
testified in
could have
court.
been
He has
better.
the worst memory, but has no notes on the
they
case. I'd
Didn't have
hammer
an
that.
awareness of what was around the neighborhood.
You don't
They
remember what
didn't know
book
what
you
was
wrote?
across the street. They didn't know any movement of individuals that may be in or out of the house. They didn't pause to stop, look, and listen, although I know there were discussions about that. But anytime you're approaching a residence that you're unaware of what may or may not be going on, stopping, being
Wait,
quiet,
I thought they were supposed to be
looking, seeing what's
inconspicuous.
around
Now
you,
they're supposed to
what-
stop
what
outside the house
areas
and
of-
look and listen.
not only danger may exist, but what areas
also
of
supposed to
egress
announce.
do I have? Where
Oh,
can
who
I
knows?
go? What areas of cover might be available for me? And then listen. Are there any noises? Are there any sounds? Any yelling? Any talking? Anything like that that's going on? I didn't hear any discussion about that's one of the steps they took. So that's certainly something that could have been done better if it wasn't done. Again, I didn't see anything that supports that it was done.
What about when they
So he doesn't even know if it was or wasn't done.
Well, when they get to the front door, the door is open. So at this point, they basically have a couple of choices. One is that they simply back away, maintain cover on the front of that house, call for additional cover to come in and assist them in securing the location so they can do a search. The second one is to basically knock and announce. So those are the two basic choices that they have, neither one of
I
them.
mean, they have a third choice, which is to continue the investigation.
Is that true?
Yes,
Well, would you be, if you reviewed the general orders, would you be surprised? Did you see Dr. Coons testify this morning?
I did.
What do you have a different opinion about how Dr. Coons feels that that these officers are cautioned about announcing themselves?
Well, I heard the use of the word be cautious. Well, you can certainly be cautious while you're announcing your presence. I mean, you're there, you're wearing Fort Worth Police Department uniform, so you're visible. You're standing in front of the door looking in. So if somebody is in there, secreted or not, there's a good possibility they're going to see you. So it's not like it's a big surprise that somebody's outside the
Secreted,
door.
sir.
But they're being
Secreted is
cautious
different
in
and
that they're
gross.
standing outside. They're maintaining quiet tones. They're not making a lot of noise at this particular point. And even knocking and announcing now, I can still be cautious while I do it because I can be aware of what's going on inside the house. I can see the house and make decisions about where I'm going to go from there.
In reviewing the general orders, did you see anything about an open structure call that's told officers specifically not to announce their presence at the call?
No.
So that option was there.
To knock and announce, absolutely.
And so after they didn't knock and announce, they moved to the second door. Well, do you have any more opinions or feelings about how they walked past the first door as it is a fatal funnel?
Well, again, best practices, two choices: knock and announce, back off, call for cover. Those are the two main things. Once they begin moving around the house, the problem I have with this is how close they are to the house. They're in the light wash of the light that's the ambient light that's coming out of the house. So they're easily seen at this point. If I'm going to walk around the house,
Wait, are
I'm
they
back
supposed to
off.
knock on the door without getting close to the door?
Means that I'm maintaining some level of security.
Apparently.
If I want to search this place, I want to do it from a position of advantage and not hugging the walls and risk the possibility that something bad could happen there.
So did they hug the house on the way to the second door?
They were very close to the house. And the fact that they're in the light wash is one. Hugging walls is never a good idea when you're doing searching anyway.
I thought they were criticized before for not getting close enough to the window.
Give you a position of advantage.
What do you mean by light wash?
We have the ambient light that's in here. Any of this light that is shining out into a darkened area is going to reflect off of you. So it's going to basically
Wait.
give you illumination that you
To be away
wouldn't
from the light
necessarily
wash, you
have
got to
if
be
you
close
sat
to the
outside.
fucking wall, though.
And why is that important for an officer to realize?
Again, goes to that cautious, and it also gives you the ability
Yeah,
to
the
be,
defense ought to have no trouble with this, but I've lost
give you
confidence
that
in the
time
defense.
delay. That if the people can't see you, they can't react to your position.
Yeah, the Iceman, this is a rebuttal witness.
What about when they get up to that second?
Defense
floor?
rested.
What's your opinion about how they encountered, investigated that second door on the side of the house?
Well, again, when they move up to the door, they're right there. They notice that there's some damage to that door, which suggested to them, or at least what was being stated, is that there may be indications of forced entry. So not only have we found an open door, but now we found a door that may have evidence of forced entry. So at what point are we going to stop and secure this? By leaving that first door, I now have an entrance and egress point that is left unsecure. So if somebody is inside that house, they now have a way to get out. Not only get out and get away, but get out and get behind me. So there are some problems with leaving that front door unsecure. Coming up to the second one, they're now again hugging that area, making no indications that they're going to do any kind of knock and announce at this point.
Well, whenever the defendant testified yesterday, you heard him talk obviously about the damage to the screen. Did you also hear him mention the screwdriver?
I did.
And why did he mention a screwdriver?
I think as a means of causing the forced entry or attempting forced entry.
And again, what did the general order say when an officer at an open structure call believes there's evidence of a forced entry?
Call for cover and secure the location.
That they shall do that, correct?
Shall, which means do that.
But did they do that after they encountered the second door?
No.
And what did they do next?
Next, they moved over by the cars, stated that they shine lights inside the tinted window cars. The difficulty there is that even shining a light inside those cars is not going to give you an indication that there's no one in there.
Wait, what?
There are a number of areas in cars that people can lie on floorboards and can lie down in the footwells. of
The glove
cars.
compartment.
Certainly, you can get into the area of the ridiculous, but there are a lot of
You're
areas
already
that you
there,
can look
buddy.
inside cars, and that brief cursory search, for me, and in my training,
Maybe they're
was not
hiding
the
under the seats.
indication that car is
It's not
clear and
Anne
secure.
fucking Frank, man.
I
It's
don't have
gonna be
any
a
information
full-grown
or any knowledge
person
that they checked
sitting
to
in a
see if the
fucking
trunks were
seat.
ajar, to where they could open those, that they checked the doors to see if they were locked or unlocked. Nothing like that. So now we have another point where there's the possibility that somebody could be secreted in those cars.
What about underneath the cars? Isn't that another place to hide?
Well, sure, under the cars, around the cars, in the blind spots.
in the trees like Charlie.
What about when those officers walked over the lawnmower, weed eater, and that? You heard that testimony yesterday?
I did.
What significance did that testimony have for you?
Well, again, there were a number of things about this house that it could just be a messy house. The fact that the lawn equipment is out there in the driveway area could be the result of a messy house.
So they haven't
The
determined
fact
it's a
that they're
burglary
seeing
yet?
it and making the leap that maybe the burglars are piling the stuff up for easy access to load into a truck or a car or whatever and get away would tell me that, well, where did this come from? The logical assumption would be the garage.
So if that's a logical assumption, what should the officer's next step be?
Well, not only go look in the garage based on that,
Yeah,
but
they're
the
supposed to
fact
call
that they're
for
going to be
backup.
walking by the garage, touching the garage, be
You just
near
made the
garage,
argument why they shouldn't
there
have
should
called
be
for
some
backup.
search of that garage. It's on the way. I don't want to leave that behind me, so there should be some analysis of that garage.
And again, while they're moving, where are they moving farther and farther away from both the defendant and Officer Garch if they keep heading towards that back gate
That front door, the open front door.
and the open side door?
Correct.
And how do you feel about them moving farther away from the two open doors in front of this house?
Well, I don't like that at all. My opinion.
What's
is
the
that
relevance of all this? Because none of this killed the
they
victim.
found that open door. If they're not going to knock and announce, back off and maintain security on that front door. That's where they should have stayed.
I don't
so
know.
the further away they get from that, the more difficult it becomes for maintaining security of the individuals who may be inside that house.
What about that window that's there on the side of the house that Dr. Coons missed earlier today? What's your opinion about how they treated that window or searched that window?
Well, depending on what it is that they're actually looking for. I mean, they say they're looking for signs of forced entry. Typically, signs of forced entry can be seen from a distance. I don't need to go up and do an actual tool mark investigation. I don't need to.
Wait, I thought they were supposed to go up to the window.
I see an open door. So could it be kicked open? Sure. Could it be jimmied open? Sure. Do I need to go up and look at it for damage or anything of that nature? Maybe I do, maybe I don't, but it's open and it meets the criteria of the reason I'm there in the first place. Now
Which is
I'm
an open
looking at that
structure, not a
window that's just
burglary.
down from near that lawnmower area. I can look and I can see that from my position, whether it's broken or unbroken. So I'll know if it's an entry point or not just by looking at it. But there's no indication that that was acknowledged. If I want to look at it for more detail, then certainly I need to get closer to it.
Okay, so now back to the garage. You said search the garage. How are they going to search the garage with the garage roll door down and the walk-through door closed?
Well, you can open the walk-through door. I mean, you can certainly do that or push on it to see if it's locked. But again, it's just like clearing a room. If I walk past this door, I'm leaving that danger point behind me. It is now a point where somebody can come out of that door and cause me harm.
So when they get to that gate, how many danger points have they left behind them?
Well, you've got the front door, you've got the side door, you got the cars.
Don't forget the adjacent buildings,
Eventually that
the sniper
window,
nest.
I don't know about that. And the garage, if we don't go into the garage.
What about the people across the street? Aren't they a danger point? Maybe they were robbing the house and saw you coming and ran across.
They approached that gate.
Yes.
That gate, that structure there with the side of the house, if you're standing facing the gate on one side of you and that garage on the other, was that a safe place for Officer Garch and the defendant to be?
By the gate?
By the gate with those little walls on each side being up against that gate.
Well, yeah, you're basically in a trapped location. You have nowhere to move to at that point. If somebody were to come out of the house and toward them, they really don't have much of anywhere to go. I mean, they're kind of stuck in that point. So it's
Did
a
they
bad
remain
position to
there
be
or
in.
move
It's almost
through
like
it?
a blind alley.
They moved through that area.
The defendant entering that closed gate at the home of Tatiana Jefferson.
Well, it's a secure location, and it's basically I'm doing a warrantless search at this point. I'm about to open that gate
Objection.
and go into an area that
Legal
is
conclusion.
fenced and secured. It would just be if my front door was closed, it would be the same thing, opening my front door and coming in. It would be the same sort of thing. We're basically
Actually
doing a
not
warrantless search,
at all.
and
the
there's no
same thing.
identified exigency at this point.
Okay, what do you mean by identified exigency?
Well, like was discussed earlier, the Fourth Amendment requires probable cause to do a search and that a warrant be obtained to do that based on that probable cause. There are exceptions to the search warrant rule, fresh pursuit, plain view, emergencies, and exigencies are some of those. An exigency would be one of those where I need to act right now, okay, because the evidence could be destroyed, somebody is in trouble, which also falls into that emergency.
The burglars could flee.
If I don't act now, people could be hurt, people could be injured, people could die. Nothing has been identified here at this point that exigency or emergency existed.
So wasn't a good thing for those officers to go through the gate.
I don't see why, well, again, I don't know why they leave the front door.
So a burglary in
But
progress
going
is
to the
not an
gate
exigency.
only exacerbates this. It's now putting them into an
It's
enclosed
insane.
area. But they have to open that gate if somebody's back there. It's problematic.
And again, with them in that backyard, who's covering the front door?
Nobody.
So anybody from the front door can go left and run down the street.
Yes,
They could also come back around to that back gate, couldn't it?
yes.
So was that a safe action by these officers to do?
Yeah. Again, my opinion is they shouldn't have left the front door.
It's also
So
really important to
anything
point
after
out
leaving that front
that
door
exigent
creates
circumstances
potential
is
risk
an
and danger.
exigent. It's an exception to the warrant requirement for a search or a seizure. No one is being seized here, and no evidence is being presented for search.
Do you have any opinions about how the defendant approached the window in the backyard?
He's coming straight at the window. He had room to move off to his right and approach that window at an angle to go up if he's going to take a look in it. But again, they're looking for forced entry. It's a simple process of looking at the window and seeing if it's broken or not.
Well, they did that.
Straight towards that window.
Well, I can't see what's inside there, and that's evident by the use of the flashlight. So I don't know what's in there. The person that's inside that darkened room is at a point of advantage. I'm outside, I'm shining my flashlight. I'm at a point of disadvantage because I'm letting everybody know where I am. So if somebody is inside that room, they're going to see me. I'm not going to see them.
Well, you bring that up about the flashlights. Was it a good idea to use the flashlights to clear the cars, the driveway?
You could shine the flashlight inside the car. There are ways to do that without bringing a lot of attention to yourself. Put the flashlight right up against
Really?
the glass, turn it on. You know, rather than
Really,
trying
that
to
doesn't
be
illuminate the
outside,
entire
shining it
interior of
away
the car.
from glass, you get that reflective glare, which can limit your ability to actually see into the car. Putting the flashlight right up against the glass and turning it on illuminates the interior. So I don't really give anybody outside or behind me or around me indications that I'm using it, and I can now see inside the car. Using the flashlight to look inside the car, I don't have a big problem with. The way that it was used, or at least the suggestion on how it was used, being away from the car, created difficulty actually seeing into the car itself.
You're supposed to stay away, and you're supposed to be
away from
close. You're supposed to go fast, supposed to go slow.
Flashlight in the dark, what's it telling everybody around it?
Well, exactly. That's why you have the intermittent button, because I can flash it if I need to. But every time I do that, I'm giving away my position. So
Only to an
if it's not
observer.
completely necessary for some safety need, I shouldn't be illuminating that at all.
The safety of someone maybe being in the car that you've said is a death funnel.
Safety was the primary concern, is
You're supposed to clear the garage, but not clear the cars.
that right?
Agreed.
So, do you have any opinions about how the officer, I mean,
Well, a competent defense should shred this guy on cross, but
They should torch him. The fence hasn't been actually.
Well, once movement was perceived
The only
in
good
there,
thing they did was hire that
he's
last
describing
expert.
it as a silhouette. Why we're not moving out of the line of fire? You maintain a position right in front of that window. Move off to a position of cover or concealment. You know, get into a position of greater safety and less risk for them to limit the ability of that person to see you or to identify your position.
would that have been a good time to also maybe alert the silhouette you just saw and you report police?
Well, I would certainly be identifying myself as police officer at that point to let them know, because I don't know who this person is or if it's a person at this point. It's being described as a silhouette. I don't know if it's a human silhouette or not. I don't recall, but a silhouette.
It's a dead
As
person
I'm
now, you
moving,
weirdo.
I'm likely going to be producing my firearm and pointing it in that direction. I would agree with that tactic, but I'm also going to be announcing who I am and what my presence is.
What about the moment that the defendant actually shot Tatiana Jefferson?
Again, I'm not identifying the threat at this point. Looking at the video, I only have the video to look at. I don't, and video certainly is much different than what people are able to see. I don't know what the officer sees. I know what he says he sees, but I don't have the ability to support that conclusion.
Where's your contravening evidence then?
Right.
Like, you have to prove this beyond a reasonable doubt. If what the officer sees is true, there's reasonable doubt.
So there's all, you've heard us
So
talk
how do you
about
go
how
around that?
that these officers had an opportunity to maybe reach out to dispatch, have dispatch get more info, or have dispatch put the caller in touch with the officers. Have you heard that testimony?
I have.
By the way, he did say it was appropriate for the officer to draw his weapon and point it at the silhouette that he can't
Well, no,
identify as a
again,
threat.
We don't have an exigency. We don't have an
Insanity.
emergency. We're not in a
But not
rush.
shoot.
This isn't a race. We're not getting paid by the hour. I don't know why we.
They're literally
Somebody
getting
aside might
paid by
be-
the hour.
We're not just taking our time.
Yeah.
I go back to, and I keep harping on this, I don't really understand why they left that front door.
I hope the defense
Back
gets up.
off
Do you
and
think
call
cops
for some
aren't paid by
assistance.
the hour?
Or knocking it out.
Overtime
Those
is
are your
really
two
important.
Best choices at that point.
And Mr. Priest, are you getting paid by the state of Texas?
I am.
State of Texas being the Tarrant County Criminal Liaison.
Yes.
And are we paying you as a consultant and as a testifying expert?
As a consultant, yes, I don't charge for testimony.
Okay. And what do you charge per hour?
It's $295 for Bevel Gardner. I get 200 of that.
Do you promise one particular opinion or the other?
I do not.
Have you testified for both in favor of police officers and against them?
I have.
Just get up and ask him the names of the cases he's testified in.
Cross-examination.
Thank you, Your Honor.
You said you testified in both. Name one of each.
And telling the truth, testimony is all about telling the truth, right?
Uh-oh.
Yes, sir.
The truth is what matters in the courtroom. Would you agree with that?
I would.
Any doubt of that in your mind?
No.
You've never said otherwise. Go ahead, you're gonna have to tell the jury eventually.
I've done programs, done training where the truth is not always what matters, but what that's talking about is it's what can be proved, what is not necessarily true.
Okay?
And
Let's
so
talk about what can be proved. When I asked you at a break, if you've ever emailed your testimony records to people, you say you've never emailed it. And I can produce an email from your Comcast account, that would be something that you didn't tell the truth about.
Holy fuck.
no, I don't have any email. I think the question was, do I have any emails with that document on it? I do not have any emails with that document on it.
Sir, you said you always mail it, you never email it. You recall that?
So you Dropbox it.
I don't. I know that I send things through Dropbox. The question, as I recall it, was, do I have any emails with that testimonial evidence in it? And I said, I do not.
Is police work dangerous?
It is.
Are police officers trained to make rapid observations and assessments?
I can't hear him at all. What did he ask?
Is police work dangerous?
Train-
Are police officers
observation
trained to
training. I
make
know that there's
rapid
a lot of
observations and
discussion in
assessments?
Police work about being a trained observer. And I never once recall going through a class on observing, but through experience, you become aware. And law enforcement officers need to have an awareness about what's going on around them.
I can't boost the attorney, guys.
Awareness comes with experience.
I wish I could.
It can, and depends on what your overall life experience is as well.
And you understand the standard when you're looking at a police officer's actions is what the officer knew based on his training experience at the time, right?
It can be.
Well, it can't be, we can't substitute your 32 years.
Subtitles are on. The court can't hear him either. Or the stream.
It depends. What is it that we're comparing? Are we comparing apples to apples, or it just depends?
getting at on this, you understand the case law in this area, yes?
Yes,
Okay? It's what the officer knew at the time he made the decision to shoot, correct?
at the moment the shot is fired, that's typically when shootings are judged from, is at the moment force is used.
And it's what leads up to that. We don't get the Monday morning quarterback like we're doing here.
Oh, that's true.
Okay. Does police work involve a balancing of risk?
It can.
When on a call, does a police officer need to trust their partner?
Certainly trust is a big part of working in scenes or investigations.
Should a police officer on call assume that his partner is following their training?
Should a police officer on call assume the partner
I
is
would
following their
expect it to.
training? I'll try this.
Officer has to rely on his training to deal with those risks, those inherent risks of being a police officer.
Does an officer have to rely on training to deal with risks of being a cop?
If an officer fires a shot while on a call, is it reasonable for his partner to assume that the officer has seen a threat that requires a response?
No.
If an officer fires a shot on a call, is it reasonable for the
When
partner
an
to assume it was?
officer is
there was a threat.
using deadly physical force,
He said no.
They are required to articulate their reasonableness for the use of that force. And what I
On the
see
scene?
is not necessarily what my partner might see, and I wouldn't assume that my partner
Well, that's fucking bullshit
knows
right
what
there.
I saw. Meaning that if I discharge my firearm, doesn't mean my partner is going to say, oh, well, they must have been reasonable in that use of force. If they saw the same thing that I did, then I would expect a similar response from them. But
This is
the mere fact that I discharged
insanely
my
stupid
firearm doesn't
answer,
mean my
in my
partner
opinion.
should necessarily agree with that use of force.
Nonsense.
Let me ask my question again. Maybe I got it wrong. If an officer fires a shot while
If an officer fires a shot while on a call,
to assume that the
is it
officer
reasonable for the partner to assume that the officer
No.
perceived a threat that required a response?
Okay.
And I could go through case after case of where an officer discharges their firearm.
No.
There was
The
no
question isn't,
reasonableness
was it
for them to
justified?
discharge the firearm. Why would my partner believe that they were reasonable in that use if they don't see that information?
Do good officers sometimes deviate from the general orders?
Yes,
Do good officers sometimes deviate from general orders?
can be.
Is there generally good police work to evaluate the facts of a call before making decisions as how to proceed?
Yes,
Does a burglar, whether in this state or Colorado, have an expectation of privacy in a structure he's burglarizing?
no,
Does a Texas peace officer have the authority to enter a private property to investigate a construction call?
I don't know the answer to that.
When you
Oh,
direct it was okay to raise the garage door, and go snooping around the garage, but it's not okay to go in the backyard. So how do I differentiate those two, sir?
Insane.
I said secure the garage door, check the garage door.
No,
to
you
see
said
if it's
open it.
closed, and see if I can push that door open.
If you push the door open, opening a plane of a structure is like Emmitt Smith crossing the ball across the goal line. As soon as you break the goal line, you've entered the structure, correct?
Yes.
I
Yes.
see the argument.
You see the argument. Yes.
That's the next question.
that's what breaking and entering is.
Call it in the state in Texas. So burglary of a building in Colorado, probably pretty much the same as burglary of a building in Texas, yes?
Pretty close.
So if you break the plane, the ball breaks the goal line going in, you stick your hand in somebody else's vehicle, that's burglary of a motor vehicle in Colorado or Texas, correct?
Yeah, I would agree with that.
Okay. So we have some inherent risk. On direct, you say it's okay to go look around in the person's garage, but it's not legal for Dean and Darts to be in the backyard. Is that what I'm understanding?
No, I didn't say that it was okay to go looking around inside the garage. I said it was okay to clear that garage to see if that
You should
door is
open the
open.
door
If I can push that
and
door
look
open
in.
to see if that's going to be a threat to me.
Well, how do I clear a garage without going in it?
Well, I want to make sure that I don't have anybody behind that. The same thing that I'm doing when I'm looking inside that car. I want to make sure
Remember,
there's nobody.
a quick
hiding
look in a
there
room
around
wasn't
there.
clearing a room, according to this guy.
I'm going to back up just a little bit. if I were doing this scene, I'm not going to be that far anyway. I'm going to be staying at the front door. I'm not going to get to that point. But if I'm going to be doing those areas and that garage door is now behind me, I'm going to make sure that I don't have a threat there.
But if you're staying at the front door, aren't you leaving the back door unguarded?
Theory of
Yes.
police policy, if they see an open structure, a priority to call, that's a two-person call, should go to a 4 or 5-person call for every call.
I'm saying that if I get to that location and I got an open door, then I have two choices. One is to back off, call for cover, and secure the location like the policy says, or I knock and announce. Those are my two choices at that point. Walking around the house is not at the top of my consideration unless I have an emergency or an exigency.
Would you agree with me that the alphabet still goes A, B, C, D?
Yes.
Okay. You keep harping on D, but you jumped over C in this little standard. The unit in charge shall call and inspect the structure to determine if there's any sign of forced entry. That's before backup and secure. Would you agree C becomes before D?
That's not true. When you look at silent alarm, the number 2 thing is to back off and secure. And then the next one is to look for signs of forced entry.
We don't have a silent alarm. I'm kind of, unless they're using that colloquially. Yeah, guys, I don't have a way to boost the attorney and keep this guy from blowing your fucking eardrums out. So
Right.
I'm trying to balance it best I can.
I know outside the presence of the jury, you take no notes. Can you tell us what version of the general orders you looked at in this case? What rev version it is?
I don't know.
So
It was the ones that were sent to me by the DA's office.
So you don't know if you looked at a complete set of general orders?
I can't tell you off the top of my head.
Well, since you have no notes, what parts of the general orders did you look at?
I looked at the ones dealing with silent alarm, burglary of a residence.
I'm going to show you what's been marked for identification purposes as Defendant's Exhibit 49 and direct your attention to 327.0 found on page 247. And I'll purport to you that I got this from the city attorney's office. And you see the word silent alarm in 327.
That's correct.
Okay. So you have A and you have B, correct?
Correct.
Okay. Am I wrong that we don't have secure the premises right there at the part?
All main exit ways should be guarded to prevent escape from the prisoner. That's secure that location. All main exits. So that's secure that location.
Take a look at D. D is what you've been harping on, is it not?
No, this is looking for signs of forced entry. I'm talking about secure the location. That's what this number 2 is secure that location. Guard those entry and exit points.
Okay. What kind of vehicles were in the driveway?
2 cars.
What kind? You said you got to look on the floorboard to find somebody hiding on the floorboard and do a detailed search. You've studied this case. How big are the floorboards of those cars to find somebody secreted down on the floorboard?
Secreted.
Well, the time that they spent at those cars didn't suggest to me that they did any kind of thorough search at all. I don't know that they checked the trunk lid. I don't know that they looked clearly on the floorboards. The time that it
You
took
don't
for them
know.
to go by there, I don't see that they could have done any kind of search, no less a detailed one.
Based on your notes that you have, how long did they spend at each vehicle?
It wasn't long based on the body worn camera footage.
All right. Signal 56 says you treat it like a silent alarm, correct?
Correct.
And if it was an audible alarm in the general orders that you have here, you also treat it like a silent alarm, correct?
Correct.
Because you've studied that before.
Yes.
This case is not the first case that you've seen those general orders, correct?
Correct.
And the city of Denver has the same type of general orders, roundabout so. The general orders are in every department in the U.S., yes?
Yes.
You've been to 32 states. Department of Justice has their general orders. Yet people deviate from general orders every day, correct?
Of course.
Denver's had general orders for a long period of time.
Yeah.
And when officers deviate from general orders, they do it and they have to stand for it and be able to answer and be accountable for their actions. You'd agree with that?
I would.
And even if they're doing stuff, I believe that the state has asked a lot of questions of folks that people should just go up and try the door. The front door to see if the door opens. You've been here long enough to hear those questions, haven't you?
I have.
Do you remember a patrolman by the name of Robert Eugene Sandoval? You do, don't you?
Name sounds familiar.
The Denver police officer was shot by a homeowner and died years later of his injuries because the homeowner was startled when he grabbed the storm door during what they thought was a break-in when the officer showed up to check it, correct?
Yes.
So there's a reason, even from your own department of 32 years, that people don't touch those doors and make noise like that because they can get shot, correct?
They can.
Now, we talk about being inherently dangerous work as a police officer. You know, and she may have been in your academy class, Patrolwoman Kathleen Garcia.
I know Kathleen well.
And Kathleen was tragically killed while sitting in her patrol car in her front yard at the end of the shift, correct?
No. She was killed in her front yard by a neighbor. She got in an argument with him and was shot and killed with her own gun in her front yard.
Things can go south for a police officer really quick, correct?
Absolutely.
It's an inherently dangerous job,
It is.
and they have to make split-second decisions as they go through stuff. Do you agree with that?
I would.
You know Patrolman James Edward Weir?
Yes.
You talk about positions of concealment. Even if you take concealment, bad things can happen to officers, correct?
They can.
Officer Weir was killed when he had to move from a position of concealment. He was shot, correct?
He was.
And he was also with the city of Denver Police Department.
That's correct.
Did y'all have training procedures and policies in place when those officers were killed?
We did.
The window that's by the Bravo side door, the B side door, it has a Weber grill in front of it. Do you recall that?
Yes.
And the Weber grill looked like the lid was still on it. Looked like if you had to get to the window, you were going to have to go over a bunch of stuff to get there. You agree with that?
I would.
So a quick scan of that, you could probably rule that out just by looking at it. I think like you said on direct, you're at the B door, you look down there, out of the corner of your eye, there's a bunch of stuff in the way. If somebody's getting in and out of that window, that stuff's still intact. You could probably rule it out based on that.
And I pretty much said that
Okay.
myself.
Are officers always required to knock and announce?
Always required? No. Well, it depends on the situation, but in every situation, no. In some situations, yes.
What would be some situations where you think they have to knock and announce?
Execution of a warrant?
Okay, how about on a silent alarm or audible alarm?
Not necessarily.
How about on a signal 56?
Not necessarily.
I'd like to give you a hypothetical. Can I put some board here?
Yes.
It depends on what he's going to do.
Okay.
Instead of a rear window, what if I make it a garage? And with the garage, I'm gonna make it an audible alarm. The garage is open, audible alarm, it's 1 a.m. And I got 2 rookies.
₹2.
Alarm though is not at the house where the garage is open, it's at another house and they go to the wrong garage. Okay? You with me so far?
I'm going to try to be.
Okay.
Want to take notes?
You go to the wrong garage, wrong residence, and walk up on somebody in the garage. Okay?
Okay.
With me so far? They walk up on somebody and that person comes out of the house with a gun. If the officers are dispatched on an audible alarm call from alarm center, do the officers have a right to be there in that scenario?
Yes.
It's not that hard.
Can the officers go to the wrong house and they can certainly articulate the reason they were there? Do they have a right to be there? I suppose they're investigating a case. They believe they were at the right location. So I imagine they have a right to investigate what they think is the right location.
Yes, they do.
I'm sorry, I didn't mean to pick up. Please finish.
It's a controversial thing called good faith exception, but they have it.
The fact that they go into the location, they believe it's the correct location. Anybody they encounter, they certainly can deal with that individual at that time.
What do you mean by deal with it?
Well, it depends on, how they're going to challenge this individual. I mean, I think you said that the individual has a gun.
Yeah,
Okay, some of this has sounded familiar.
it is familiar, isn't it?
Uh-oh.
It sounds like another case that I looked at.
It's a case where you justified the shooting by a Fort Worth officer of a homeowner that pointed a gun at the officer and didn't follow the officer's commands.
Correct,
And you testified under oath in that case.
I did.
And you said the officer's actions were justified when the homeowner, who the officers didn't know at the time was the homeowner, brandished a weapon at the officers. He raised the gun up and the officers shot him.
Correct,
They went to the wrong address. They walked up on the property. They had separated at one point. One officer stayed up front, as you recall, yes?
yes,
And one officer
Whoops.
was in the back by himself.
yes,
The second officer came running back to the back of the garage when he heard his other fellow officer giving commands. And they weren't Fort Worth police. They were show me your hands type stuff, right?
correct,
Because officers usually visualize what they're seeing as the stimulant against them, the weapon.
correct.
You've worked in 32 states and taught around the world on police shooting. The officers don't usually fall back to their full vocal training. It's
You're
usually
torching
very
him on
bad
this.
words and what's in the hand, or I want to see, correct?
And sometimes there's no sound. Sometimes they say nothing.
Okay. Is there, the officers, each person you would agree reacts differently, yes?
They can.
In that scenario, the officers gave commands, the individual raised the weapon, and the individual was shot.
Correct,
The officers were at the wrong house. Yes?
yes,
The officers were inside the garage,
correct,
and the homeowner was the one that was shot.
correct.
This is starting to feel like a counter ambush.
Yep.
Mr. Brissett.
Thank you, Your Honor. And you ruled that a clean shoot is in the province of your world.
Well, full disclosure on that, my original assignment was that the argument was the individual was raising his hands at the time that he was shot and was not armed. And I was asked to look at it to determine what his position was based on the shooting reconstruction and the bullet wound location and the blood stains. And through that analysis, I was able to show that no, he was more likely in a position consistent with what the officer described, and that his shooting was reasonable considering that position.
Do you recall giving a video deposition during the time of COVID, that was September 25th, 2020, for federal court in Angie Waller versus the city of Fort Worth?
Yes,
In that, you recall when you were asked by Mr. Brender, who was one of the plaintiff's attorneys in the case, that experience teaches reasonable officers that burglars come in all shapes, sizes, and attire.
Correct.
You don't know, they could come out wearing a suit or a tux, and it doesn't make them any less a criminal. Somebody that's wearing socks and no shirt when they come out of the house. Do you recall that?
Yes.
Because rightfully so, you were there to give a deposition of blood spatter, but when Mr. Brenner waded off into this, you answered it.
Yes.
And you gave your professional opinion based on that 32 years of experience.
Yes.
And you remember telling Mr. Brenner back then that you have to base it based on the officer's experience and what they knew at the time when they got there?
Yes.
Okay?
Oof.
They didn't know that there was a weapons call on that case, or a weapon would be involved. They were going to an audible alarm call, correct?
Correct.
So they further, your senses are aware when you get there on a call. The four of us have never been police officers and don't claim to be. That's why we have experts like you. When you're on a call at night, whether you're a single person unit or you have a SWAT team there, you still have to be careful where you go. I think that's what you were explaining on direct, and you talked to me a little bit on the cross, right?
Yes.
This wasn't a tactical operation where concealment needed to be the utmost of it, was it?
Well, certainly you want to be cautious anytime you approach any location. The fact that it's an audible alarm, you're looking for those entry points, and they had the different way to approach in this particular case, which they did.
When we're talking about how we compare somebody and look at them, certainly to be clear, when it talks about reasonable offer, it's talking about somebody with life experience and training.
Yes.
When you cleared the Fort Worth officers for their shooting back on that garage hypothetical, that's the standard you work with, reasonable experience and training, correct?
Yes.
So you have to look at two rookies in this case, yes?
Well, again, the fact that they're rookies, I mean, they're closer to the training end of this, but light on the experience end of this. I don't want to give somebody a pass simply because they have less experience.
And I'm not asking you to, but we don't have the breadth and depth of your knowledge of 32 years of doing it your way. We have to do it the way the rookies would do it.
Well, the way the law says we need to do it.
Well, the law says we look at it from their training and experience, correct?
Correct.
So the law says we look at it from the rookie's perspective. Do you agree with that?
I think that's fair.
Objection, Your Honor. The court will be getting the law from the jury.
I'll let him answer.
You mean the
I
jury
think
will be
that's
getting
fair.
the law from the court? Not the court will be getting the law from the jury.
You look at Darch and Dean's records. They weren't on the streets very long.
No.
And how Chief Fitzgerald, who designed the shift duty, put two rookies on the streets at night together, that's a debate for another court, not a criminal court. You agree with that?
To a degree, yeah.
To a degree.
I guess this is why they didn't want to disqualify
Do
him.
you have any qualms with the study?
Well, they had some preparation, obviously a lot.
Talked about reaction times. You've read that before, haven't you?
Yeah, Blair's not the only one that's done that. There are several people that have done that sort of thing. It's the same sort of deal with the 21-foot rule. And yeah, I'm very familiar with the study, but lots of studies like it.
Wait, you didn't rely on any academic studies.
Computer technology has evolved. We try to test so we can better train and protect officers, not only for their safety, but for the public they encounter. That's safe to say our whole goal in the law enforcement system is to make sure everybody's as safe as they can at any one time.
Well, sure.
So can you explain to the members of the jury, you just mentioned 21-foot rule. What's that?
Well, the 21-foot rule is kind of an antiquated deal, but basically it dealt with sharp force weapon usage, but it can
Not
really
sharp.
deal with pretty much anything.
It's
other
not
than
limited to
firearm.
sharp.
I guess it could with a firearm too, but basically what it says is somebody armed with a knife can close the distance and severely injure or kill an individual who is armed with a gun if they are within 21 feet of their position at the time.
And you say
Any impact weapon.
the studies have shown that really needs to be pushed out a little bit further, correct?
Yeah, probably about 35 feet.
And the studies in we talked a little bit before the jury came back in the studies that you reviewed on reaction time for officers. Do you have any qualms with Dr. Kuntz's reaction time? If Officer Dean's already in a position, however he got there, I know that we differ on how he got there or why he should have got there. But once Officer Dean is in a position with his finger indexed or moved to the trigger, you don't have any qualms with the time it takes for him to make that decision of shoot, don't shoot.
Action, it's basically action reaction, which is a third to half a second, depending on the training of the officer.
And at the point that he got there, I know we disagree on how he got there, but we talk about different decisions along the way. Would you agree with Dr. Coons that once we're there and a weapon, if that's what the testimony is, and what Mr. Frederick showed with an object in the individual's hand in the window, once we get to that point in Defense 40, slide 53 through 56, where there's an object coming forward, we're at a decision point of shoot, don't shoot, are we not?
Well, I can't assess whether an object was or wasn't present.
Okay.
So I only have the ability to say that Officer Dean is going to have to make the decision or articulate his reason for discharging that firearm. I can't support or negate that based on what I saw within the evidence.
Okay. And you can't support or negate what Zion saw with that. It actually, Zion corroborates what Aaron saw.
With respect to a handgun?
Ms. Jefferson pointed the gun at the window.
Well, yes, that's true.
So,
Well, let me back up.
yes, sir.
Pointed the firearm and pointing it at the window are two different things. Pointing the firearm, I will agree with Zion.
Okay. And Aaron says he saw the gun and the barrel was huge. And you've done enough use of force. You've done enough use of force stuff that's typical of what the person says, whether they're a victim of a robbery and they say the barrel looks as big as your fist, or it's an officer looking at a suspect's gun pointed at him.
Weapon focus.
What do you mean?
Weapon focus.
Can you explain that?
Hey,
Weapon focus. Typically what happens, and it's been discussed in here a couple of times about the degree of visibility with the eyes, which is when your degree of focal vision is 2 to 3 degrees, and it's always that. Peripheral vision is out to about 120 degrees. About 210 degrees to the sides, and you've heard all of that. Under stress, your focal vision really takes over, so that 2 to 3 degree that is always there really starts to concentrate, and you're paying attention on that. If you identify a threat, you begin to stare at that threat, whatever it is, and if it's a firearm, you begin to stare at that and you see it. Now, that doesn't mean that you actually have a firearm either. Okay, it could be that you are identifying what you believe or perceive as. And because that's how you perceive it, that's how it's reported.
As part of your 32 years of training, you've had to be qualified on many different weapons. Is that safe to say?
Ask that one more time.
Sure. As part of your training as a peace officer, I guess, is it a post certification in Colorado? Is that the proper phrase?
Post, yes.
Part of your post certification in Colorado to carry a weapon, you have to qualify on it, correct?
Well, I carry a firearm, and I have to qualify with it, yes.
You familiar with semi-automatic weapons?
I am,
You've had to qualify with handguns, correct?
yes.
Have you examined either the Glock or the Walther in this case?
The firearms in this case, no.
Yes. You familiar with light rail systems?
Yes,
You familiar with laser light rail systems?
yes.
Can I Coach Wittenshire?
Yes, sir.
so I mean, the defense has, to their credit, shredded this guy's testimony.
I'd ask you first.
I think the biggest one was
Can it
you
take a
testified
look
the
at-
exact opposite in another case in Dallas. Like,
Right.
States 97 and make sure it is equipped to be rendered safe with a zip tie in it right now.
Slide is locked back. There's a zip tie through the both ends of the barrel, which prohibit the firearm from accepting a live cartridge. And again, the slide is locked back.
So you would agree for demonstrative purposes, you and I can chat about this safely here in the room?
Yeah, as long as I'm not pointing at anybody.
Yes, sir.
Won't be doing that.
Understand completely. So on 97, States 97.
Why? It's
that
completely
has a
cleared.
light rail system on it. Would you agree with that?
I would.
And do you know how a laser such as that?
Alec Baldwin would point it.
There are toggles right here. There's a button on either side. That you
Not
can
only will
turn
I
on
point
and
it,
off, so you
I'll pull the
can
trigger.
either way.
Okay. And if the battery, it's been in the property room for 3 years, safe to say from the date of incident. If I have a fresh battery, do you know that we unscrew the front to put a fresh battery in it?
I imagine it loads in somehow.
Okay. Do you have one of these light rail systems?
I do, but I don't carry my light on there.
Okay.
I've never seen the need for it.
What is it used for?
Targeting.
You should point at the guy and be like, hands up, motherfucker.
It puts the dot where the round is going to go. And that's if it's adjusted properly. I don't know if it's been sighted properly, so I can't attest to that.
Sure. And for everybody's benefit, there are adjustment screws on States 97's light rail system to, if you had this in a jig that hit the range, you could do this. Hone it in.
Oh my God, get over it. The weapon is cleared
And
completely.
showing 97, you mentioned a minute ago on 97, if you hit the button
Yes,
on either side,
right,
you can turn this on. And if you press it long enough or flip it, it'll stay illuminated. Is that correct?
correct.
Did the jury see that?
I think so. I think that's kind of why he backed off to the side there. So I assume the jury's off to the left as we're looking at them.
Do you still hold the position that you taught nationally that we have criminal jury system, which is superior to any in the world, and its efficiency is only marred by the difficulty of finding 12 men every day who don't know anything and can't read?
And
That's your view of a jury, is it not?
it is a joke that is part of a PowerPoint for testimony.
Wait, what did he say?
It's to teach experts.
He described the jury. The difficulty of the jury system is having to find 12 people who don't know
Anybody that
anything
wants to talk about testimony, and it is
and are ill-informed or words to that effect.
Well, you go through some of the other side, it says, get ready for rapid fire questions from like that Dean had to experience.
Yes,
And get ready for questions that might be unfair in rapid fire.
correct.
You think I've been fair with you today?
You know, I've done this so long, I don't know that I'd identify an unfair question.
Thank you. Pass the witness.
Redirect.
Now, Coach.
Yes, sir.
Do you believe this defendant is guilty?
After that testimony, I'm going to ask you to pick up that gun, sir, and point it at your head. Pull the trigger. You've been no help to us at all today.
So they were prepared.
I guess they just wanted some of his statements on the record from Daubert to use, because I mean they used those statements in or some of them in the cross.
The no notes.
Yeah, I know from prior testimony you don't take note, or when you're not in front of the jury you don't take notes. That was good. Are we going to get questions from this defense attorney? Is that going to happen?
Now, Coach Witness, Your Honor. Yes, sir. Sir, I'm handing over to Mark States Exhibit 122. Do you recognize it?
I'd like to show you Exhibit G for guilty.
Is that the same general orders that the defense attorney had up here talking to you about silent alarms?
Yes,
Just the 327.01 of the general orders that deal with silent alarms.
correct.
Thank you. At this time, Your Honor, state offer State Exhibit 122 for all purposes.
No objection.
State Exhibit 122 is admitted.
That talk to the defense attorney.
Yes.
Now, Mr. Creed, this case in Fort Worth, the man that was shot, was he following the officer's orders?
No,
Did he have an opportunity to follow the orders?
yes,
You've seen the video that Tatiana Jefferson had the opportunity to observe the defendant's orders?
no,
Why not?
She didn't? Why not?
In the defense attorney asked you a bunch of names. Do you
And
recognize
that's-
the name of Tatiana Jefferson?
That's
Uh,
bold to say.
other than from this case, no.
But you know the name now, don't you?
I'm not saying
very
she
well.
should have.
Where did she die?
Died in her home?
In her own home,
Yes,
at the hands of the defendant.
yes.
We'll pass the witness.
Mr. Brissett?
Under the rule of optional completeness, we offer defendants 49 to general order.
No objection, Your Honor. We join in its submission.
Defendant's Exhibit 49 is admitted.
That was enthusiastic.
Now,
Wait, has it been marked previously?
yes, Your Honor, it's on the witness stand.
Okay. I'm sorry, Mr. Brissett.
Thank you, Your Honor. Now, they didn't drop the case that you cleared the officer on. Do you remember telling them that they may not have an opportunity to get the commands out if you go that quick?
I don't recall it specifically from this case, but yeah, that's quite possible that you can't get commands out very quick.
And as you're visualizing as an officer what's coming up at you, the prerequisite that the media and everybody else wants to have in any shooting case that really isn't reality is officers are faced with deadly force and it may be that quick and they have to make a life-second decision.
Agreed?
If you don't have any problem with Dr. Kuntz's timing for the split-second decision, once he's, regardless of how he got there, once the decision is shoot, don't shoot. If Dean says he's faced with a deadly weapon and it's presented at him, you said earlier on direct that mere presence alone is sufficient to identify the officer. Do you recall that?
Well, mere presence alone, if the officer is seen, can identify them. But yes, I mean, in a basic sense, the fact that the officer is there wearing a police uniform, that's enough to identify them as a police uniform if they are recognized. Sure.
And that's the whole part of this, but that's the general training that Fort Worth and every other department in the United States operates under, correct?
I'd agree.
If you have a uniform on, that checks off the first box, you're a police officer.
I agree.
Like if somebody's in a military uniform, you know combatant versus non-combatant, correct?
Agreed.
And there may be situations in time, and you've seen the timing in this case, where if Mr. Fredericks stills on defendant's 40 at slides 53 through 56, have the timing with the voice overlay, that whatever's in that person's hand inside, Ms. Jefferson's hand, there's something coming up in her right arm. You disagree with that? Whatever it is, there's something, if Brant, you disagree with Mr. Fredericks?
I don't know what she's holding, if anything.
So when you were looking at this, I know you didn't take any notes when you were looking at the videos. We looked at Axon Interrogate yesterday with Mr. Fredericks. The precursor to that was Input Ace, which was Mr. Fredericks' product. And the Fort Worth Police Department or the Tarrant County DA's office both have copies of it. I have one. Do you have Input Ace? In your farm, you do a lot of crime scene stuff.
Yeah, but no, I mean, we don't typically use that kind of program.
Okay. You just look at it with whatever software is generally available to the public?
Yeah.
Doing your crime scene reconstruction?
It is like body worn camera?
Yeah.
Yes.
You never look at it, the forensic detail to see what is artifacts or anything like that, and you make your opinion just off of, you never interrogate it, for lack of a better term.
Oof.
Well, typically, no, because again, my ability to look at that frame by frame by frame is not how the officer actually saw it. And they may see things that the video is not. So looking at the video, I see what the video is showing. You know, looking at it frame by frame is not how people see things.
And would you agree that the video may, if it captures and saves stuff that's wrong, that didn't get recorded, like artifacts or overwash from the flashlight, that Mr. Frederick said yesterday, you can't unsee something you think, correct?
Correct.
You'd agree with that?
Agreed.
Were you given the individual stills from the Input Ace discovery that was done the morning of this shooting by the Fort Worth police? That everything Mr. Fredericks did, minus the arrows, was available to the police when they were investigating this by 10 o'clock Saturday, October the 12th, 2019.
I would agree that they had the body worn camera and could do that kind of analysis, yes.
And have you seen the edited version that the city of Fort Worth put out that morning that was done in Input Ace? The stills were available, the edits were available, the triers that were looking at that, the officers could look at that in the same forensic software that morning. Have you ever looked at those forensic edits as you were looking through this case?
I don't believe I have.
Did they just not provide them to you?
I can't say they haven't. I don't recall seeing individual stills, but I can't say they didn't provide them.
It's part of your job, because you're a big consulting firm that goes around the world, correct?
Yes.
Do you have somebody on your team that intakes, here's a list of all the evidence I received, so I know what I had when I'm forming my opinion?
Well, I have a list of all of that. I just can't recall everything that I have.
How do you make the list if you don't take any notes?
Well, I've got the file on my computer.
So you did take a note.
File list, but you don't take any notes to index and inventory. Here's everything I was given in case something didn't get through your Dropbox account. It can be sometimes.
I can only tell you that I can't recall if I have those frames or not.
Thank you, Your Honor. Pass the witness.
Mr. Smith,
Nothing further, Your Honor.
may Mr. Priest be excused subject to any potential recall?
Yes, Your Honor. No objection to the
Thank you, sir. You may step down.
Man, I don't think he did.
That wasn't good.
Phone back, come on.
Yep.
Mr. Smith.
Your Honor.
How can you be stupid enough to be an expert witness at trial and say nonsense like that about a jury on the record?
Okay. Retire to your jury. See you back in a few minutes.
Wow.
All right, 3 o'clock there, 3 o'clock next time.
Mm-hmm.
I can't imagine they're going to do closing today. Guess they could.
No.
Kind of
They
late,
have
right?
time for it.
They got jury instructions. They got to do at least, if they don't have to discuss jury instructions outside the hearing of the jury, and I expect they do, the jury would at least need the preliminary jury instructions before closing.
Right. Yeah, I don't think I can't imagine they're going to get to closing today. Unfortunately, I will not be covering tomorrow. I'm on
Okay.
Megan Fox's channel tomorrow at 11. I think I could maybe start if you wanted to host, I would happily join you for a little bit if you're able to.
Well, why don't you decide what you want to do? If you want to start, you can start on your channel, and then we can pop it over to mine when
That's a
you have to
possibility.
go.
Yeah, I'll check because I think it's 11 a.m. that I have to move over. I don't know that I have anything specific in the morning, but we'll figure it out because it could be that they do closing arguments and are done by 11. Like that's entirely possible
Right.
depending on what they end up doing today.
Yeah, I mean, I don't have an emotional need to host a stream. Your audience is 10 times the size of mine at least. So if you can do it, I'd prefer we do it on your stream. But if you can't, it's fine. I can pick it up. It's not a problem. So you just let me know what works out most convenient for you.
Sounds good. Well, we'll figure that out. And ooh. Oh no, Jeremy, what are you doing? Don't, brother. Everybody's going to pitch at you too. The Quartering with a big super chat says, massive thank you to Nick for opening my eyes, balls, to brand new experiences. Code knows at baldo.com. Yep, there you go. Go get yours. Grab your Chuck the Balls today. Make sure you share your balls with your loved ones in all of the best ways. How you doing, buddy? Oh my goodness. Wow, what a disaster. Let me read a couple of these super chats real quick that I've missed, and then we can talk a little bit more about this witness. David says BitChute's bank has frozen their account. Maybe you can cover the story on the night show. I'll have to check into it for sure. I do not believe in foreclosing anyone's access to the banking system. We don't foreclose access to the banking system of murderers, of rapists, of anybody, but apparently political dissidents. That's it. That's the people we choose. Like someone who has a different political opinion that we don't like, they don't get to access the bank. But the worst people on earth, they get full access to it. Pedophiles don't get their bank account shut down ever. Yet,
Right.
But well, you're a little too far to the right for my taste. You're done. Yeah. Okay. Fantastic. Gates of Above says, if there was no report or notes, did the defense think he wasn't going to go and testify? Well, I think what Andrew, and you can expound on this if you want, but you were alluding to the idea that no, they actually were fully prepared for this guy. They knew exactly what was coming, but maybe they just wanted they wanted to raise a little bit of a specter on the record at Daubert that they could then use when he got in front of the jury. And they did that. Like, you don't take notes in front of the jury, you know? And they got him, they got him to, I thought they should have harped more on his statement that he had a bad memory, that to the point where he couldn't even remember what book he had written. I think they should have gone into that. You don't take notes though, right? Like you don't do that, but you don't have a good memory. You just said you can't even remember the title of your own book, which to me, like how many books has this guy written that he can't remember a title of a book he co-wrote?
He only mentioned one or two, right?
Yeah. I mean, you've written a book. Can you remember its title?
I can. It's called Law of Self-Defense Principles, free at lawofselfdefense.com/free book.
Wow. Seems like it's not that difficult to remember the title of a book that you wrote. Because look, this guy's an expert. He's somewhat of an academic, sort of. I mean, that's kind of the business.
Academic without a degree.
You're right. But I mean, he's in the business of being an expert. And typically I would think experts would take pride on their works that are being used to train other people. Like that's the whole purpose. So very weird. I've met a lot of academics and professors and experts, and none of them that I know do not remember the names of the books that they write. It's weird. Right-wing extremist says Stephen King was so coked out he doesn't remember writing books. Maybe it's the same with Elmer Fudd. Could be.
Elmer Fudd.
Macabre Society says if a federal employee was shot every time they tried to take someone's land through eminent domain, they would stop trying to take land. It's a strong argument. Strong argument. Might be true. I'm not a big fan of eminent domain. Although there are known advantages to it, right? Like we all have internet and electricity and gas lines because of eminent domain. But okay. Well, I mean, do you have any thoughts on this witness other than what we've said already? I mean, I don't know. What do you think?
Well, I mean, it doesn't change anything for me. I mean, frankly, none of the evidence we've really heard at trial has changed my initial impressions from the start. This guy's direct testimony was just parroting what the prosecutor had already said himself on cross of the defense expert. So it didn't add any value, except he obviously looked like he was parroting. And then on cross, he got run over by the defense.
Yeah. I think he was completely blindsided.
If anything, net negative value.
Yeah, and maybe that was part of how they handled the Daubert hearing, was to set him up that they didn't know anything about it. So he was very cavalier in his testimony and was, I mean, he seemed completely unprepared for when they started bringing up the instances. I like the one where he smiled and he goes, "This is starting to sound real familiar," on that hypothetical. This is starting to sound real familiar. Oh, is it? Is it starting to sound familiar to you? And they did let slip that, yeah, or didn't let slip, but the prosecutors did mention that his 2021 CV was attached to an email. So they likely had reviewed that and could pull any of those cases. And they may have been able to grab more information that they just didn't want to let on to. If they're like, okay, you're going to play games and bring this guy for cumulative non-rebuttal testimony, fine. We'll play games too. I think they played it okay. And I was worried how they were going to handle that witness. And then they did a pretty good job with it, I thought. So good job on that. I wanted to clear the air on that one. And speaking of clearing the air, if you go to ekpure.com, you'll find the next sponsor of the show, which is EnviroCleanse, which I'm contractually obligated to say it as EnviroCleanse, just like that with the German accent. This is your in-air home purification or in-home air purification system. The in-air home purification system is a little bit different. That's called Ebola. No, this is the in-home air purification system. It's it's a high quality air filter. It's made to remove particulate matter from the air. They claim, I can't test this, I don't have a way, but they claim that it will remove things like COVID, like the flu virus, like the common cold virus. It'll remove those particulates even from the air. It will reduce the instances of getting sick in your household. If you have guests, if you have kids, that is, a nice way, especially with the holidays around. That is a nice way to keep everybody healthy, according to them. Again, that's not something I can test. What I can test is this thing is actually really good at dealing with smells and odors. I have children, I have pets. There are odors that exist. And I put this thing in the highest odor traffic area of my house and cranked it to full. I've been running it, and it took just about a couple hours for it to actually eliminate basically all of the smell in that area. And so that's a cat box. And my kids are bad at cleaning up after they eat in a nearby room. And so that food smell gets around, the cat smell. God, it's just, I hate it. But this thing actually gets rid of that really, really effectively. Look, it's not a cheap product. That is for sure. But if you're in the market for air purification, especially if you have about 1,000 square foot space, because that's what this thing is really designed to tackle, is about 1,000 square feet. If you've got an apartment or a house that's in that area, this thing can be the one spot that takes care of all of that air, and it cycles a lot of air through its system. It goes from 80 cubic feet per hour, I think, up to 250 cubic feet per hour. And, when you're standing around the thing, it is definitely moving air through it. And so it's pretty effective at that. If you're looking for that, it is a nice way to improve the smell quality of your home. And then, of course, there's all those intangibles that I can't test that they talk about as well, just general health, removing dust and allergens from the air. That's the other stuff that it's supposed to do. So check that out at ekpure.com, and you can use promo code KNOWS to get yourself a little bit of a discount on that. So check that out. I'm actually going to be getting they sent me one. Full disclosure, this is a paid sponsorship. They sent me a unit to test, and I've been liking it so far. I am going to buy another one because I have another room, and I have a guest who has routine allergies, Drex, and there's a room that he sleeps in, so I'm going to put one up in there to try and reduce allergens in that area for him. So, but you guys can check that out at ekpure.com and use promo code KNOWS. So there you go. There we are. With that, I've got some more super chats to read, unless anything pops out to you that you want to talk about. I mean, I'm willing to talk about anything.
Not really. I mean, if we have the opportunity, maybe I'll mention those American law classes again one last time for today to remind people.
Yeah, anytime. I mean, you can do it now. Oh yeah, here it is.
Yep. All right, folks, American law classes. These are law school level classes taught by expert attorneys in their fields, taught on a law school-like basis, semester-long classes, 14 weeks each, taught live over Zoom, one class a week for each of the courses. In the spring, we have courses on evidence being taught by an extremely experienced trial attorney, more than 200 trials, and property being taught by none other than our friend Andrew Esquire, an expert on property law. These are taught as if they were being taught in first-year law school, much as Nick and I and all the other lawyers you see on the internet took these courses, taught in plain English with real-world examples, so you can have a masterful understanding of the law when you cover these trials with us. They are taught at a fraction of the time, a fraction of the cost of actually going to law school, a fraction of that commitment, and without any of the crazy progressive politics that pervade law schools today. We just teach traditional American law in the traditional American way. And if you register for the spring classes or any of our other classes before the end of the month, we are in the pre-registration period for the spring. You can save 50% on these classes. Learn more at AmericanLawCourses.com/Nick.
There you go. Thank you very much.
right.
And I think that'll be great. Andrew's course is going to be certainly exciting. I saw a clip about him posted on Divinity Said's channel. Is Andrew Esquire even a real lawyer? Because there was apparently some rumor floating around that he wasn't, that he was not a real lawyer.
I can tell you that he is. So
yeah,
I checked naturally just to be sure, that the people we are teaching our courses are actually licensed at the bar, and Andrew Esquire is admittedly not under the last name Esquire. That's a pseudonym, but I do know his actual last name, and I checked the records, and he's a real lawyer.
Yes, I've also checked the records, and I can confirm he is a real lawyer.
We had a discussion about this at the bench. It is another portion of the forensic interview of Zion Carr.
Turn the fucking mics on.
Offered and admitted at other points during the trial. I don't recall what the largest segment of it. I don't recall the state's exhibit number of that, but there was a second exhibit offered and admitted by the state, which is state's exhibit 116, which is the second portion of that interview. We offered this portion of the interview under rules 106 and 107, it being a part and parcel of the exhibit that was offered earlier by the state on the same subject matter of the forensic interview of Zion Carr.
So as I understand the way the interview was admitted, it was agreed to between the parties as to certain portions of the interview would be played and certain portions would not be played. The interview was not admitted in its entirety. Is that correct, Mr. Smith?
That is correct, Your Honor.
And that's your understanding, Mr. Gill?
Because the state's exhibit, we did not oppose the admission. First exhibit, so it was admitted without objection, and then there was a second portion offered by the state, the state's exhibit 116, which came in without objection. Now we're offering defendant's exhibit 50, which is a part of the same interview.
But it's my understanding that the portion that you're wanting to offer does not relate to the incident on trial here. It relates to a totally separate incident.
It relates to Ms. Jefferson's handling of the weapon on the second occasion, which is consistent with the handling of the weapon on this occasion, in which Zion Carr also demonstrated with his hands how she manipulates the weapon. The relevance being on this occasion, a live round is found in her feet.
I don't think this should be included.
Described on defendant's exhibit number 50, it described how in a separate incident, she manipulated the slide of the weapon and ejected a live round and said, "Oh, it's already loaded," which is behavior consistent with her behavior on October 12th, 2019.
response.
Your Honor, going back to Monday last week, December 5th, after Zion Carr when Zion Carr testified, we both, the state made it clear on the record that that testimony was different than he had divulged to us in prior meetings and in the forensic interview. The defense acknowledged that we had been sending them disclosures about meeting with witnesses, and the defense at that time said that they did not believe that the state of Texas was holding anything back, and they acknowledged that the state had heard that new testimony for the first time with the defense in this courtroom, so there was not a 3914 Brady violation. At that time, instead of subjecting Zion Carr to the lengthy process of rewatching the forensic interview piece by piece for the defense to impeach him with prior inconsistent statements, the state made an offer with the defense to play the portion of the forensic interview that dealt with what Zion Carr had discussed happened at his grandmother's home on the early morning hours of October 12, 2019. The state of Texas told Mr. Gill specifically, we don't care which parts we play. We just would like to keep the part out about the incident with the car on a different day and the Tatiana Jefferson and her weapon, because it's extraneous, has nothing to do with this case, and has no evidentiary purpose whatsoever. At that time on Monday, Mr. Gill said, that's fine, and we played that first portion. A couple of days later, last week, I can't remember if it's Mr. Brissett or Mr. Gill, they approached me and said, hey, we want another piece of the forensic interview played. I said, no problem. The state of Texas has in its possession a format of the forensic interview which makes it easier to redact. So they asked the state to redact that portion. We pulled it out. I showed it to them. Mr. Gill was nice enough to inform the state of Texas that that was not the right portion. It talked about something completely different. Another portion the state didn't want to keep in, so the state appreciated Mr. Gill telling us that. We got the right portion. They listened to it, and that was the second part of the forensic interview. So we would object to the optional completeness because this was done by agreement so that they didn't have to impeach Zion Carr in that lengthy process so they could get that testimony out the way they wanted. And then also that this is a completely extraneous matter on a different day, that its prejudicial value, its prejudicial effect outweighs its probative value.
So do we have a complete copy of the forensic interview that has been introduced for purposes of the record?
Yes, we have, Your Honor. That is State's Exhibit 94
Okay.
for record purposes only.
Right. And the exhibit that you're wanting to introduce, Defendant's Exhibit 50, is the final portion of State's 90 that you would want to show.
Correct.
Okay. And during the break, Mr. Gill provided me a transcription of the interview. Is the state satisfied that the transcription that he provided to me is fair and accurate in regard to the video?
That is correct, Your Honor. I reviewed the same transcription, and I have reviewed the exhibit, the defense exhibit that they're trying to introduce. That exhibit has portions of the forensic interview that are already in front of the jury under State's Exhibit 116. It's like the last 2 minutes of the exhibit that Mr. Gill just provided the court.
Okay. All right. I'm going to sustain the state's objections. Would you want to introduce Defendant's 50 for purposes of the record?
Yes, Your Honor.
Any objections?
No objection for purpose of the record.
All right.
Okay, so they tried to
Does
introduce.
the defense anticipate having any rebuttal evidence?
No, Your Honor.
Okay. So both sides will rest and close in the presence of the jury.
Yes. Yes, Your Honor.
Let's go.
What?
Okay. I can summarize what just happened. So
We're going
waiting
to
for
rest
the
and
jury
close
to-
right now?
Yes. Well, they're gonna. Yeah, I don't know
You
if
said
they're
rest,
gonna close.
rest and close. Yeah.
Yeah, if they're gonna do closing arguments, I'm for it. What just happened there? I know it was really hard to hear. what just happened there was the defense tried to introduce the interview of the now 11-year-old boy in its entirety under basically the rule of completeness, even though they had previously agreed to only introduce certain portions of the interview. And the specific portion that they were trying to introduce today under the rule of completeness was a prior incident involving the deceased in which she allegedly handled a firearm in a similar way to how she allegedly handled it at the time of the shot. They're trying to use it as a matter of consistent practice. Oh shit.
Your Honor, and ladies and gentlemen of the jury, the defense closes.
State closed.
Your Honor, ladies and gentlemen of the jury, the state closes as well.
Thank you. You may be seated. That's going to be all the evidence that you're going to hear. And as I told you at the beginning of the trial, once both sides rest and close, I have to prepare the set of written instructions that contain all of the law that's applicable to the case. So that's what we are going to work on for the rest of the afternoon.
Okay.
I'm going to allow you, however, to remain here for as long as you want to review your notes, because I anticipate in the morning when you come in, we'll hit the ground running. I'll read those instructions to you. The lawyers will make their closing arguments, and then you'll retire to your jury room to begin your deliberations. Okay? So work as long as you want to back here today. When you're ready to go, just let Deputy Nicholson know, and we'll get it all taken care of. Very, very important that tonight you stay away from anything involving the media. Don't watch TV. Don't read anything. Go out and eat dinner. Okay? Because tomorrow we begin on your time. You're in control of this tomorrow, not me. So work as long as you want to today. We'll see you in the morning.
Your Honor, before we may approach.
Yes.
All right. So the reason I think that was improper, and I don't know if you have a similar opinion, is how she handled a gun allegedly at one point during, at some point in history, has nothing to do with how she would have handled a gun, or what the officer, more importantly, what the officer perceived about her handling of a gun in this instance.
Your notes are your notes, okay? While you're looking at them, you're reviewing them. Don't be talking about the case, because that hasn't started until in the morning, okay? All right, with that, follow Deputy Nicholson.
He just wanted to instruct them to only use their own notes, not to use other people's notes. I wonder if they're going to keep the cameras on for the discussion about jury instructions. But yeah, I don't think that is relevant evidence. How she used a gun on one previous occasion, how she may have been holding a gun on this occasion. We have testimony about how the gun is being
All right,
held
everybody, we're through. Thank you. I just need the lawyers for the rest of the day.
from the defendant and from the 8-year-old's interview that they did introduce. Oh, there we go. They cut the cameras.
All right.
So
We will be right back. I don't think so.
Yeah, I'll keep it. Whoops. I'll keep it on for now in the background. If anything pops up while we wrap up, while we're, I guess, wrapping up, then I will gladly bring it back. But for now, I'm going to assume the way he said that, I just need the lawyers kind of looked and then the camera feed just stopped. I'm going to think that they're probably not going to broadcast the jury instruction arguments. But yeah, I don't know. Do you have any opinion on the inclusion or exclusion of that?
And it seems a reasonable decision by the judge. I mean, it didn't seem to me to have very much relevance, and it had potential for prejudice. So it just didn't add much. Frankly, I don't know what they were going to try to say, that she was incompetent in handling the gun because she didn't know it was loaded already. I don't see how that's relevant to the facts of this case.
Right.
Completely different incident.
Steve White says, "Hey Nick, you up for doxing Andrew on your chat?" No, not really. If people want to go find out who he is, they can go find out who he is. It's out there. I mean, you can find him if you do your sleuth work. You can do it. And I had actually heard some rumor a while back that people were going to go after him, and as not being a licensed attorney. Look, I don't know what anybody thinks, but going online, presenting yourself as a licensed attorney, it's not a crime unless you're trying to actually sell legal services. but it would fucking destroy anything you've built like immediately if that's what you did. Like if you're like, I'm a licensed attorney, but you actually weren't. I mean, it would be devastating. So I don't know anyone who would do that, but I guess it's always possible. But no, I have seen his lawyer registration, his current lawyer registration. I know he's a lawyer in good standing. So yeah, they just killed the feed. So it's done
Okay.
over there. But yeah, so whatever anybody may think of him, and I like him just fine. Whatever anybody may think of him, you know, it's not his credentials that should be the basis of their criticism, because he's a licensed attorney like the rest of us on LawTube, except for that one chick. Well, it wasn't like, I've never met her, but she is suspending or giving up her license because she was afraid of losing it. Something like that. I don't know, which is foreign to me. You'll have to pry my fucking attorney license out of my cold dead hands. Before
All right.
I did,
Hey,
sorry.
Nick, if court's wrapped up, I'm going to take off. I got some household errands I should take care of, given the opportunity. But send me
buddy.
a text later and let me know what you want to do about the morning. Or we can probably get through closing on your stream and still free you up in time to do whatever you need to do. But I'll leave it in your hands to decide what to do, and just let me know.
Yeah, if not, maybe I can get Ryan to manage the stream, even if I have to step out. We'll see.
Okay. All right.
All
All right,
right.
folks. Take care, everybody.
Thanks, guys. I'm still here, though. Just Andrew's leaving. Hi. Just you and me now, chat. Just you and me. So yeah, just to finish that up, you know, whatever criticisms you have of anybody should be based on facts and your impressions of them. And I don't know where any of this rumor started. I don't know what was going on with that, but like I said, it's done now, I guess. And people can just move past it, maybe. With the rest of that, what I was saying right before Andrew came back, I was going to tell you a quick story. Before I started YouTube, I had my law practice, and I was actually offered a different position. Someone I know is a financial advisor for a major financial firm, and a local financial advisor was going to actually retire. And the way these things work is, you know, you work for a firm and you build a book of business, and those are your clients. That's your client list. And if you move firms, sometimes, you know, you can't really move clients with you because the book technically belongs to the firm. There are ways to kind of weasel it out. But when someone retires, what they tend to do is pass their book on to the next person who takes over the office. In this case, I had the opportunity to take over that office. If you don't remember, I was in the financial industry for years before becoming a lawyer. And I had this really great opportunity to take over a financial advisor's office and to hit the ground running with a full book of business, easily making six figures in my first year of employment and doing that. And so I was doing the interview process, and I got to the final stage of it. And they said, oh, one thing, we need you to suspend your law license. And I said, I'm sorry, what? Like, yeah, you can't be a lawyer and work in the financial office because people might think that you're giving them legal advice on their finances. And I said, well, that's silly, because I wouldn't be giving them legal advice, and could easily state I'm not your lawyer. But I'm not going to be practicing law. I'm going to be practicing financial advice. And they said, no, sorry, we need you to cancel your, suspend or relinquish your law license. That's our policy. And I said, well, fine, fuck off. I'm not going to do it. I'm not going to do this and to get rid of my law license. I worked really hard for this thing. It's part of who I am now. And no. And so I didn't take that job. I'm only bringing up this subject because I saw the video of that girl who gave up her law license because she was afraid that someone would take it from her. And that's a really foreign thing to me. Like if I'm worried someone's going to take it from me, I'm not going to give it to them. Ever. It's mine. I dare you to try. On that note, I get asked this from time to time. I still have no resolution on my outstanding ethics complaint. So as soon as I know, you guys will know. I have no idea how that's going, the investigation. So that thing is not going to end up in disbarment anyway. Even if I get a negative result, it wouldn't be. But I don't think I'll get a negative result. But we'll have to see on that one. But yeah, I would never like, well, I'll give up my license so you don't investigate me for using my First Amendment. Oh, no. Quite the opposite. Quite the opposite. So anyway, I'm not, such a weird thing. I don't get it. Okay. Where were we? We've got super chats left. Oh, tonight there will be a nighttime show. There will be a nighttime show Tuesday, which is tonight, Wednesday, Thursday, and Friday of this week. Friday is my birthday. I say there will be a nighttime show on Friday. Look at this. Oh, I have time to go get a haircut. I say there will be a nighttime show on Friday. It is entirely possible that Lady Raggeds would have something, some sort of surprise that she doesn't want to tell me about that would change that. As far as I know, and I tried to beat it out of her earlier. As far as I know, I'll be here for the nighttime show on Friday. I'll be inviting a bunch of friends. We're just going to be drinking, having fun, telling jokes, talking about whatever stories come to mind. Hopefully a big panel of people coming in and out. It'll be a good time. So Free 63, why no more streams or videos on Odyssey? Okay, I'll do this one more time. Odyssey's process of setting up a live stream somehow takes even longer than Rumble's. And today I was confronted with no internet this morning, and I was scrambling to get everything done. And I actually got started a little bit after 9 because I was resetting routers. I was rebooting computers. I was trying to get just anything to work. And the internet was a little choppy at first, but in the course of setting things up, I did not have the 10 minutes it takes for Odyssey's fucking stream to get set up. So I couldn't do it. And I actually have a contract with Rumble. So that one's going to take priority, unfortunately, for Odyssey. But typically there will be Odyssey streams on Trials along with YouTube and Rumble. Unfortunately, the last 2 days being really short on time on both of those, I just didn't have time to set them up. So if you like watching on Odyssey, my apologies. However, on the exclusive videos that I will do with Rumble and YouTube, where after an hour on YouTube, it switches to Rumble, I will not be streaming those on Odyssey. So I hope that is the explanation that helps you out. I know that some people don't like that and won't like that. And I actually really like Odyssey. I like their team. I like their product. I think it's a really, really good platform. But, business is business on that one. So next, let's hit these super chats. Then, oh, God, maybe I can get out. I have to see. The weather fucking sucks. I have to see if I can get over and get a haircut. All right. Where are we? Okay, Adam A says, I'd rather let 10 guilty escape than 1 innocent suffer. Looks in window, bang. Hey, y'all, there's no objection by defense to bad cop BS still. No, the defense did not object very much on this one. I think they should have objected in lots of places. But they really did okay at the end. But that was the best lawyering we saw by the defense, was taking down that expert witness of the state. That was the best lawyering that they've done that I've seen in the case. They were not particularly impressive with their trial prep for their defendant. and they didn't seem to do too well on direct examination of him. But their cross-examination of this guy was really good. So that was nice. Pro AF Farrier. Oh, they did have the good expert witness too today. He was pretty good to start. Pro AF Farrier says, I bet this prosecutor is real fun at parties. He actually probably is. He seems like a loud, boisterous Texan, probably a good dude. His conduct in this case I've not been very happy with, but he's got a bad case, so he's going with what he's got. I think if you've got a bad case, you should dismiss it as a prosecutor. Amateur Anth, Nick, you need to make your own GTA role-playing server, then we can all come on and follow the rules. Wink, wink. Vince Clortho, this is a weird trial. I would agree, brother. Kingslayer Damocles, I bet this guy thinks the Walter Scott shooting was justified. He's a police officer. He is a police officer certified, which means his lips are moving, so he's lying. Damn. Robbie, 1485 says, objection, relevance, objection, legal conclusion, objection. This guy is an idiot. Objection. That was about that expert. Talking trash and truths. Plussy, po plussy, fanana, fana, fo flussy, me, my, mo, mussy, plussy, hit that plussy. That's to the Rumble audience. Dragon's Treasure says, USPS sent all of my orders from last Friday to Puerto Rico. If anyone places an order from then, please contact me. There's incompetency. Then they're sending 11 orders to a different country. Imagine one USPS employee going, you know what? Fuck it. I'm going to the islands. Getting on a plane with his tea. It's going to taste good. Flux says, what is actually happening? What is going on? The two of them should have been guarding all 7 exits and entrances. This is dumb. Yes. Flux also says, YouTube won't let me call the prosecutor stupid. Isn't that weird? Nancy Jennings, Dean Wormer would give this prosecutor a 0.0. Lol. Yukishiro Rai says, can I get a drink for my cousin's funeral last week? Died at 28 due to cervical osteosarcoma, relapse complications. 3rd family member funeral I've had in the past 5 months. Thanks. Fuck that. That is not, that's not fun, man. Sorry to hear that. Yukishiro, to your cousin and your other lost family members, losing family is very much losing a part of you, even if they're a little bit distant. They're people that are connected to you by blood, by marriage, by contract, sometimes by force. And we may not always get along with them, but they are constants in our lives that make us who we are and carry parts of ourselves with them. So cheers to you and your losses. May their losses become your gain as you reflect on your life. Forget any drama and bad stuff you had with them, letting that go, and enrich your life with your positive experiences and the hope of peace and consolation for them and their families. Floppy Turtle, and that's how it goes, isn't it? Floppy Turtle says, I love how this witness had control of that cross. It was very entertaining. Yeah, that was the first expert witness for the defense. He was great. Miles Coots, yes, I have a glass smoker. I do. Thank you. Wick Dipper. The juxtaposition of my hatred of the state killing innocent citizens and my hatred of the state overzealously prosecuting citizens cause an interesting state of cognitive dissonance. It's really tough. I mean, because we've been through this before. I hate when the state kills a citizen. I hate when it's justified and they do it. I don't ever want, like, I'm a libertarian, man. I don't like watching anybody get fucking offed by the boots. And, but then at the same time, I really, really hate overzealous prosecution. I hate the politics of prosecution. And I feel like this one the case hasn't been political. I feel like the prosecution of the case is political. Pinochet's helicopter tour says, why not play to the emotions of the jury? Why can't he look at the jury and say, yep, he shot her, but fuck you, jury, exigent circumstances, nothing you can do. He can. He can do that. He also says, Andrew, where do you stand on LEO and civilian use of night vision and thermal? Your stance on etching extend to revolvers. Wyatt Earp would be sad. His stance on etching or anything that you do to a gun is that anything you do to a gun will be used against you. It's not that like there's anything inherently bad about it. It's just that doing anything will be brought up by the prosecution, and you don't want that thing that you do to be the one tipping factor that means that you go to prison forever or even get executed just because you wanted your gun to look a little cooler, right? Like if you etch Widowmaker onto your gun, then you have to defend yourself against a guy who's married and you kill him. The jury's like, holy shit, did he, like, is he trying to kill married men? Like, is that what he's trying to do? Like, who, you know, you just don't want bullshit to be the reason you go to prison. So that's kind of the stance there. As far as night vision and thermal, civilian use of night vision and thermal should be unlimited. I should be able to use whatever the fuck I want. Like if I can get it, it should be mine. And there's nothing about that should bother anybody. As for law enforcement, use of night vision and thermal, I guess it depends on the use case. I don't have a problem with it unless it's being used to violate the Fourth Amendment in some way, which in theory, I guess could be possible. I'm not sure. I guess in this case, if there was like a convenient night vision setup that the police officer could have used, he could have used that instead of a flashlight, right? But the flashlight has other uses, tactical uses for police officers to do, a less than lethal option to stun someone when it's dark. Flashing those high lumen lights in someone's eyes can give you that second you need to do something else. Whereas a military use of night vision, not necessarily concerned with preserving life at the same level. At least in theory. I don't know. I don't know what Andrew would say. Legendary Racing, my neighbor's bone dry drainage ditch was viewed as a navigable stream. He had to pay $5,000 for the DNR to come say, that's not navigable. Yep. I hate it. Roby McCann says, legal vices, you're savage, heart, honest but savage. Dr. Diddler, did you stream the other 4 parts? No. If so, what platform was it on? Only yesterday. I did stream yesterday on Rumble and YouTube, but the previous 3 parts to that, I did not stream. I was not around. That was while I was in Miami, I believe, or busy otherwise. I can't remember specifically, but I know I wasn't watching the stream, but Andrew Branca did on his channel, Law of Self-Defense, which is linked in the description. Finally, how do you do that thing where you make your nose get gradually bigger? That's my secret, brother. It's a trade secret. Brian Schulz, is Charlize Theron going to play her in the movie? Gummy says, don't lose the Pope hat. Oh, I won't. It's right there. It's right on my floor. We'll have it tonight. Ashley Williams, Branca, do you work for police organizations? He does training, or he has done training for some places. Like he's mentioned, he's done training at FBI headquarters and stuff like that. But I don't think he works for police organizations. He said earlier today that he's only ever hired as a consultant by defendants. The state never wanted to pay him. Would you cover cops if they were a platinum member? Note, paying rackets because Branca no stream. I think that's the only way to get his services now is to be a platinum member. The Chief's Way says Fred Flintstone is a real piece of work. GTG957W, catching up on the stream. Maybe this had been said before. John Boyd said in his book that people will misapply the OODA loop concept in the exact way the defense expert did. The prosecutor should have been prepared for that. And they weren't. Jonathan M. Thomas, for a bunch of defense lawyers who are also conservative and pro-limited government, you guys are coming across as way too pro-cop and back to blue. Okay. Again, First of all, I'm not conservative. I'm libertarian. I've never claimed to be conservative except to be being conservative in my own practice. But I'm a libertarian in the sense that I don't impose my viewpoints on anybody else. I'm also probably bad at being conservative in a lot of ways. But that being said, I am pro-limited government. The fact that this guy's a cop and he shot a civilian deeply, deeply bothers and concerns me. However, if he did it lawfully, while the policy is bad that led to a lawful shooting, it's still the law. And this guy should not have to suffer for bad law. Change the law. Happy to discuss that. Reduce the role of police. Happy to discuss that. Reduce the number of police. By the way, conservatives have been largely pro-police to an alarming level over the past several years, in my opinion. But that being said, I'm all for reducing the police forces. All for it. Reducing their interactions and making them focus on actual violent crime as opposed to pretty much a bunch of other shit they focus on now. I'm for elimination of like drug laws. I'm for elimination of bullshit traffic stuff. I'm for elimination of all the petty fucking garbage they do. I'm for the reduction of their like SWAT response trigger fingers. I'm for massive reductions in policing. But until we have it, we analyze things under how the law is. And this guy is not the sacrificial lamb, so to speak, for the fucking problems of the Fort Worth Police Department. That's not fair to that guy at all. That's not justice. So that's, that's my personal opinion on that. Yeah. And again, for people who say I'm like overtly pro-cop, I have very not pro-cop opinions about Derek Chauvin that people get really pissed off when I talk about them. You can go watch my Derek Chauvin coverage and discussions I've had about that. The other cases I've covered that involve cops are Kim Potter, which again, the law didn't support her conviction, frankly. Curtis Reeves was a former cop, not acting as a cop when he shot someone in a movie theater, and his actions were clearly justified by the facts. Again, nothing to do with him being a cop other than they, brought it up as his history. And then this one. So, but no, I'm not a fan of cops shooting people, especially. Rain 432, he was specifically instructed not to write anything that would be subject to disclosure. I would imagine so, actually. Dustin C says, my issue is that Bronca backs basically every LEO shoot that comes up. From what I've seen, yeah, that seems to be the case. And cops win on a lot of them. I don't know if I agree with all of them. Brandon Jones, Rittenhouse's prosecutors are geniuses compared to this guy. He was doing okay yesterday, and then he just completely phoned it in. Zadig Attack, curriculum vitae, Latin for course of life, often shortened to CV, is a short written summary of a person's career, qualifications, and education. Correct. Oh, were people asking? Sorry. Let's see. Lancelot 652, you have to move fast, but check every door, every window, and somehow get to the house without getting across the wide open road. Yep. Sherry D, yes, there will be a show tonight, Sherry. Crusader Joe, people misunderstanding AB. He's not a bootlicker. He's a gun licker. He'll always defend the use of the gun. Pretty sure the guy snorts Winchester 231. Lancelot 652. So are they supposed to just have a billion cops on every search? They have to check every angle, watch every door, and look out for the sniper nests like Iraq. Remember the rule of prosecution is this. If I can use anything against you, I will use everything else against you too. The prosecution will throw everything at you. They will come up with all sorts of crazy stuff that is completely impractical. They'll make it sound like it was the only reasonable thing to do that you should have done. You didn't do it. So now someone died and it's your fault entirely. let's see. Pin King 554. The prosecution is wanting the defendant to do two different things at once. Yes. They don't want him to do anything at all. They want him to just die or like lose. They want him to go to prison. So they throw out all of like the reasonable conventions. This is what the state of prosecution in the United States has become for a lot of people. And that's really, really unfortunate. But what is reasonable is gone. And now the only thing that's focused on is how do we put you in prison? Dustin C says, we're mad because cops get to hide behind a bad shoot with "it was policy." If I had taken that shot while deployed, I'd be in prison. They shoot first when nobody else does. I'm tempted to agree with you, but let me just say that both Branca and I have suggested that the error that the deceased person made here was not shooting the cop. I would have shot the cop. Andrew said he would have shot the cop. That's what she should have done. She should have shot the cop. Looked like a prowler outside their house, 2:30 in the morning, shoot the cop. I would defend her in that case. I would say very specifically that, man, shooting a cop is going to be tough sell. Like, it's going to be hard. Not because it should be, but because I've talked about, and maybe need to do a specific video on this. The blue bias is very, very real in a courtroom. It's very real. I hate it. Any defense attorney hates the blue bias because a cop comes in, they'll wear their uniform. Oh, well, because I was working up until I got, he's like, bitch, you normally are in plain clothes or sweats. They come in uniform, they sit down and they speak authoritatively and they fucking lie. They just lie right on the stand. They just lie. And what do you get to do? That's a lie. Unless you can prove that it's a lie based on them admitting it's a lie or like having said something opposite earlier. Unless you can prove that, you just have to fucking take it. And you know they're lying. You know it. You know it. I've talked about this before, but I had a case where there was a house fire, total loss or whatever, and the cop kicked open a bag that was on fire, a garbage bag that was on fire, and he found a bunch of weed in it. This is in a burn trash pit. He did not have consent to search. In fact, he asked for consent to search, specifically did not get consent to search. He didn't get a warrant. He could have easily gotten a warrant to search if he wanted to, but he didn't. And I'll tell you why. At the time of the search, he did not have probable cause. So he didn't think to get a warrant, but he asked my client if he could look, if they, what to do about these bags that were on fire. And the guy said, that's burn trash. Just let it go. Instead, he had the fire department come over, extinguish the fire, and he kicked it with his foot. He moved the bag with his foot and it just opened. That's what he said. That's what the cop said. He wasn't actually searching. He just moved it with his foot and the bag just ripped open and spilled marijuana everywhere just by chance. Then, even though there was no articulation of this in advance, he says later that he smelled a strong odor of marijuana wafting out of the fire, of the garbage fire with burning plastic, melting aluminum, and the weed was still green, so it wasn't burning. Also, while the entire earth around you is on fire, leaves are on fire, trees are on fire. I think a car was on fire. 2 structures are on fire, but he could smell weed. Out of all those smells, he smells burning weed coming out of this garbage. Yeah, I don't believe him for a fucking second. I don't buy it. He didn't articulate to any officers, firefighters, or anyone why he thought that he smelled weed in this thing at all. Oh, and also that weed had been used already to extract resin from it, or to extract, resin. I can't remember what it's called. I think make dabs or whatever, that honey shit that they make. So it's not even like THC in the weed anymore. Wax, that's what it is. Yeah. Yeah. And then after all that, the judge created the plain smell doctrine in Minnesota, which didn't exist. By the way, Minnesota and our circuit court, at the time at least, I think still, do not recognize plain smell as a doctrine. They used another case from another place, the Fourth Circuit, in which the Fourth Circuit case that they used involved a barge with 527 bales of marijuana. And the best part of that is they didn't even rely on the smell in that case, even though the judge cited it for plain smell. But the tarp that was covering the bales of marijuana was actually ripped, and so they could see it through there. It was still plain sight. It was still plain sight. The other two cases the judge used were dog sniff cases, not human smell. You want fuckery? If the court wants you, they got you. They'll just get you. Why was everything on fire? It was a total house fire. Whole thing up in smoke. So, yeah, that would have been a good case for appeal, except my client killed himself. He wasn't going to jail or anything. We had a really good deal for him, but he killed himself on Valentine's Day. So that was nice. Was he making wax because that can cause fires? No. His brother made the wax. Brought it over to throw away. He was making a burrito and he dropped the burrito in the fryer. Burrito had like one of those packaged burritos had some like water on it, and it caused the fry oil to bubble over, and house went up in a grease fire. So, and that's how you go from being happy about making a midnight burrito to killing yourself in 3 easy steps. Anyway, that was not a fun case. Here we go. Tortheo. Rumble still forcing me to give phone number to post. Yeah, I've got to talk to them about that. I don't know what's going on with that. Maybe they have a good explanation. Kind of annoying. Michael W says, sounds like one hell of a dark case. It was very dark. I was not prepared for a self-deleting client and having to talk to that client's parents, who were also my clients in the insurance claim on the house. But I did get them really good results in the insurance claim. So that was nice. But yeah, yeah. Yeah, I wasn't a fan of that one. Evil Ash, 3373. Andrew Clifford Dedesky is definitely a real lawyer. Stephen Cooper says, emailed follow-up update to the update I didn't completely update you with yesterday. Cool. I'll check it out. Thank you. John Lee Pettimore III says, let it snow, let it snow, let it snow. And Chininator says, Rackets, can I get a toast/prayers for an older lady in our church? She was our Sunday school teacher growing up. She's been diagnosed with bone cancer. To the old lady Sunday school teacher at Chininator's church, may she be provided with a team of doctors with, again, wisdom beyond their experience and skill beyond their training. May they have answers and technique to bring her to a place of health and peace. Cheers. All right. I've got a couple more chats over on locals, and then we're done for the day. Iceman 1014, this guy's going to get hosed. He only had a day and a half of defense. Andrew, was it expected defense would rest? I missed about the last hour and a half of defense testimony. Well, there were only 3 days of prosecution, or what, two and a half days of prosecution, and there was just not much in this case. But you know what? Like, let me point out, This case is moving at the pace of a normal murder trial. They're really not that, like, they're usually 4 days to a week is what you got. You usually don't have many witnesses. You usually, you have most shootings or murders happen between two people. There may be a couple people who see it, but you usually only have a handful of eyewitnesses. Then you have your experts, your ballistics person, your forensic person, whatever, maybe a police tactics person in this case. And that's about it. You don't have so many people that take up so much time in most cases. So that's why this one is going pretty quick. So this is kind of normal. I would love it if we had more normal length cases. They're easier to cover. B. Miller says snow's getting bad in Fargo, North Dakota, so it's getting close to you. We had a bunch of ice this morning, so we'll see how that goes. Hyper Shouta says, God, I have to talk to locals about how they do this. Clearly, officer training should be live fire. And Jensen Zeiger says, the Mesa, Arizona one bothers me. Visibly can't walk drunk. Told to put hands on head, cross ankles, and crawl. Also told if he tries to catch himself, they will shoot. So extra stress. Yep. He was supposed to. All they had to do in that one, that's Daniel Shaver. All they had to do for Daniel Shaver, they had, 6 responding officers, was tell him to put his face down on the ground, hands behind his head, cross his legs on the ground like this, laying face down, have an officer of the 6 go and secure him, handcuff him, and remove him from the scene. That's all they had to do. They did not need him to prostrate himself, to get down on his knees and waddle forward on his knees to the officers or anything like that. All he had to do was lay down. They had plenty of police there to provide cover, to clear the area behind him in case anybody else tried to walk out or anything like that, and they didn't do it. Wait a minute, what? Okay. That is all of the chats. Thank you so much to Rumble, the Rumble audience, the YouTube audience. Very much appreciated. Tonight's show will start on YouTube and Rumble, but it will transfer to just Rumble after an hour. You can save yourself a little bit of hassle if you want to just go straight to the Rumble link. If you want those links, follow me on recadalaw.locals.com. Best chat on the internet. Also makes every show possible with their support. Thank you for them. Thanks to all of y'all. And if you're still a member on YouTube, I'm going to be cutting the YouTube memberships off very soon and encouraging anybody who's a member to go ahead and cancel your membership on YouTube and please move over to Rumble. Join on Rumble. Join in the conversation that's going on there. It's a lot more fun. There's no censorship. The only thing you can't post is penises, balls, anuses, vaginas, and nipples of women. That's it. You can say all the crazy shit you want. You can have fun talking to people. It's a good time. And look, if you want to do that, it's $5 a month. You get other stuff too, but it's $5 a month, $50 for the year if you want to save a little on the months and lock yourself in for a year of content. I don't grift it enough, but I really should because it's fantastic. So we'll catch you guys later. Hope you have a good rest of your day, and I hope to see you tonight. Peace. Peace. I meant locals, not Rumble. Oh, damn it. Locals, recadalaw.locals.com. Come to join locals. Oh my God, what terrible at everything.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side, if his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Valmore, a Lafroig, the spirits blow as the ones who get unemployed. So pour out a glass for the tea post on Twitter, as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plenty folks from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter, as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law